Gwen, this is Gary Landry. I just wanted to let you know that it's 9 o'clock and you can start the meeting since we have a quorum of board members.
Okay, that's fine. Good morning.
Morning.
Good morning. Welcome to the Nevada State Board of Cosmetology Board meeting. Today is January 11th, 2021. Can I have a roll call, please? Board members?
Brian Baltazar, present.
Victoria Negretti, present.
Board Member Douglas, present.
Roxanne Harris, present.
Kai Stanton, board member present.
Tia Latrell McCormick, present.
Okay, that's all board members. We did hear from you, right, Brian?
What the hell?
Yes, the yes, first one.
Oh, okay. All the board members, good. Can we have a roll call from staff, please?
Gary Landry, Executive Director, present.
Andrew Helm, Chief Financial Officer.
Leah Easter, Chief Compliance Officer.
Lisa Nguyen, Compliance Specialist.
Justin Taruk, Deputy Attorney General. And we also have Michael Detmer, Deputy Attorney General, who will be acting as board counsel for agenda item E1 through 4.
E1 through 4?
Yeah, Mike, you're on the line, correct?
That is correct. And good morning to the board. My name is Mike Detmer, serving as board counsel for the item specified by Mr. Taruk.
Thank you.
Maggie Adams.
Adam Higginbotham, Deputy Executive Director.
Okay, we did get you right, Maggie.
I am here, yes.
Okay. Do I have any staff from up north?
David Scarpelli, Inspector.
Michelle Fanning, Inspector.
Pamela Fitzgerald, Inspector.
Rodney Moore, Inspector.
Okay, I think that is that everyone. All right, thank you. The mission of the Nevada State Board of Cosmetology is to protect the public health, safety, and welfare of those that obtain cosmetology-related services through quality of education, through quality testing, licensing, inspection, and education services that focus on consumer protection. Do we have any comments from the general public? Comments are to be limited to 3 minutes or less. You can comment on any item that's on the agenda or not on the agenda, but will not be voted on, will only be heard today. So do we have any public member that would like to make a comment? No comments? The floor is open for comments if you have any comments. This is the time to make a comment. Okay, so it looks like we have a pretty full agenda. I would just like for you to keep your microphones on mute until it's actually, you're the person that's up for the next agenda item, then you can unmute your microphone unless it's staff or board members, please. Can I get agenda item number D? Can I get approval of minutes from our previous meeting, November 9th minutes, December 7th, regular minutes, December 7th, special minutes. Can I get a motion for approval, please?
This
Brian
board
Baltazar.
member.
Oh, go ahead.
Go ahead.
Not at once.
Brian Baltazar, I motion to approve the minutes of the November and December meetings in 2020.
This
Okay,
is
that's-
Kai.
Oh, go ahead.
This is Kai Stanton. I second that motion.
all in favor?
Aye.
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 Any opposed? Motion carries. Agenda item number E, Smoking Hot Hair Salon. Salon license 13045, Nevada State Board of Cosmetology, complaint number 2020-0969, for discussion and possible action.
Good morning, board members. This is Justin Taruk, Deputy Attorney General. For agenda item E1, this matter was actually a matter that proceeded before the administrative law judge, Jill Greiner, on October 22, 2020. And this case number was C-2020-0969, the matter of Nevada State Board Cosmetology versus Smoking Hot Hair Salon. Is anybody from Smoking Hot Hair Salon on the call today? No. If I could, Mr. Landry, could you just swear in Leah real quick?
Do you swear that what you're going to tell today is the truth and nothing but the truth?
I do.
All right, Miss Easter, can you state your name for the record?
Leah Easter,
And what's your job title?
Chief Compliance Officer.
All right. Did you send out notification of today's meeting to Smoking Hot?
I did.
And when was that?
It was regular and certified mail on November 23rd, 2020.
Okay, thank you. If it pleases the board, in your board packets, there is a findings of fact, conclusions of law, and recommendations that were drafted and presented to Ms. Greiner, who is your ALJ on this matter. If it pleases the court, I can read the findings, conclusions, and recommendations to the board.
I think our board I've read the information and I have questions. So if you want to go ahead, Justin, that'll be fine. If you want to just kind of refresh everybody's memory.
Okay, so starting on page 1 is the findings of fact. So on or about February 28, 2012, Smoking Hot received a cosmetology established license from the board to operate a salon and was issued license number S-13045. At all times relevant, respondent Smoking Hot engaged in the business of cosmetology and is therefore subject to the jurisdiction of the board and the provisions of NRS Chapter 644A and NAC Chapter 644A. On March 12, 2020, Nevada State Governor Steve Sisolak issued a declaration of emergency to facilitate the state's response to the COVID-19 pandemic. On March 2020, Governor Sisolak issued declaration of emergency for COVID-19 Directive 3 that required the closure of non-essential businesses, including aesthetic services such as beauty shops, barber shops, nail salons, tanning salons, and wax salons. On May 7, 2020, Governor Sisolak issued Declaration of Emergency Directive 018 that allowed nail care salons and hair salons licensed by the board to reopen to customers, provided that 1, salons and barber shops with walls or partitions between stations or chairs may utilize all stations, but under no circumstances may more than 1 customer or client be seated at any given station or chair. 2, salons and barber shops without walls or partitions between stations may only seat customers or clients at every other station or chair, or arrange stations or chairs so that a minimum of 6 feet of separation between customers is maintained. 3, salons and barber shops may not accept customers or clients on a walk-in basis, and technicians, stylists, and barbers are not to serve, may not serve or accept appointments for more than 1 customer at any given time. 4, customers waiting for appointments must wait outside the facility and must practice social distancing by maintaining a minimum of 6 feet of separation between customers not residing in the same household. 5, technicians, stylists, barbers, and other employees must wear face coverings at all times. 6, persons licensed by the Nevada Board of Cosmetology or State Barbers Health and Sanitation Board must abide by all guidelines promulgated by their respective boards. Boards are directed to impose disciplinary measures against licensees who violate this provision. On or about May 7th, 2020, industry-specific guidelines was released by the Nevada Healthcare Response Center in coordination with the Local Empowerment Advisory Panel, or LEAP, which included guidance on the reopening of care salons. Within the infection prevention item checklist of guidance, it specifically noted that face masks were mandatory. Further, the guidance required that nail care salons must follow the strict guidelines set forth under Section 16 of the Emergency Directive 018. On May 18th, 2020, the board received a complaint that respondent Smoking Hot was not complying with the governor's directive, including that respondent staff were not wearing facial coverings, that respondent staff were servicing more than one client at the same time, and that workstations were not 6 feet apart. On May 19th, 2020, the board performed an inspection of respondent Smoking Hot cosmetology establishment and found that respondent staff were not wearing facial coverings. On May 21st, 2020, the board received a complaint that respondent Smoking Hot was not complying with the governor's directive, including that respondent staff were not wearing facial coverings and that respondent staff were double booking appointments. On July 16, 2020, the board performed an inspection of respondent Smoking Hot cosmetology's establishment and again found that the respondent staff were not wearing facial coverings. Conclusions of law. Pursuant to NRS 644A, the board is vested with sole discretion to discipline cosmetology establishments and licensees of cosmetology. Section 2 of Declaration of Emergency for COVID-19 Directive 003 provides that non-essential businesses that promote extended periods of public interaction where the risk of transmission is high, including fitness establishments such as gyms and studios, aesthetic services such as beauty shops, barbershops, nail salons, tanning salons, and wax salons, and any other such non-essential businesses shall close effective March 20, 2020 at 11:59 p.m. for the duration of the directive shall be in effect. Section 9 of Declaration Emergency Directive 003 provides that businesses that do not comply with this directive or regulations promulgated under the directive after receiving notice from law enforcement may be subject to criminal and civil penalties under NRS 202-595, 202-450, and any other applicable statute, ordinance, or regulation. All law enforcement agencies in the state of Nevada are authorized to enforce this directive and regulations promulgated under this directive. The Office of the Attorney General is given concurrent jurisdiction to prosecute violations of this directive and any regulations promulgated thereunder. Section 16 of Nevada Governor's Declaration of Emergency Directive 18 provides that licensees must abide by all guidelines promulgated by their respective boards and further direct the boards to impose disciplinary measures against licensees who violate the directive. Subsection 6 of Governor Sisolak's Declaration of Emergency 18 specifically provides that nail care salons and hair care salons licensed by the board may reopen to customers amid the pandemic, provided that a number of safety precautions were followed, including that technicians, stylists, barbers, and other employees wear face coverings at all times. NRS 644A850 subsection 1 provides the grounds for disciplinary actions by the board, including any other unfair or unjust practice, method, or dealing which in the judgment of the board may justify such action. NRS 644A852 provides that if the board determines a violation of NRS 644A.850 has occurred, it may refuse to issue or renew a license, revoke or suspend a license or certificate, place the licensee on a probation for a specified period, impose a fine not to exceed $2,000, or take a combination of any of those actions. So I'm going to skip to section 18. The board alleged as a first claim of relief that respondent was subject to discipline pursuant to NRS 644A.850 subsection 1 subsection N for engaging in any unfair or unjust practice, method, or dealing by failing to comply with section 16 of Governor Sisolak's Declaration of Emergency Directive 18 when respondent staff failed to wear facial coverings on May 19th, 2020. As you'll see, it says that Ms. Greiner, the administrative law judge, found at the hearing that respondent violated NRS 644A.850 subsection 1 subsection N for engaging in unjust practices by failing to comply with section 16 of the Directive 18 when respondent staff failed to wear facial coverings on May 19th, 2020. The board also alleged as a second claim of relief that the respondent should be subject to discipline pursuant to NRS 644A.850 subsection 1 subsection N for engaging in any unfair or unjust practices, methods, or dealings by failing to comply with section 16 of Governor Sisolak's Emergency Directive 18 when the respondent staff failed to wear facial coverings on July 16th, 2020. As with the May 19th one, the ALJ found that the respondent violated NRS 644A.851N. And so after the hearing, or upon the conclusion of the hearing, the ALJ signed off on those proposed findings and recommendations. And so we've submitted those findings and recommendations to the board.
Thank you, Justin. Do we have any board members have any questions for Justin or Leah? Or any of the compliance officers?
President Gwen, this isn't the time to rehash the findings. The findings and recommendations are presented as is. If the board and Mr. Detmer can counsel the board as far as what their options are, if it finds that they don't agree with the findings or conclusions.
Okay. Can we hear from you, from council, please?
Good morning, Mike Detmer for the record. Mr. Taruk is correct. The findings are as they stand. The board is confined to the record. If the board did have questions for cosmetology board staff that were more procedural in nature, that would be fine. That would be appropriate. But as far as a determination of additional findings, this would not be the appropriate time or venue for that. That would have happened during the actual adjudication.
Okay. Thank you, council. I think my question, and I don't know if it's a question or a concern, at what point do this information gets to the board before we have to not ask questions or concerns? Because I did have a concern about the 3 consecutive findings of this for the same actual regular violation. And then I had a concern about the excessive alcohol that was on site. So I'm not quite sure at what point do the board members get an opportunity to question that, because I mean, the fine is the fine, but what happens when a person consistently keep breaking the violations 1 month and 2 months after another?
And Madam President, first, Mike Detmer for the record. I believe that would be a issue separate and apart from what's before the board today. What came before the ALJ, the administrative law judge, was what was alleged in the complaint. The administrative law judge ruled on what was in the complaint. And those are the findings the board was looking at exclusively. If those were in the complaint and the administrative law judge did not address them, then under NRS 622A.300, the board does have different remedial measures or different actions it could take. I shouldn't characterize it as a remedial measure. It could accept the findings and conclusions. It can accept them with changes, that is to say modifications. It can reject and remand. It can reject an order de novo hearing or take other appropriate measure. So those are the mechanisms, the vehicles to which the board can act today.
Okay, was it kind of unfortunate that the person is not, the Smoking Hot Salon is not here today? I'm just one board member. Do any other board member, I mean, if we want to accept the findings, we can accept the findings, but
And Madam Chair, this is Justin Taruk for the record. I believe that the complaint was attached as part of the board materials. You'll notice in the complaint that the complaint was solely focused only on the COVID-19 allegations, and it wasn't dealing with the alcohol. So I believe that there was a citation, or it was addressed previously and separate from the complaint itself.
That's correct. This is Leah Easter, Chief Compliance Officer for the record. So to your point, Gwen, and speaking kind of procedurally from here, if Smoking Hot were to continue to be in non-compliance, they would be back before you to determine if they were going to go before the ALJ or you were going to hear it again. For the alcohol, because there's no prohibition in our laws, it was just brought to the attention of business licensing. So it was sent to the agency that would oversee something like that. To Justin's point, the only thing that the ALJ heard were those issues of not wearing masks and social distancing. And so that's where this penalty is coming from. Everything else, they're going to continue to be inspected for regularly, just like the rest of our salons. So we'll be back in there 3-4 times a year.
Okay. Thank you, Leah.
Sure.
Brian Baltazar, and I don't know if I'm allowed to ask this because it is a separate question, but Leah, under whose jurisdiction would it fall, the distribution of alcohol? Is that the county, or I'm not quite sure?
Yeah, in this case, I believe they fell under the jurisdiction of Clark County, so it was brought to Clark County's attention. It's my understanding that a license to sell or distribute liquor is necessary, but again, because we don't regulate that, the best we could do is just bring it to the attention of the entity that did regulate it. And the only reason it was concluded in a finding was just that it was slightly out of the ordinary, but it's not in violation of cosmetology law. So it was flagged, but they weren't in any way cited or brought before the ALJ for that reason.
Okay, thank you for clarifying.
Sure.
Okay, so can I ask again, because I was looking there and I saw more fines. What are we ruling on, Justin? I need some more clarification now because I'm lost.
Sure. So the ALJ Griner recommended that the board issue a fine. You'll see on page 5 of 7. It is hereby recommended that the Nevada State Board of Cosmetology order respondent to pay an administrative fine of $500 for violation NRS 644A.851N as stated in the first claim of relief, and an administrative fine of $500 for violation of NRS 644A.851N as stated in the second claim of relief. So it's a total of $1,000 that she found should be recommended as a disciplinary action against the Smoking Hot. The ALJ also recommended that the board order respondent to reimburse the board for its attorney's fees and costs expended in this matter. And the board will provide the respondent with an itemized statement of those fees and costs within 15 days of the board's order on this matter. And if there's a payment plan needed for that the respondent could reach out to the board staff to try to set up a payment plan. So to sum it up, it's $1,000 total for the 2 fines that she or 2 allegations and claims for relief. So it's $1,000 fine plus fees and costs in this matter.
Can I make a recommendation that if this particular salon is cited again, that they come directly to the board?
You can have that happen.
I need to have that. We need to have that in the motion. If we could, please.
Sure.
Mike Dever for the record, to supplement Mr. Taruk's correct summary of the adoption process for the board. Unless I'm mistaken, I believe the adoption would actually also go to the findings that were enumerated within the document itself, because that's part of the order. The board's finding this, 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 and this, and then this is the penalty to which the board is adopting if it doesn't change it. And
Okay.
if Mr. Taruk said that, I apologize if I'm just being redundant.
That's correct. That's correct, Mr. Detmer is correct. So the board would have to vote to approve that the findings that Ms. Griner found are true and correct, that the conclusions of law were also found to be proven, and the recommendations for the penalties, as well as any other recommended changes to that, including that in the future, if there's any additional COVID-related allegations, that they be brought before the board directly and not before the ALJ.
Okay. Okay, I think we can move forward. Can I get a motion, please?
This is Kai Stanton. I'd like to make a motion for Smoking Hot Hair Salon, case S-13045. To uphold the findings with the adoption that has been presented before the board today, presented by the president regarding the adoption. And I know I need to adjust that a little bit. So what was the adoption? I know there was an adoption somewhere.
Yeah. You're a good stab at it, Kai. We appreciate it.
Okay. Just want to take stab at that, sorry.
Member Captain, this is Justin for the record. I believe you said the licensee's license number, but the case number is C 2020-0969.
Okay.
And Mike.
Just
Detmer
wanted
for
to
the record-
clarify that.
Thank you.
Mike Detmer for the record, Member Stanton, I think it was a well-worded motion. I just want to, for clarification purposes, ensure that the motion included adoption of the findings of fact and conclusions of law, as well as the recommended penalties as stated within the document.
Perfect.
This is Board Member Douglas. I second that motion.
Yes.
I thought we had to restate. No, we're good?
I believe Member Stanton just responded in the affirmative as far as the clarification. So if the minutes can reflect that her yes in the affirmative was incorporating by reference my statements as the clarification.
Yes, sir.
I think I'm being too wordy right now. For that, I apologize.
No, I appreciate the clarity. It's phenomenal. I appreciate it. Absolutely. Yes, sir. Mhm.
I just want to jump on any opportunity to talk to other adults. So thank you.
So we'll take it. Edric, we'll take it. Thank you.
Member Stanton, sorry, and Mr. Detmer, just for clarification of the record as well, I know that Ms. Stanton modified her motion for the findings of fact, conclusions, line recommendations, but Chair Bramo also recommended one other modification, which was to have this submitted to the board and not the ALJ if there's any additional penalties. Did your motion also want to include that as well?
Yes, sir.
Okay, thank you.
Yes.
And then Ms. Douglas, I believe you were the second.
Yes, sir.
All right, did you want to agree to the modifications? I know that you already seconded it, but I just wanted to confirm for the record.
Yes, I did, sir. Thank you.
All in favor?
Aye.
Any opposed? Motion carries. Thank you. Agenda item number 2 is Jennifer Frazier, license number C33676, Reflection Styling Salon. Is she here today? Do we have a Jennifer Frazier here today?
Or anyone from Reflection Salon? No. Okay, Madam Chair, if it's okay if I could take the floor on this?
You sure can. Are we gonna have to read that whole thing all over again?
Yeah, unfortunately, because it's a different case.
That's how I feel too, Glenn.
I'll try to read faster this time, but at least it's on the record.
Okay.
All right, so before the board is the Nevada State Board of Cosmetology versus Jennifer Jean Frazier, license number C-33676, and Reflection Styling Salon, license number S14465, case number C2020-0970. And I believe Ms. Easter was previously sworn under oath, but Ms. Easter, could you just state your name again for the record, please?
Leah Easter,
And what is your job title?
Chief Compliance Officer.
And that's with the Board of Cosmetology. Okay. Did you send out a notification of today's meeting?
I did. It was sent regular and certified mail to both Jennifer Frazier individually and Reflection Styling Salon on November 23rd, 2020.
And that was sent to the address that was most recent?
Most recent address on file.
Okay, thank you. Board members, as part of your board pack, meeting materials, there is a findings of facts, conclusions of law and recommendations. As with the previous case on October 22, 2020, the board proceeded with a disciplinary hearing before Administrative Law Judge Drill Griner on this matter. And I'll just read the findings of facts and conclusions of law and recommendations for you guys, so that way it's also in the record as well. So on or about July 12, 2011, Respondent Frazier received a cosmetology license from the board and was issued license number C33676. At all relevant times, Respondent Frazier engaged in the business of cosmetology and is subject to the jurisdiction of the board and the provisions of NRS and NAC 644A. On or about February 26, 2015, Respondent Reflections received a cosmetology establishment from the board to operate a salon and was issued license number S1465. at all times relevant. Respondent reflections engaged in the business of cosmetology and is therefore subject to the jurisdiction of the board and the provisions of NRS and NAC 644A. Ms. Frazier was at all relevant times the owner of Respondent Reflections. On March 12, 2020, Nevada State Governor Steve Sisolak issued a declaration of emergency to facilitate the state's response to the COVID-19 pandemic. On March 20, 2020, Governor Sisolak issued Declaration of Emergency Directive 003 that required the closure of non-essential businesses, including aesthetic services such as beauty shops, barber shops, nail salons, tanning salons, and wax salons. On April 28, 2020, the board received a consumer complaint that respondent's establishment never closed pursuant to the Declaration of Emergency Directive 3 and had stayed open and was receiving clients. Although the board provided a copy of the social media posting, perhaps indicating that the period of closure of non-essential businesses pursuant to Directive 03, respondent Frazier may have accepted personal appointments and was working during the closure, the board did not provide any direct evidence in support of this allegation. On May 7, 2020, Governor Sisolak issued Directive 18 that allowed nail care salons and hair care salons licensed by the board to reopen to customers, provided that 1, salons and barber shops with walls or partitions between stations and chairs may utilize all stations, but under no circumstances may more than 1 customer or client be seated at any given station or chair. 2, salons and barber shops without walls or partitions between the stations may only seat customers or clients at every other station or chair, or arrange stations and chairs so that a minimum of 6 feet of separation between customers is maintained. 3, salons and barbershops may not accept customers or clients on a walk-in basis, and technicians, stylists, and barbers may not serve or accept appointments for more than 1 customer at any given time. 4, customers waiting for appointments must wait outside the facility and must practice social distancing by maintaining a minimum of 6 feet of separation between customers and not residing in the same household. 5, technicians, stylists, barbers, and other employees must wear face coverings at all times. 6, persons licensed by the Nevada State Board of Cosmetology or State Barbers Health and Sanitation Board must abide by all guidelines promulgated by the respective boards. Boards are directed to impose disciplinary measures against licensees who violate the provision. On or about May 7, 2020, industry-specific guidelines were released by the Nevada Health Response Center in coordination with LEAP, the Local Empowerment Advisory Panel, which included guidance on the reopening of hair care salons. The guidance specifically noted that face masks were mandatory within this infection prevention checklist. The guidance also required that nail care salons must follow the strict guidelines set forth under Section 16 of Directive 18. On May 14, 2020, the board performed an inspection of respondents' cosmetology establishment and found respondent staff were not wearing facial coverings. On May 24, 2020, the board received a complaint that respondents were not complying with the governor's directive, including that respondent staff are not wearing facial coverings. On July 17, 2020, the board received another complaint that respondents were not complying with the governor's directive, including that the respondent staff are not wearing facial coverings. On July 21st, 2020, the board performed another inspection of respondents' cosmetology establishment and again found that respondent staff are not wearing facial coverings. Pursuant to NRS Chapter 644A, the board is vested with the sole discretion to discipline cosmetology establishments and licensees of cosmetology. Let's see here. And just skipping around, NRS 644A.851 provides grounds for disciplinary action by the board, including subsection N, which states that any other unfair, unjust practice, method, or dealing which in the judgment of the board may justify such disciplinary action. If the board determines that a violation of NRS 644A.850 has occurred, it may refuse to issue or renew a license or certificate of registration, revoke or suspend a license or certificate of registration, place the licensee or holder of a certificate of registration on probation for a specified period, impose a fine not to exceed $2,000, or take any combination of the actions authorized by paragraphs A through D. The board alleged as a first claim of relief that respondents should be subject to discipline pursuant to NRS 644A1N for engaging in unfair, unjust practices, methods, or dealings by failing to comply with Directive 003 when respondents continue to serve clients amid the closure of non-essential businesses. However, the ALJ found that without direct proof thereof, the board did not prove by a preponderance of the evidence that respondents continue to serve clients amid the closure. The board alleged as a second claim for relief that respondents should be subject to discipline pursuant to NRS 644A 851N for engaging in unfair, unjust practices, methods, or dealings by failing to comply with Section 16 of Directive 18 when respondent staff failed to wear facial coverings during the inspection on May 14, 2020. The ALJ found that the board met its burden and that the respondents violated NRS 644A 851N for engaging in unjust practices for failing to comply with Section 16 of Directive 18 when the respondent staff failed to wear facial coverings on May 14, 2020. The board alleged as a third claim for relief that respondents should be disciplined pursuant to NRS 644A 851N for engaging in unjust or unfair practices, methods, or dealings by failing to comply with Section 16 of Directive 18 when respondent staff failed to wear facial coverings on July 21st, 2020. The ALJ found that the board met its burden in proving that respondents violated 644A.851N for engaging in unjust practices by failing to comply with Section 16 of Directive 18 when staff failed to wear facial coverings on July 21st, 2020. Upon the conclusion of the hearing, ALJ Greiner recommended that the respondents' cosmetology licenses be suspended for 15 days. Both the personal license and Ms. Frazier's personal license and Reflection Salon's cosmetology establishment license. And ALJ Greiner also recommended that the respondents reimburse the board for its fees and costs expended in this matter, of which the board will provide respondents with an itemized statement of the fees and costs expended within 15 days of the board's order.
Thank you, Justin. I have a question for council. I'm not quite sure how different this particular case is from the case that we just ruled on. So, because I'm confused. I'm confused why this particular case is getting license and establishment license suspended when it's similar case that we just ruled on.
Madam Chair, this is Justin Taruk for the record. Just for the board's clarity, at the ALJ hearings, Ms. Greiner actually took into account some of the requests that the respondents had. She asked Ms. Frazier if she could do a fine or a suspension, and she preferred and opted for the suspension.
Oh, thanks for the clarification. Thank you, Justin, because I mean, they're like the same case.
Right. No, so in the two cases that went before the ALJ, Ms. Greiner actually did ask them which one they kind of asked them their input as far as what they wanted, but in a reasonable manner. Obviously, she's not gonna, but she gave them the opportunity to say,
Okay.
I prefer this or that.
Okay. So since there's no questions from any board members, can I get a motion for the case for Mrs. Jennifer, is it Jennifer Frazier?
This is Kai Stanton. I would like to uphold the findings as well as the citations for complaint number C-2020-0970.
Member Stanton, this is Justin for the record. Just wanted to confirm as well that your motion included the findings of fact, conclusions of law, and the recommendations as stated. Is that correct?
Yes, sir. Thank you.
Thank you.
Mike Debner for the record. I did note that in the findings of fact and conclusions of law, when it came to penalty, there was a discussion within which it said that the suspension against both can be run concurrent. I don't know what the board's pleasure is as to those regards.
So are we saying that they can't run concurrent, or that we need to have a motion for them to run concurrent, just to have clarification, sir?
I would say for clarification, and maybe I'm remembering the document wrong, but I believe it left that part optional. So the question being to the board, which would you like to take, that being concurrent or executive? I think Mr. Turk is looking right now. Was I correct in that assessment, Mr. Turk?
That is correct. My recollection at the hearing was, I believe that they were trying to get it to run concurrently though.
I would like to make an amendment to that I would like to add to have them run concurrent, Madam President. Thank you for clarification.
Thank you.
It's Douglas, board member. I second that motion.
All in favor?
Aye.
Any opposed? Motion carries. Thank you. Agenda item number 3, is it Diva Nails?
Davi Nails, Madam Chair.
Yes.
Okay.
Can you take it over for me, Justin?
Sure can. All right. For the record, this is the case, Nevada State Board of Cosmetology versus Davi Nails, license number S-18078. Board of Cosmetology, case number C2020-0968. Is anybody on the line from Davi Nails? No. All right, Ms. Easter, you're still under
Yes.
oath.
I'm still Leah Easter, Chief Compliance Officer, Nevada State Board of Cosmetology. Has sent regular and certified mail notice of this meeting to the last known address we have on file, November 23rd, 2020.
Thank you.
Thank you.
Board members, before you, in your board packets is a settlement agreement, recommendations, and order. The board had actually filed a complaint to be heard on the same day as the other hearings before ALJ Griner. However, prior to that hearing, the parties reached a proposed settlement agreement, which is now before you. And my apologies, Madam Chair, but I'd have to read the agreement again.
We have a short version.
I'll try to do a Cliff Notes version of it since you guys know that it's going to be under 6448850. So starting on page 1, licensee Davi Nails is now or was at relevant times alleged herein issued salon license S18078 by the State Board of Cosmetology. Accordingly, licensee is subject to the provisions of NRS and NAC Chapter 644A. So the stipulated facts is stated is that licensee Davi Nails understands the nature of the allegations under consideration by the board. Licensee acknowledges the conduct described below constitutes violations of chapters 644A and 644 NAC 644A governing the practice of cosmetology, and that if proven by a preponderance of the evidence, licensee is subject to disciplinary action before the board. So the stipulated facts are as follows. Licensee Davi Nails was at relevant times mentioned herein licensed by the board to operate a cosmetology license establishment, issued salon license number S18078. On March 12, 2020, Nevada Governor Steve Sisolak issued declaration of emergency to facilitate the state's response to the COVID-19 pandemic. On March 20, 2020, Governor Sisolak issued Directive 003 that required the closure of non-essential businesses, including aesthetic services such as beauty shops, barber shops, nail salons, tank salons, and wax salons. On May 7, 2020, Governor Sisolak issued Directive 18 that allowed nail care salons and hair care salons to reopen, provided certain provisions as stated in the agreement. On or about May 7, 2020, industry-specific guidance were issued, including guidance on reopening nail care salons. The guidance specifically noted face masks as being mandatory under the infection prevention item checklist. The guidance further required that nail care salons follow the strict guidelines set forth under Section 16 of Directive 18. On May 13, 2020, the board performed an inspection of licensee Davi Nails' establishment and found an individual not wearing a face covering while performing cosmetology service on the client. On June 29, 2020, the board performed an inspection of licensee Davi Nails' establishment and found an individual not wearing a face covering while performing cosmetology service as a client. On July 21st, 2020, the board performed an inspection of licensee's establishment and found an individual not wearing a face covering while performing a cosmetology service as a client. Violations of law, the foregoing allegations by Davi would violate 644A 851N for engaging in unfair or unjust practices, methods, or dealings by failing to comply with Section 16 of Governor Sisolak's Directive 18 when licensee Davi Nails' employees failed to wear a face covering while servicing clients is on May 13, 2020. The same goes with their failure to wear facial coverings while serving clients on June 29, 2020, as well as July 21st, 2020. Pursuant to 644A 852, the board may impose discipline, including refusing to issue or renew a license or certificate, revoking or suspending a license, placing the licensee or holder of a registration on probation for a specified period, or imposing a fine not to exceed $2,000 per violation, or a combination thereof. As stated, the board had prepared and filed a formal complaint against Davi Nails, but this settlement agreement before you was reached before the hearing. As far as the terms, licensee Davi Nails agrees to pay a total administrative fine of $3,000 as follows. For the first alleged violation stated in paragraph 4 of the agreement, a fine of $500, $1,000 for the second violation of law, as stated in paragraph 5 of the settlement agreement, and $1,500 for the third alleged violation, as stated in paragraph 6. So again, that's a total of $3,000 for an administrative fine. Licensee Davi also agrees to reimburse the board for its attorney's fees and costs. The board will provide licensee with a tally of its attorney's fees and costs within 15 days of the date of the board's order approving this agreement. And licensee can contact board staff to coordinate a payment plan if necessary. Everything else is boilerplate as far as their waiver of their rights.
Okay, I had a question for you, Justin. So the total of, is it Dava or Diva? Dava Nails?
Davi?
Davi, okay, I'm sorry, I messed that up. Okay, Davi Nails has a total of administrative costs of $3,000.
A disciplinary fine of $3,000 plus.
Disciplinary fine of $3,000 plus administrative costs once the board gets it all written up.
That's correct.
Okay, so, okay, I'm okay with that one, but can I just make sure that this is another one that probably needs to, if there's another offense, I would like to see this particular establishment come before the board.
Okay, Madam Chair, I guess Mr. Detmer can also counsel you on that, but the settlement agreement is presented to you as is. I believe that there is a provision in your regulations where if the board does want to have that, we can have that separately from the settlement agreement.
Okay.
Mike Detmer, for the record, for what it's worth, Mr. Taruk is correct. I have no additional statement to add to that.
Okay, so how do we need to vote on that?
So what you would do is you would, right before you guys, it's just a settlement agreement in order. So I would, Mr. Detmer, I don't mean to step on your toes or anything on this, but I would request a motion from the board to accept the settlement agreement. And then I guess you could just state on the record subsequently that if you wanted, if there is something before the board for a subsequent matter, that we would have to bring it before the board, but it wouldn't be a board vote. It would just be more so following the regulations and statutes that are already in place.
Mike Detmer, for the record, that is correct. I would interpret that to be more of a direction for board staff opposed to something that you're putting onto the agreement itself, because Mr.
Okay.
stated, it is a self-contained document.
I'm good with that. So as long as board staff, I guess can document that. Leah, is that how it works?
It is. After the meeting, I'll have a note to flag the account. So if they have any more infractions related to the governor's order, or quite frankly, anything else, I'll have it flagged. I'll get notice, and then I can bring it before the board for you guys to determine what you want to do with it from there.
Okay. So can I get a motion for Davi Nails, please?
It's Board Member Douglas. I would like to uphold the fine for Dobby Mills.
Can I get a second?
Mike Demmer for the record. That's just the motions to adopt the settlement agreement.
Correct. And also adopt the settlement agreement.
Thank you.
Okay, can I get a second, please?
Board Member.
Victoria Negretti, board member. I second that motion.
Thank you, Victoria. All in favor?
Aye.
Any opposed? Motion carries. Thank you. Agenda item number 4 is Nails and Spa. Complaint number C 2020-0971. That's for you, right, Justin?
That is, sorry, Madam Chair, we were on mute for a second, but I can take the floor on that. Before we take the floor on item agenda 4, though, I just wanted to make a comment on items 1 and 2, the findings of fact and recommendations and conclusions. I believe that there was a document uploaded, Madam Chair, for your signature. Since the board voted to adopt those, if you could just have those signed and send them over to board staff just for the record.
I can coordinate that with you too, board chair.
Okay, Leah, tomorrow.
Yep, sounds good.
Okay.
And board members, bear with me. This is the 4th and final case before the ALJ that I'm going to have to read the terms, but the 4th one is Nevada State Board of Cosmetology versus Nails and Spa, license number S-18291, case numbers C 2020-0971. Before you in your board materials is a settlement agreement, recommendations, and order. As with the previous one, the board actually prepared a complaint and filed it that was supposed to be heard on October 22, 2020 before ALJ Griner. But before the complaint was heard and a hearing was held, the parties agreed to a proposed terms of settlement, which is before you today. The stipulated facts are as follows. Licensee Nails and Spas is now and was at relevant times alleged herein issued license number S-18291 by the State Board of Cosmetology. Accordingly, licensee is subject to the provisions of NRS and NAC Chapter 644A. Pursuant to NRS Chapter 644A, the board is vested with the legal power and authority to take disciplinary action, including but not limited to the suspension and revocation of licenses to practice cosmetology in the state of Nevada. On March 12, 2020, Nevada State Governor Steve Sisolak issued a declaration of emergency to facilitate the state's response to COVID-19 pandemic. On March 20, 2020, Governor Sisolak issued a declaration of emergency Directive 3 that required the closure of non-essential businesses, including aesthetic services such as beauty shops, barber shops, nail salons, tanning salons, and wax salons. On May 7, 2020, Governor Sisolak issued Declaration of Emergency 18 that allowed nail care salons and hair salons licensed by the board to reopen to customers with certain provisions as stated in the settlement agreement. On or about May 7, 2020, industry-specific guidance was issued, including guidance on reopening nail care salons. The guidance specifically noted face masks as being mandatory under the infection prevention item checklist. The guidance also required that nail care salons follow the strict guidelines set forth under Section 16 of Directive 18. On May 10, 2020, the board performed an inspection of licensee's cosmetology establishment and found proof that licensee was possibly allowing employees to perform aesthetic services. The board noted that it appeared there was more than one client per licensee in the establishment. On June 7, 2020, the board received a consumer complaint against licensee that licensee staff was not wearing face coverings. On June 8, the board performed an inspection of the establishment and found licensee's employees were not wearing facial coverings. On July 15, 2020, the board performed a follow-up inspection of licensee's establishment and again found licensee's employees not wearing face coverings. The violations as alleged would violate NRS 644A.851N for engaging in unfair or unjust practices, methods, or dealings by failing to comply with Section 16 of Directive 18. when the licensee's employees failed to wear facial coverings on June 8, 2020. The second cause of action was that their failure to wear face coverings on July 15, 2020 was also prohibited. The settlement as proposed is that licensee agrees to pay a total administrative fine of $1,500, $500 for the first alleged violations of law as stated in paragraph 4, and $1,000 for the second alleged violations as stated in paragraph. So that's a total administrative fine of $1,500. Plus, the licensee agrees to reimburse the board for its attorney's fees and costs. The board to provide licensee with an exact tally of its attorney's fees and costs within 15 days of the order approving the agreement. The licensee may contact board staff to coordinate a payment plan if necessary, and everything else is boilerplate.
Thank you, Justin.
I hope that was quicker for you.
You did good.
Thanks.
Good morning. Can you hear me?
Hi, good morning. We're on agenda item E4. If you could please mute your microphone unless you're on the agenda item that we're talking about, please.
Yes, we are. We are the iNail Spa.
Oh, okay.
So I understand that we need to pay for the fine, but I need to know that what I need to pay for. So we allow one of the days that we are closed. So we do construction inside. So so we have family and construction to put out the cabinet. As you can see that my salon is remodeling right now, during that time. So one of our staff did not wear masks, which just mean not employee, but we are family doing construction. So we got fined for that. So we do get fined on the day that we close.
I don't mean to interrupt you. Could you state your name for the record, please?
I am behalf of iNail Spa for Dien Bien.
Okay, ma'am, I was speaking with the previous one before the settlement agreement. He signed it, and I forgot what his name was off the top of my head.
Yeah, Dien. He is my cousin, and I am the partner with him.
Okay.
But I just need to know that we got violated for that. Is it like by law on the date that we close, we still got fined, even though we don't open, we close to do the construction?
So, ma'am and Mr. Detmer, correct me if I'm wrong. Today's meeting is to discuss the settlement agreement that has already been proposed. Today is not the time to make assertions as far as any allegations. Mr. Fan indicated to me that he was able to sign off on the proposed settlement agreement on behalf of iNails.
I understand. I totally understand, but we need to know. So it's a future. If we closing and you guys come in on the date that we close and we do construction, then we still got fined for that same reason. That's what I need to know.
Mike Detmer for the record. Again, as Mr. Taruk just stated, this is the agenda item is specifically relating to the adoption or rejection of a settlement agreement. It sounds like you want to get into something that this is about.
No, it's just like I just want to understand that if it by law that if we are doing the construction on the date that we close, with all the family, like we have the date that, for example, we have the date we close, we go in, we do basically maintenance, and we do repair everything.
Mike Detmer, and I do mean it. I don't mean to be rude about it when I do that, but again, I don't see, and maybe I'm being too literal. If this agenda item is about adopting or rejecting a settlement agreement, it sounds like you're asking for something other than that.
Yeah, I understand. I just want to understand, that's all. But the fine is fine. We already signed it, so we're not arguing for that. But I just want to be understand and clear. So next time, if we close, then we just lock the door. Then we say we close, so we can do maintenance inside. That when you guys go in, we're not interrupting us when we do construction.
Ms. Fan, this is Leah Easter, Chief Compliance Officer. If you do have questions unrelated to the settlement agreement, just generally about operations, please feel free to call the office's main line or send an email to info@nvcosmo, and someone would be glad to answer any other questions you have.
Okay, indeed.
All right.
Thank you, Leah. I was just about to suggest that because it sounded like we weren't going to be able to answer her question because it didn't pertain to the agenda item.
Okay, my question, excuse me, my question, maybe it's for you, counsel. I'm not quite sure she wants us to reject this and she wants to renegotiate with our administrative
No, we're
legal
moving
person.
forward, ma'am.
Okay, so you're good
We're
with it.
moving- Yes, I'm good with it, but I did have a question, that's all. But I know how to reach out to other department to find out, because to be honest with you, is my cousin doesn't know what we I try to understand. I wasn't there, but now I'm back. So, but we are fine. We are fine with the fine and everything, but for moving forward future. So I will reach out to the other department to see that what appropriate to run the business with a lot of requirements. That's all. But so far, everything is fine.
Okay, thank you. So you have the number to the board. You can speak with the chief compliance officer.
Yes, ma'am.
Okay, thank you. So as that stands, can I call for a motion?
Yes, ma'am.
Can you can just mute your Ms. Hannah? You can just, okay, there you go. Can I get a board member? I would like to call for a motion.
This is Kai Stanton. I would like to make the motion to uphold the settlement and the findings for complaint number C-2020-0971.
This is Douglas, board member. I second that motion.
All in favor?
Aye.
Any opposed? Motion carries. Thank you.
And
We're
board
at
members-
agenda, pardon?
Sorry, this is Justin for the record. Just wanted to interject. I wanted to say thank you to Mr. Detmer, but I believe he will be leaving us. And I will be serving as board counsel for the remainder of the meeting.
Mike Detmer for the record, to the board. It was an absolute pleasure. Thank you for this opportunity and time to sit with you. I look forward to the next time I get to be amongst this board. So thank you very much and have a good day. Be safe.
Thank you, counsel.
Thank you.
Thank you, Mr. Detmer.
We're now at agenda item number F, petitions before the board. We have petitioner, is it Kang Nugent? License number U102281. Do we have a Kang Nugent? Calling twice. Kang Hoan Nugent. Can we accept board's recommendation, Director Landry?
Yes, you can. You can accept it, and that will make when you accept one, when they want to come back, they've got to present new evidence. So if they can just present the same evidence they were going to present the first time, they're not going to be allowed on. So that I would say you want to rule on all of them.
Okay. But I'm confused, how many we ruling on?
Just that one at a time, each one.
Oh, okay, you're talking about all of them
Yes.
moving forward, right?
Yes, that's correct.
Okay, can I get a motion to accept the board's recommendation for Kang Nugent license number U102281?
This is Kai Stanton. I would like to make a motion to uphold the information that is set before us for U-012281 for the board.
All in favor?
Ms. Douglas, board member, I second that motion.
Oh,
Sorry, I believe that there was a comment.
No, I don't, the record so far, Board Member Stanton has denied the petition and Board Member Douglas has seconded Kai's denial. Good.
we had Stanton to deny?
No, uphold.
Uphold the board's recommendation.
To deny his petition.
Yeah.
Okay, you're upholding. the
Yeah, we're gonna uphold the recommendation.
Right, no, not deny, yeah.
Okay.
I apologize if that's what you heard. I recant that if that's what was stated.
Okay. We're phrasing it differently, but I got you. Our recommendation is to deny him and you're upholding our recommendation.
Yes.
We're
It was like,
upholding
"Don't
board's
put that in."
recommendation.
We're on the same page. I got you. And we have our second by Board Member Douglas. So now you're good for the vote.
All in favor?
Aye.
Aye.
Motion carries. We're now at petitioner number 2. Is it Mojan Tamkin?
It's Mojgan Tamkin.
Oh, okay, I was close. Hi, welcome.
Hi.
License number ST 101714. Can I have you sworn in, please?
Yes.
Will you testify that everything you're going to say today is the truth and nothing but the truth?
Yes.
Very good.
You can go ahead and speak to the board.
So I was caught on my phone during the test. They thought that I was taking pictures of the screen, but I will admit that I was looking up answers, but I wasn't taking pictures or like recording anything. So that's pretty much it. I was just caught on my phone during the test.
Okay, so thank you. Any board members have any questions?
This is Board Member Douglas. I would like to know why you were on your phone as far as trying to cheat.
Sorry, what was that?
This is Board Member Douglas. I would like to know why were you on the phone trying to cheat?
I don't have a good excuse for that. That was like my biggest mistake. I took the test a couple times, and that was when it was during the whole quarantine, and I kept failing, and I had no money for retaking it. So I know that's not a good excuse or anything, but like I don't know. It was just something super dumb that I did. And I know I should have left my phone in the car, or I shouldn't have had it at all. And it was just something that I totally regret.
Do you feel that you learned your lesson coming before
Yeah.
the board?
Oh, yes, I did.
Okay, thank you.
This is Board Member McCormick. I would like to hear from Adam Higginbotham. I see there's some information here from him. I believe.
I'm here. Madam, thank you, Board Member McCormick. Madam President, I can share screens if.
Yes, go right
you
ahead.
vote.
I appreciate that. We appreciate that.
One moment, please. Okay, can everyone see the screen that I'm sharing?
Yes.
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 So the applicant is a complete aesthetic student from a Nevada school. The applicant was caught in a compromising situation with our theory test's integrity. which we're required to protect as a state agency with the third-party testing vendor that we utilize, PSI Testing Services. Part of our state contract with PSI is that we do maintain the test integrity. So the applicant is brought before the board for the transparency handling of that. The applicant has unsuccessfully attempted a theory licensing exam on 4 occasions from July 4th to July 11th. The applicant was visually observed with a prohibited mobile device at the testing station. And at this point, the applicant would need approval for the board to test, and this occurred 7 months ago.
This board member Douglas, would that be June 4th to June 11th or July? I know you said July, and I'm looking at June.
I think that the testing was from June 4th, 8th, 9th, and 11th. I don't see anything for July.
Yeah, he said July. That's what I just want to correct.
I'm sorry, June. I apologize. June 4th through June 11th.
Okay.
Adam, I have a question for you.
Yes.
How many times do the board allow an individual to test, and is it normal for a applicant to test like every 2-3 days?
We have no laws that would prohibit the volume or the frequency of the test. And our testing services, we test on the top of every other hour, which is very unique because a lot of boards don't do that. We are a testing facility. We operate 16 testing stations between 2 locations. And if it's available, if that test spot is available, anyone can get that test spot.
Okay. So what has you, I just got a question too, probably for, I'm not quite sure that maybe you can answer it. When an individual is caught on their phones, and we appreciate the fact too, that the applicant has admitted to the fact that, she was looking up answers. How often do we haven't gotten anything before you? Have you guys seen this before?
There have been several occasions where we have caught applicants, and we do the same thing. We prohibit them from retesting until our superiors, which is the board, grants them approval. Or the board could have us look at whether or not the applicant has merits any type of discipline for any moral character clauses that might be in our law. But we haven't typically moved forward with that. We've been waiting for the board to approve whether they can retest, but the board can take this administratively if you all would like to have an administrative hearing over moral character, but we haven't done that in the 2 or 3 that I recall that we've had in the last 5 years.
But have anybody ever been, I can't remember, even in the last 5 years, have anybody ever had a fine for this?
No, not that I'm aware of.
Can I say something?
Yeah, sure.
I just wanted to say, like, I'm okay with getting fined or whatever, because I just feel like if hopefully I'm allowed to retest soon, they can check me or whatever, because I promise you that's something I will never do again. And they can even have someone stand beside me if anything, but I'm okay with getting fined as long as I'm allowed to take the test again. Like, it's been, I don't know, I just feel like it's been 7 months and I've been super super sad about this whole situation. Like, I could have had my last license by now and started my career if I didn't do this. So that's what I wanted to say. Like, I'm okay with getting fined or whatever you guys think, but that's just something I would never do again.
Thank you.
And I apologize.
Thank you.
This is
Go
board
right,
member-
go right ahead, Board Member Douglas.
Oh, I would like to know, have you been studying real good? Because doing 4 tests back to back and you haven't passed any, I would think that you would need to get in your theory and practice more, because you
Yeah,
don't want to be guessing on a customer and then there's an accident because you guessed on it.
I was kind of like going through some stuff during quarantine, which is why I did study. But then as soon as I got in front of the screen, I felt like I completely blacked out. And I was also going through some stuff around then. So, which is why I should have waited and studied more until I was in a position to actually take the test and was ready for it. So that's why I had to take it back to back and stuff, because I felt like I knew the answers, but once I got in front of the screen, I completely blacked out. But yeah, I've been studying since then. But yeah, that's pretty much it. I was just not in the right state of mind to take the test, which is why I was doing it back to back.
So now you feel that you're ready to take the test and pass it?
I definitely feel like I do need to study more, because with my job and this whole I was unemployed for the longest and stuff. I do feel like I need a couple of weeks to study really hard, because I really want to pass the next time I take it. But yeah, I've been studying and I just feel like I need a little bit more time to study.
Okay, thank you.
Adam, I have one more question for you. Is there anywhere in the regulation where this would fall up under a fine?
That would be a question better applied to Justin.
Okay. I need to ask Justin that question. Can you hear me, Justin?
I sure can, Madam Chair. I was just talking with Leah and Gary about it. As far as a fine goes, I think if you guys are going to want to impose a fine, this isn't the time to do it, because it's a petition for asking her to retest, not so much a disciplinary action to do it.
So there's no disciplinary action attached to this?
No, I think what the petition, correct me if I'm wrong, board staff,
Right,
but
her,
it's just.
her petition was strictly that she was denied testing, so she's here to ask whether or not she can test. So if you all felt that it was most appropriate to levy a fine, we'd have to first file a complaint, have either a settlement for her to agree to the fine, or you would hear the matter and levy a fine at that point. And that earliest we could do that would be April. We'd revisit everything in April.
But
because what I am, and I do appreciate her sincerity, but what I do have a concern with is that we have hundreds and hundreds of students in school and they're testing, and we need to set a precedence that that it's not okay. You know, even if you're allowed to test, I mean, if the next person come before us, we're gonna have to allow them to test.
So, Madam Chair, this is Justin for the record. I think what can happen then is for the petition, you would decide whether or not you allow her to retest. And then I will speak with the board staff to determine whether or not disciplinary action and a complaint. We have sufficient grounds to file that and then present that before the board at a future hearing. But as far as this petition goes right now, I don't believe that you should be issuing any fines because it's just a request to retest.
Madam President, does the board prefer that we move forward with administrative actions and put it into the Attorney General's hands?
I just think during COVID, there was a lot of students that, you know, working from, you know, doing theory from home, and like she was explaining, and maybe the information wasn't as clear to her, and she's taken the test multiple times. It's kind of what she's saying, and it's in her notes. I just think that the next student comes before us, you know, there's no way we're going to be able to deny the next 10. So I just want us to start taking that sobering look, as Board Member Stanton uses the word. I picked up your word. Because I mean, we're not gonna be able to deny anybody the test. Once we set this today, we're gonna have to let anybody that has an issue and had an issue on their phone, taking a copy of the test or looking up answers, we will vote for them to test, if that's gonna be the outcome today. So, I mean, if the board wants to discuss it and they want to go ahead, it's up to the board. I'm one vote. And normally I don't. So if I'm just seeing this, it's not gonna end here. So if we want to put something that, I'm not quite sure how to handle the situation. Leah, if you can, or no, I'm sorry, Adam, you right there. I'm sorry, you right here. If you can give us some assurance of something. I just feel like I don't have enough assurance that it's not going to happen another 10, 15 more times this coming year.
Well, one of the challenges that we have whenever, or one of the experiences that we have whenever we encounter these issues, you know, I think that there have been 3 in the last 5 years. We communicate to the applicant that we're not the owners of that test. So if they compromise that test, there is an enormous financial liability to have a test recertified and validated by a testing vendor, whomever that company might be. I've heard before at conferences that the liability could be close to $1 million to redraft a test. We did notify PSI that their test could have been compromised in this situation. We gave them the information related to the applicant that was pertinent for them to communicate to their attorneys. I don't know what their steps have been done, because our job as their vendor is to only report what we've experienced.
Okay.
And there is that very detrimental act. You know, if you're responsible for compromising the test, it is a substantial amount of money to have that testing vendor supply that replacement for that test. As for a specific assurance, our staff, we monitor 4 or 5 cameras daily within our testing facilities. We have windows to help us look through. We have cubicle stations that applicants are required to put their personal belongings in. There's a locked bag. It's a bag, an orange bag with a lock on the top with a key. They put their belongings in. We lock their bag up with a key. We give them the bag and they put the bag in a cubby hole in the testing room. This applicant knew about those processes. And I believe on June 9th, prior to the day of us finding it, we had to remind her that her phone needed to be put back into the bag the day prior to the day we found the phone that she was utilizing while in front of the testing station.
So that was before the test that she's actually was cited for.
Correct. So our staff already had their eyes on the applicant while she was testing. So they do a really good, the staff does a really great job of monitoring.
Okay.
And they see both the window right beside them to look at the test. And then on the computer screen, there are all these computers, all these cameras pointing at the testing stations.
And if I may, President Bramo and Adam, this is Maggie Adams, compliance specialist. At that time, we had just come back from COVID, and the bags we had been using we couldn't sanitize them. So we didn't use the bag at that point. But since then, since this has occurred, we've used the bag to have them put their phones and personal belongings in. So it was just a reboot coming back from COVID about what to do properly and how to do it.
Okay.
Thank you, Maggie.
Thank you, Maggie. Thanks, Adam.
Brian Baltazar, and I'm sorry, may I, Madam President?
Yes, go right ahead.
So staff, just for confirmation, if we were not to grant her the ability to retest, what is the blackout period that she's not able to retest without our permission? When would she be able to retest based upon, you know, the system just allowing her to do so after a certain time? Or must we allow her to retest from this point onward?
Well, we haven't had too many of these cases, and I'm not aware of too many that have petitioned to the next level. This individual's before you all for you all to decide whether you want to approve her for testing, or if you would like staff to transition this matter from a petition to administrative action that would transition to Justin for whether it's a settlement or some type of hearing to occur for disciplinary action to be applied. At this point, we haven't transitioned into that disciplinary action because we're looking at the board's appetite. How do you all want to handle this specific issue in the past? Typically, when we encounter something when a test could have been compromised, we bring it before the board and the board makes the determination. So it's up to you all how you want to proceed. And Justin, if I'm misspeaking, please correct me. But at this point, it's either approve or I think maybe still transition into some administrative action by the Attorney General's office.
Thank you. So if I'm understanding correctly, we're essentially laying the groundwork for this kind of infraction from this point onward because we don't really have anything established.
Correct. And in so many ways, yes, but this is still appropriate avenue at this point because we do not know the appetite of the board on this particular type of scenario.
Okay, I would have to agree with Gwen that if we do move forward with granting permission to test, we really wouldn't make a case for ourselves should we ever want to deny someone to retest. So I would feel most comfortable laying down the groundwork for what something like this is going to look from this point onward. And so if that means deferring to the Attorney General's office to help us decide what that's going to look like, I mean, I really highly doubt that this is going to be the first time this comes up. It's unfortunate. I mean, if I had done this in a test, I mean, I would have immediately failed the course and it would have had major ramifications for me. So I think that's only fair to have that across the board for any level of education, regardless of where it's from. But at the same time, I also do understand that this has been a highly stressful time period, unlike any in our lifetime.
And board member, sorry, this is Justin for the record. Just want to reiterate that, again, the petition is whether or not to allow the petitioner to retest. If there is an appetite for disciplinary action, I would just caution not to have such detailed discussions, I guess, on that, because it might sway how the administrative hearing will be entertained, because right now it's not really a disciplinary action adjudicated right now because there's no complaint before you guys. So I would just, if there's any specifics as far as what you want to do, as far as a fine or any other disciplinary action that you want to take against someone who does this, I would caution against having discussion about that right now and just focus on the task of whether or not you would like to approve her to retest at this point.
I understand that, Board Member Bramo, but Justin, I think the issue is we needed a little bit more clarity. And because normally when I haven't seen a situation like this, so maybe it was right when I became a board member that many years, those years ago, but I don't remember seeing a case like this. So I would prefer it not to go to the administrative judge, to be totally honest with you. I would prefer staff to bring a recommendation and come back before the board. If I can get the board members to give me a motion on that.
That's fine, President Bramo. I didn't mean to say that everything has to go before the administrative law judge. I just meant that if there was going to be some discipline or anything imposed, that we shouldn't do that right now. It's just
No, I totally understand what you're saying, and that's why I'm going to move on with that one. I get it. I really do. Okay. I just think staff this is something that staff can take care of and bring it back before us. It's just that I think everybody wants to be clear, that's all.
Sure, no, I understand, thank you.
Okay. Can I, any other board members, I apologize, have any other questions for the plaintiff, the petitioner?
This is Board Member McCormick. I don't have per se questions for the petitioner, but I do have a question related to the frequency of testing. Am I clear that there's not currently anything in place for a failed test? There's no increments of time in place that one person has to wait before retesting? Based on these dates, that doesn't appear to be the case. I do agree with Board Member Baltazar and President Bremo that I don't believe this is the first time that we'll see this, but I do believe that approving testing at this point is premature. And definitely we have obvious attempts at, fraudulent testing by admission, and also she was caught. I did hear the petitioner say that even though she has had since June 11th was her last failed test, that she does believe that she needs a little bit more time. So I think we have to listen to what she's saying and understand that even now, with 4 failed exams and having had time since June 11th, she still feels she needs more time. With that said, I do think administrative, not the administrative judge, but I do think that transitioning this to administrative action by the staff would be the best course of action before allowing her to retest.
Thank you, Board Member McCormick. Can I get a motion from a board member, please, so that we can move to the next agenda item?
This is Board Member McCormick. I'd like to make a motion to deny the petition to retest and transition this to the staff for administrative action.
This is Kai
Brian
Stanton. I second that. Oh, go ahead, Brian.
No, go right ahead, Kai.
This is Kai Stanton. I second that motion. Sorry.
All in favor?
Aye.
Any opposed?
So sorry. So we got, I'm not allowed to retest?
The board office will be actually in touch with you, and then they'll give you the steps for the next step.
Okay, so I just wait for an email or a call?
Ms. Tamkin, you'll actually get a letter in the mail, and it'll have contact information for you. So you'll know who to reach out to and how to get a hold of them.
Oh, okay. Okay, thank you.
Okay, so I'm asking all in favor. Everybody said all, motion carries. Thank you. Petition item number 3 is the Thai My Lin loan, license number U102323. Are you available today?
Yes.
Okay, can I have you sworn in, please?
Excuse me, my English is not good.
Do you have a translator with you?
Yes, please.
Okay, we're gonna need you both to be sworn in. Executive Director Landry will swear you in.
She doesn't have one? Oh, Madam Chair, this is Justin for the record. I believe I was speaking with Lisa and board staff. I don't believe she has an interpreter with her. She was thinking that we would provide her one. But I guess she needs to, so, Ty, you don't have an interpreter with you, do you?
No.
Okay, and you need, and you would need someone to help you?
Yes, please.
Okay, we, unfortunately, the board doesn't provide interpreters. You would have to provide your own.
And the interpreter does not have to be someone who's certified as an interpreter, just needs to be someone who can understand your language and translate that to English and back and forth.
Unless you want to proceed with your petition without one, that's your decision.
So that means, do you want to stay with us today to go over your petition, or do you want to reschedule for the next board meeting and have someone to interpret for you?
Yes, please.
Lisa, member President Bremo, Lisa Nguyen can speak Vietnamese. I think if we can have her just tell her on the record in Vietnamese that she needs to bring her own interpreter, and we'll just reschedule her for the next one, so that way she can understand that.
Yes, please.
Okay.
Em ơi, bây giờ nếu mà hôm nay em không có người thông dịch á, thì bây giờ nó em phải chuyển qua cái tháng 4 thôi. Lúc đó em mang người thông dịch theo em để người ta dịch cho em, chứ ở đây á, không có thể nào mà dịch cho em được. Phải là cái người của em.
Dạ em không có quen ai mà giỏi tiếng Anh hết chị ơi.
Em phải mướn người, chứ giờ ở đây không có thể nào mà chị không có thể dịch cho em được, tại chị là người của Bo. Em phải kêu người đó dịch cho em, còn không thì em coi như là bữa nay á, một là em sẽ đồng ý em làm tiếp tục, em hiểu bao nhiêu thì hiểu, còn không á, thì em về qua tháng 4 em phải có cái người, em muốn chọn cách nào.
Dạ vậy em chọn hôm nay, em muốn hiểu bao nhiêu thì hiểu, mà em nhờ mấy người hội đồng viên á nói chậm cho em.
Ok, chị nói là she's agreed to proceed with a petition today, but she asked if we can talk a little bit slower for her to understand more.
Okay.
Dạ em xin lỗi.
Thank you. Does she understand that you will not be acting as translator for her though?
Yes, she does.
Okay, I just want to make sure that there's no miscommunication that we are providing a translator.
Yes, I
Thank
sent
you.
an application to her and she will proceed with her petition today.
Thank you.
Thank you.
Okay, so Director Landry, can we swear Xylin in?
Okay. Do you swear that the testimony today, you're going to be telling the truth and nothing but the truth?
Yes.
Very good.
Okay, Adam.
Thank you, Madam President. Tai Mi Ling Luong, there's an update on the last document that you received. She's an applicant she's applied 2 times at this point. The applicant submitted a reciprocity application from California in September of 2020. The applicant previously applied for an out-of-country testing applicant in Nevada in May of 2019. The applicant has attended training from a beauty school located in Vietnam. As a reminder, at the October 8, 2019 board meeting, the board voted to not recognize schools from Vietnam as being comparable to Nevada's requirement due to the following reasons. 1, lack of oversight authority. 2, inconsistent reporting of educational requirements by the schools in Vietnam. 3, inconsistent reporting of the textbook materials utilized by the school. 4, the validity of the documents were difficult to determine. 5, there was a high test attempt frequency from applicants from these schools. And 6, I'm sorry, I might be off my number. 6, there was a spiked increase in the volume of applications coming from certain schools during a period of time. This applicant applied again in May of 2019, was denied because the board voted to not recognize the license. The applicant then obtained a California license in September of 2020. So she now has a California license that she's transferring over from California. The applicant is now, I guess, it could be eligible for reciprocity through a California license upon board approval. This is another kind of a nuance or a new type of petition coming before, just like the last one. This one is coming from someone who has got a license from a jurisdiction that we do accept, bypassing certain mechanisms put into place by the board once the board identified certain curriculum requirements and school structures of a certain jurisdiction was not comparable to Nevada's jurisdiction. So this is another matter before the board, whether to approve the California license with the Vietnam training and how to move forward from this point on.
I have a question for you, Adam. Thank you. So the individual, Mylin, was denied licensing in Nevada because she's from, she wanted to apply for license out of country from a school located at one of the schools that were banned.
Well, it's that whole jurisdiction, because
Yes.
not just that school, because we asked out of nowhere, we started getting a lot of volume of applications coming from Vietnam. So we started asking questions that we would ask any of the schools here to determine validity of documents coming through. And there was a gap of understanding of what the documents were coming. So we had this concern in 2018 of getting documents we couldn't verify. And when we tried to verify the documents, we discovered that some of their training wasn't comparable to Nevada's. And what we found was those 6 items or 7 items that made it difficult for the state of Nevada to confirm the validity of those documents because the accuracy being recorded.
I have one more question. So the applicant, after the denial of Nevada, the applicant obtained a license in California, which maybe an exam was taken, and received license. Now the applicant is eligible for reciprocity if the board approved, but this is the same applicant that graduated from a school in Vietnam.
Correct. And we may be bound to accepting that reciprocity applicant, possibly. It's just, how do you all prefer that we move forward with this? Do we look at an avenue of seeing how this can be tightened up through some procedure? Do we move forward with the application? What's the appetite of the board?
So does California, one more question for me, I'm just got questions today. California doesn't look at Vietnam schools from Vietnam? Vietnamese schools, they just automatically accept the documents?
That process has changed. They didn't used to, and now they are. They do not verify the validity of those documents, nor do they attempt to even go into a layer of is it valid?
Okay.
And this is a larger scale of states making some of these changes as a result of occupational licensing review that's occurring. States have made those modifications in response to this. So
okay. Any other board members have any other questions?
Yes, this is Board Member Harris. I would like to know, how long did she study in California coming from Vietnam?
Hi, T.
Hi.
How did you hear the question from Board Member Douglas?
Harris.
I'm sorry, Harris.
Mhm.
How long did you work in California?
No, I just test at California. I no work at California.
Oh, okay. Okay, thank you.
Thank you.
So board members, you all have read the information and we've all heard from Adam. At this particular time, I will call for a motion.
Brian Baltazar, I motion to deny the petition.
This is Board Member McCormick. I second that.
All in favor?
Aye.
Aye.
Motion carries. Thank you, Tylin.
Thank you.
I'm now moving on to petition number 4 is Tay Nugent. Do we have that one up, Adam? Okay.
I'm sorry, Madam President. I think it's Azita Amari Formoazaki.
Adam, did number 4 get dropped?
Oh, I'm sorry. Yes, I apologize. It's not on my slide.
Oh, number 4 was dropped?
That's correct. Number 4 can be skipped.
Oh. Okay, so we can just move on and do we have to make a motion to withdraw it?
Nah, it didn't withdraw. It was just dropped. So you're good to just move on to Azita.
Okay. Azita, petition number 5, Azita
Yes, hi.
Amari. License number U8804. Petitioner is asking for approval for testing.
Yes, hello.
Yes. Can I have you sworn in, please?
Yes,
Do you swear that you're going to tell the truth and nothing but the truth in your testimony today?
yes.
Very good.
Madam President, may I begin?
Yes, go right ahead.
The applicant enrolled in school in February 2009. We know this because there is a $10 student enrollment fee that was charged and paid for and is in her account. The applicant paid the application fee, paid for an application fee, which was required to be eligible for the test at that time, back in 2012. So we have an accounting transaction where a $15 fee for an application was paid for, which meant she was getting a testing application. The issue that we have with the file is that the applicant has a 2011 record of completion from Advanced Beauty School, which is a school that closed down 4 years ago, I believe, 5 years ago. The applicant's record of completion is checkmarked that she has completed the program. Where we are at administratively is, and we need the board's guidance, is that on that record of completion, it shows that she has completed 928 hours, which means we cannot account for 871 hours on her record of completion. And the applicant is seeking approval for taking the licensing test. And on the next page here, I can show you on the top of the application. If you look at the image on the top, that is what our old records of completion or withdrawal used to look like several years ago. This particular document is from February 1, 2011. And it's completed by the school, and this is for Azita. This is her completion form, and you can check that it's completed on the form. And you can see that there's a little gray area on that check mark. That is a highlight. That was a standard operating procedure of board staff at the time to highlight whether or not an application was completed or withdrawn. The applicant additionally has a diploma that shows that she has a certificate of completion from Advanced Beauty School. It's just, the file shows that she's completed, and the file is almost 10 years old. but we don't have the hours that she apparently transferred into Advanced Beauty School from some other location. And that's where we're currently at. Our application shows that she's completed, but there is missing hours from wherever she transferred the hours to prior to. And I believe it was a matter of record keeping or system functionalities at the time of digitally maintaining records is the reason for the gap. And that's all.
Adam, well, maybe this question is for Azita.
Yes.
You're applying to test, and you transferred prior years you attended school at Rollers, correct?
Yes.
Okay, when Rollers closed, Adam, did we get a copy of the students' hours from Rollers?
There are difficulties in any school closure of obtaining hours. We have not been unable to find the information that she needs to transition to the next, or the front part of that data. We have been unable to find that. We only have the latter part that shows that she's completed.
So you're testing for esthetician?
As a cosmetologist.
Oh.
Can I say something?
Yes.
Oh, when I was in a rural school, my last name was Amiri Hormuzaki. So when I and call on October to find out how can I sign up for the state board test, she told me she cannot find the hours and she can find just 928 hours. So I went to the board and I talked to the lady, and one of the girls, she find some of the hours from rulers. So it shows like 400 something hours she find by my social under Amiri Hormuzaki. And I don't see that here now. And it just says I have 928 hours, but actually they found some of the hours, some more hours under the rulers, but by the last name of Amiri Hormuzaki, not Amiri, because when I become citizenship, I changed my last name to Amiri. So she finds some of the hours, but not the whole hours from rulers. And you know, the rulers just a school suddenly without notice or anything. One day I went to the school and I see the school is closed. So I contacted the state board that time. And they told me, you just find the school, we're going to transfer your hours to the new school. So I did that. And after I finished an advanced beauty school that time in 2011, I went to the board to make sure everything is okay and I have my hours. So the lady, she checked, it was at Sahara that time, the state board. The lady, she checked and she said, yeah, everything is complete. You just need to get ready for the state board test. And when you're ready, come back and just do the test, you're okay. I said, is this the hours going to be expired or something? She said, no, everything is here and not going to be expired. Just when you're ready, come back for the test. So last year I lost my job. So I said, okay, so it's a good time. At least I can do that because that was my only hope. And I was sure I finished the hours and I've already paid for that at school. I have the proof, but I don't have the breakdown hours. So I said, so it's a good time. At least I can do a study test and go for the test. So I can get the license and find the job after I lost my job last year by the pandemic.
Madam President, what she is saying, it is accurate with the processes back in the time. She would have been unable to purchase the $15 application fee without having a record of completion on file. In addition to that, it appears that it is, since the school that she was attending prior to transitioning to the school she attended last, it appears that it was a prime event for poor record keeping to occur, not only from a school closing down and the lack of being able to digitally store it. At the very, and our hours don't expire if you have completed the program. The hours only expire after 4 years if it's an uncompleted program. We do have a copy of things that have completed. We just don't have a full record. We still have the theory, practical, and state law tests that would be administered to her if she gets approved for testing, which would be a good measurement for consumer safety and to be able to deliver the services in a safe and sanitary manner. At least we can verify that through those features. It's just between the record of completion, that checkbox being checked, completed, then it being highlighted. In addition to that, her paying a $15 application fee to get that testing applicant. The data trail shows that she was considered a completed student at one time. It's just, we have missing data from over a decade ago.
I just have one question. Maybe it's a comment or a question. Normally, when a student transfers from another school, the state board gives the hours of approval to the next school to enroll that student. So I just want to make sure that the hours that the 400 plus hours will still be short. It appears to still be short, but if the 400, because it was 1,800 hours at that time. So I'm still kind of confused here a little bit. So if it was still short, if Azita was told that we found 400 plus hours, 400 plus hours weren't transferred to this 900 hours. I'm hoping not, from the time that she enrolled and the time that she completed. So if she completed with 925 and 4 plus 100 hours, how many hours is that?
1,300 something.
I think those 400 hours that we've found, they might be handwritten or through another file. It's not on her account. I do remember the discussion about additional hours being found and still being short. I think it's in a handwritten ledger that shows how many hours that she had, but that's again, that's the reason why this application is here, is that we don't have a completed picture of things. We only see the end of the data trail, and the end of the data trail shows that she was on the path to be eligible for the test. I guess it just she never came in and completed the test after that point.
Azita, how many hours did you complete at Rollers? How many hours did you complete?
I don't remember. That was a long time ago.
Yeah.
I just know they transferred my hours to the advanced, and they said, okay, you need 928 hours. So I finished that at advanced beauty school.
Okay.
This board member Douglas, I have a question.
Go right ahead, Douglas.
I remember Rollers school, beauty school, and I remember that situation where it did close like that. But as the advanced beauty college, wouldn't they have like a paper trail as far as like before they enrolled her for a certain amount of hours? And then I'm also remembering, if you don't take the test within certain years to get your license, you got to go back for what, retraining or more hours just to get back up on the new stuff or current stuff? That's what I
Kind of,
remember.
yes. In a way, yes. If those hours are if they're incomplete hours, they do go away after 4 years. But I believe the regulation is specifically for incomplete. And in this case, we have a document that shows that she is completed from that school, which would make the hours non-expirable.
I think we just go with, if I would like to myself personally go with staff recommendation.
Well, if in this situation, I was preferring her to take the test because it is a measurement of the validity of her training and her ability to mitigate the risks that we're statutorily obligated to protect against. The test will help verify her understanding, and it's a good measurement. We do have documents that shows that she's completed, and it seems like it's just a missing data set from her earlier career that we don't have. And the last set of her data set shows that she's completed and ready for test.
Okay.
That's just the way the data looks. It looks like it's just we missed the front part.
And things happen and then transition. It's just hard to say. I mean, I would hate for her not to be able to move on with her career. But I just think that Azita, my personally opinion, it's been a long time. So, you know, any other board members have any other questions? Can I get a motion, please?
This is Board Member Douglas. I would like to approve Zita to take the exam to get her license.
This is Board Member McCormick. I second that.
All in favor?
Aye.
Aye.
Good luck.
Any opposed? Motion carries. Good luck, Azita.
Thank you. Thank
Okay.
you, guys. So I can just take a test and make an appointment and take a test.
Yeah, we'll send you an email.
Thank you. Thank you, guys. Thanks for your time.
Okay, bye-bye.
Thanks, bye.
It's 11:01. Can we keep going? Director Landry?
We can continue on as long as the board wants to. If you need a break, you can take a break, but if you want to continue on, let's continue on.
We want to continue on, right, board?
Yes, ma'am.
Okay. Petitioner number 6, Claudia Sanchez, license number U102285. Petitioner is requesting for approval of her reciprocity application from California with a felony. Can we have Claudia Sanchez, please?
Hi.
Hi, can you
Claudia
raise your right
Sanchez.
hand? Be sworn in?
Yes.
Do you swear that everything you're going to say today is the truth and nothing but the truth?
Yes, sir.
Very good.
Okay, we don't want to rehash history, but so can you tell us what has changed? Tell the board.
Well, it's been 10 years now. Unfortunately, I was at the wrong place at the wrong time. However, since I did get the felony charge, I know it has to do with the assault with the firearm. However, I just want to put it out there that I was there. However, I did not have a firearm, nor did I use it on anyone, nor did I know that it was going to be there. I was with friends that night. It happened. And because I didn't say anything as I should have, it did catch up to me, and I did pay my debt to society for that. And I did everything I was supposed to, which was completed my probation. 5 years, stayed out of trouble. I've since then moved. That was back in San Diego. Decided to move to Riverside or Murrieta first. Then I did cosmetology, as I've been trying to for years on end. Between then to now, I feel like I've been a model citizen. I've had my 2 boys. I support them on my own. And I did my 1,600 hours. And I just would hope to be able to get my license here in Nevada to continue that. Well, my career. So I know I was denied that because of the charge. I just don't want to be judged based on a mistake I made 10 years ago. I did put in my hours. I did put in my time. This is something I work towards as far as getting my cosmetology license and running or trying to run a business. I took unnecessary classes, which included with probation, I had to do anger management, which I did do. I completed my formal probation. I since then have always carried a job, and you know, I distanced myself from people in the past, and I was young, and I made a mistake, and I'm just hoping to be able to continue out what I've been doing in California here in Nevada, since I am new here, and I've been here for about 6 months now. So, I mean, do you guys have any questions, or I don't know what I'm supposed to say?
This is Board Member Douglas, Claudia.
Yes.
You said you only completed 1,600 hours?
Or whatever, I'm sorry, I don't even know. Whatever hours I was supposed to do in California, that's what I completed. Honestly, I don't remember.
Okay, thank you.
Yeah, I just threw out a number out there. I know it was in the 1,800, 1,500. I don't remember. This was at Riverside Community College. I did part-time there for 2 years, but I did complete the whole program. I did graduate. I did take the test. I did all necessary steps that I was supposed to in order to get approved.
License out here?
I'm sorry?
So you're just trying to transfer your license from California to Nevada?
Yes, ma'am.
Okay.
Board President Bramo, I just wanted to mention, the reason why she's here today is because she had a felony that has violence. So unfortunately, if she had not remained silent and let them charge her with a violent crime, she wouldn't be doing this now. She would already be approved. The only reason why I had to deny her is because she had a crime of violence, but it really wasn't a crime of violence. She didn't have the gun. They charged her with having a gun, and that's the way it goes sometimes. And that's, you shouldn't remain silent. You should speak up. But when you're getting charged and all this stuff's going on, I know it can be confusing.
I understand. I don't have any questions.
Okay.
If there's no other questions for any other board members, can we get a motion?
Board Member Douglas, I would like to approve Claudia Sanchez U-102285, so she can take her test for Nevada State Board of Cosmetologists license.
Can I get a second, please?
Board Member Harris, I second that motion.
All in favor? Aye. Any opposed? Motion carries. Good luck, Ms. Sanchez.
Thank you so much, you guys. You guys have a good day. I appreciate everything. All right, thank you.
Petition number 7, Lucila Rodriguez, license number U-102225. Petitioners requesting approval for reciprocity from an application from Florida. Thank you, Adam.
Hi.
Hi, Lucilia. Can we have you sworn in, please?
Yes.
You swear that the testimony today you're going to be telling is the truth and nothing but the truth?
Yes.
Very good.
Okay.
It's actually from California. I originally, do you want to speak first? Or, I don't know.
No, you can go ahead and speak.
Oh, okay. I wasn't sure. I went to school in Florida. I moved to took my tests, my practical and my written test in California. My husband lost his job. He worked for Apple in California during the pandemic. We moved here because we got job opportunities here. And then I was trying to transfer my California license to Nevada.
Okay, can we have Adam, please?
Thank you, Madam President. For the record, Adam Higginbotham, Deputy Executive Director. The applicant is seeking an aesthetics license or the ability to test as an esthetician. She does have an aesthetics license in California, but it's a little complex. The applicant completed a program as a skincare training program and a paramedical training program in Florida. And she holds a Florida facial specialist registration and license. Now, Nevada does not have a license or registration titled facial specialist, nor do we have a license with a scope of practice that matches the license of Florida called a facial specialist. A Florida facial specialist license or registration, it's very limited in performing facial related services. And the training for a facial specialist does not cover body treatments or hair removal training as outlined as the aesthetics training. And the scope of practice requirements in Nevada and other states that have a license as esthetician, they have those abilities to perform those services. The facial specialist does not have it within its scope. The applicant's transcripts were reviewed because she does have a facial specialist program. And in addition to that facial specialist program, she has training for that paramedical training program. And some of the courses in that paramedical training program are comparable to some of the training in aesthetics. But overall, the applicant's transcripts were reviewed and a letter of credit of 414 hours would be issued to the applicant for her to take to a school to complete for aesthetics. However, the applicant is seeking an esthetician license or the ability to test as an esthetician. We reached out to California to see why they issued this license, because typically they don't issue reciprocity for facial specialist license, and they are looking into that situation. That's what we've got back from California.
May I speak?
Yeah.
Well, in California, I have a license in California. In Florida, I did hold a business for 7 years as only waxing eyebrows and body waxing. So I did that for 7 years in Florida. You could even Google me. I've been in magazines. I am responsible with holding wax and working with clients and people. I've never had any issues. I don't have any negative, like history within the law or anything like that. I've had my license since 2000, I want to say 2002 or 2002, 2003. I did take wax classes in waxing in school. I remember physically waxing people in school and everything. I've had my license for a very long time. I could even teach people, I've taught people. In California, they said, okay, that's fine, because they saw my history and they saw, I was a good person in the sense of working, and I never had any issues. So that's why I'm surprised that, that I don't have enough, enough history or I don't know what the word is, but I believe that I have enough knowledge on my work. And I've had my license for working in the same field for almost 20 years.
I just had one question. Maybe it's a comment, because I think I think the letter of credit for 414 hours. Given the fact I did review the transcripts as well, I thought that was, to me, my opinion, was fair. I understand that you do have a lot of experience, but the license of esthetician.
I have more than 400. I have almost 900 hours.
But the license of an esthetician in the state of Nevada is a lot more stringent than in a lot of other states. And we kind of get this issue a lot, even with those that do lashes. They do lashes, they have lash bars, but they don't have an esthetician license. And an esthetician license is a lot different, because when I was looking at the transcripts, I saw a lot of the procedures that we have here in Nevada that you didn't have, that wasn't, I guess, required for a facialist specialist. Am I correct, Adam?
That is correct. The facial specialist program, it's just simply not comparable to the aesthetics program, not just in Nevada, but in the major majority of the states across the country, because they dissected the level of training and the scope of practice is narrow, that it does not include certain types of services that are more of the higher risks services in mitigating the consumer risks for health and safety malpractice, and the product reaction risks with the types of chemicals and the ingredients in those products that are applied to the face. The level of training of knowing how those products interact it's an important component of mitigating the risk to the consumer. Unfortunately, we even have a notice on our website that says we do not recognize the training in full specialists because the scope of practice just isn't comparable. It's only covering possibly 60% of the 100% of the license that you would be able to be granted in the state of Nevada. And I confirmed with California, their policy is that they still do not accept facial specialist licenses. So I don't know how this application got through.
Yeah, how did I get my license in California?
I don't know. I don't want to.
I took a test. I thought of, you have to do the physical part. I did everything, and I'm just ready to work. Through this pandemic and through this hard time that we're all going through and all that, I'm just ready to get my feet back in and work. It's hard.
And that's what we want. We want for all of our licensees and potential licensees to be able to work so that the industry can continue to thrive.
Yeah, I want to really, like, my goal was, I really want to get into tattoo removal, and unfortunately, nobody wants to give me a chance on it because I don't have an esthetician's license in Nevada. And even though you can work in Nevada without a license doing tattoo removal, most of the people here want you to have a skincare license just to have, into
No,
tattoo
I think we as
removal,
board, I can speak for myself as a board member. I truly do understand, but at this point, when they're given a letter of credit, when the board staff issues a letter of credit, it's mainly that the board, I would like to uphold the board's recommendation.
Okay.
Any other board members have any other questions before I call for a motion, please?
This is Board Member McCormick. I completely agree with you, President Bramall. I do believe that the letter of credit for 414 hours towards the completion of an aesthetics program should be done, but I do not believe reciprocity should be done. It's important for all estheticians to be up to speed with Nevada laws and Nevada regulations, but also it's important that you learn every aspect of aesthetics. And it doesn't sound like these licenses, the license that you currently hold, covers everything. Thank you.
This is board member Douglas. I have a question for Lucilla.
Yeah.
Does Florida have a esthetician license or just a facial specialist license?
I thought I had an esthetician's license. I worked with dermatologists. I did medical facials. I worked with Dr. Brandt, which everybody knows who he is.
No, I'm speaking of what the school gave you when you graduated. What did they give you?
I did two courses. I did a esthetician's course and then a medical esthetician.
Okay, so did they give you an esthetician license?
Yeah, that was what I thought I believed I had. I mean, I could go and look for my Florida, I could look for it and see, but on there it says esthetician. That's why I'm confused.
Board Member
Okay.
Douglas, I just
This
want to
is
kind of
where
like, if you look in
this
your
is where,
packet,
yeah. You
excuse
like
me,
it? Yeah. No, no, I
excuse
don't
me,
like
I
it.
think
Okay.
somebody's, excuse me, if you're not speaking, if it's not, you're not up to speak, can you put your microphone on mute, please? Thank you. Board Member Douglas, if you look at the transcript, it appears to be more of a college transcript, which is credit. Am I right, Adam, versus clocked hour?
Right, yeah, I did look at that. And I was confused at that too.
Well, because a lot
there
of
should be two
colleges and
courses.
universities do it that way.
Yeah,
There
this
should
is
be-
her second course. This is her second series of training.
You don't
So
have the
she
first?
has, yeah, I do.
Oh,
That is for your your facial specialist training. Your first one, I think it's 260 hours is what Florida has for facial specialists. I can't remember off the top of my head. But we took not only the first transcript that she provided us for the facial specialist, but in addition to, we've dissected courses within the paramedical training that are comparable to aesthetics training in Nevada. That would be, those hours would be in addition to the full specialist training that she would have. It's just out of both of the transcripts that were provided, we couldn't come up with the 600 hours. And that's us even including that second training requirement for the paramedical skincare training that she has. And it's just, unfortunately, we couldn't find all the subjects that would enable her to perform the full scope of practice for an
Right, I agree.
Correct.
Okay, at this time, I would like to have a board member call for a motion, please.
This is the Board Member McCormick. I'd like to make a motion to deny the petition for reciprocity. I would also like to approve the 414-hour letter of credit to go toward the completion of an approved aesthetic program.
Can I get a second, please?
This is Kai Stanton. This is Kai Stanton, board member. I second that motion. Sorry.
All in favor?
Aye.
Any opposed? Motion carries. So they will be in contact with you, Ms. Rodriguez, for any other your additional details to move forward. We're going to go on now to petitioner number 9. Is it Zesta Felix?
Zesta Folks, ma'am.
Zesta Folks, I apologize.
Hi, Gwen, I think you may have skipped one. There's just one ahead of Zesta. I think it's Leor Backman.
Yeah, agenda item 8.
I skipped agenda item 8?
I think so.
Oh, I'm sorry. I sure did. Okay, I apologize. Petitioner, is it Leor Vacan, license number U 102341? Petitioners requesting approval for out-of-country reciprocity for testing.
Hey, hello.
Hi, hello. Can I have you sworn in, please? Can you raise your right hand?
You swear to tell that the testimony you're going to give today is the truth, nothing but the truth?
Yes, sir.
Very good.
Yes, you want to speak to the board?
Yeah, please. So, I was already approved by the board on October 28th. Paid the fee to take the test. I bought the books to study for it. On November 4, I was notified via email that not all my credits are accepted and I cannot take the test. I have to complete nearly 200 hours. I explained I already finished all my hours and brought all the documents that were required of me, and everything was already accepted. I did not understand the students change. I was given the list of school where I need to complete my hours. I called the schools, some was closed, some want from me repeat all classes and said they do not allow complete hours, even to it was what I was told in the email. So I went to State Board office again and was told to bring documents showing that I did 200 hours of facial from the school in Israel. I brought the documents, both the original and the translate symbol. That's it. I just want to option to be tested, to do the exam and engage in my profession. That's it.
I don't know if there's any other questions. Everything is pretty much cut and dry. Adam has it all written out for us there. If you have any of the board members have any questions for Adam, any questions for Ms. Valken?
Brian Baltazar, so just to quickly recap, and staff, if you could help clarify, so she was approved to test in October, but now we're finding that she's not able to test because of the deficiencies in eligible credits or hours?
I would have to look to see if she was officially approved or if it was a matter of the application being completed. And in the process of review, the automatic text is sent and says you're eligible for your test now. But anytime that there's an out-of-state, an out-of-country application come in, it's slightly slower if the country that the school is located in isn't responsive, or if it's in a different day. So, for example, if we have to send out an email at 2 o'clock in the afternoon, it might be nighttime overseas, and we won't get an answer till the following day or longer. So there could be any time gaps over that. For this particular applicant, we looked at the application a little bit more. You know, skincare, aesthetics, it's one of the fastest growing, it is the fastest growing field in the beauty service industry. There are a lot of applications that we get coming in, and some of the applications that we get require us to look at the transcripts to verify if the applicant is eligible for a test. This is one of the applications coming from out of country. They would have to provide us with a transcript, and from that transcript, we look at the curriculum subjects to see if they match Nevada's curriculum subjects, and if those subjects transition to the scope of practice for an esthetician. And the staff has reviewed this, and staff has only been able to identify 406 hours that would be transferred from the course that she took in another jurisdiction and apply it to Nevada's jurisdiction. And I want to communicate that Nevada's aesthetics jurisdiction is it's not a unicorn in itself. It's not that you have to fit this model. There are more states that do fit this model than not. It's just trying to find, it's the occupational licensing reforms changing certain entry points in certain areas, not only in the United States, but also other countries might not have the regulation structure that we have in the United States. So we have to look at each application carefully, each letter, each transcript carefully. We have to look at it translated and compare it to its original document. And we do our best to come up with what we can assign them. And if that scope of practice, if that subject can fit in our scope of practice, we give them the hours. And these are the hours that we were able to identify based on the transcripts that were provided. And that's 406 hours on this particular case.
It looks like 406 hours was good for the transcripts. I mean, you guys did a good job, because a lot of the wording is totally different from what we actually have in our curriculum. So I think you did a good job with the 406 hours. Do we have any other board members have any other questions before I call for a motion, please? I would like to call for a motion. Hello?
This is Board Member Douglas. I would like to uphold Lori for not applying for her license or not taking her license.
Hey!
Until she gets her other, what, 190, 194 hours she needs?
Problem.
Correct. That would be the remainder of the program.
Can I say something?
Sure, go ahead.
So they just said that I need to complete 196 hours of facials, and I just gave them a paper, a document from my school in Israel, separate that I did more than that. I did 250 hours of facials. It just come in Israel. It's coming separate. It's not coming in the same page with things.
Okay, but they just explained.
Excuse me, Ms. Douglas, board member. Ms. Vacan, I believe that the board has combined looking at both transcripts and comparing it to the curriculum for the state of Nevada. It appears to me, looking at the transcripts, that 406 hours was given, in some of the subject matters that you took. That's not even our same subject matters. They took those subject matters to break them down to say what was comparable, which I think they did a really good job, because there was a lot of things that you studied that was not comparable to what we actually study here in Nevada. In the majority of the surrounding states throughout the country, there's certain studies that have to be not just facials. So the letter of credit for 406 hours is what the board staff has recommended that you get towards the completion of your esthetician program. So did we have a motion on the table?
Yeah, Douglas board member did a motion that she would have to go back to school for the 194 hours she needs to complete.
Can I get a second?
Victoria Negretti, board member. I second that motion.
All in favor?
Aye.
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 Any opposed? Motion carries. Thank you, Ms. Vacan. You can contact the Nevada State Board will contact you with the information that you need to move forward.
Thank you.
Thank you. Petitioner number 9 is Zesta. Okay, you got to pronounce that for me, Zesta Falk.
Folks. Yes,
okay.
ma'am.
Yes, can I have you sworn in, please?
Yes.
You testified today that you're going to tell nothing but the truth and only the truth?
Yes.
Very good.
You want to go ahead and speak with the board, please?
Yes. Back in 2013, I had gotten into a altercation with my youngest 2 children's dad, and we had met at Family Dollar for him. Well, we had seen each other at Family Dollar, and basically we agreed that he was going to watch his kids. So I told him to follow me back to my house, basically. And I told him I had some things to do, take my other children to school and other things. So like he wanted me to do their hair. So I told him he would have to wait until I gotten back. I left, did what I need to do. And then I went back to my house, and he was asleep on the couch. And my kids were, my youngest two were playing on his phone. And I heard a woman's voice on my phone, on his phone. So I wanted to see, who they were talking to. So I walked into the bathroom and basically asked who it was. And, she told me that she met my kids. So
you know what, Ms. Folks, I don't want to interrupt you, but we see a lot of good stuff here. So you don't have to go over that because we do have that information.
Okay.
Mainly what you can say to the board at this time is what you have done to change your life so that you can move forward.
Okay, I'm sorry. Yes, I have completed cosmetology school. I've also completed nail school, and I also went back for aesthetics. And I have gotten my licenses except for one. And I have moved to Las Vegas to make a better way for my babies. I'm a single, and I'm just trying to, make sure that my kids, I'm financially stable for my babies. And
okay. No, go
sorry.
right ahead.
And I'm just trying to make sure that I'm financially stable for my kids, and that, that I just take on my career here in Las Vegas and, hopefully become a billionaire one day.
Okay, so Director Landry, this is just another application that went before you. That's just a formality.
Right. It's just any of the ones you're hearing today are those who have felonies with violence attached to them, no matter how far back it goes and whether it was rightfully or wrongfully charged. That all gets muddled in the mix. But these are all the ones you're hearing today are the ones who have felonies with violence, and that's the only reason why you're being heard today. All the rest of them I process as part of my duties, but the ones with violence I can't process. It has to go before the board.
Well, I look for change is what I look for. What you used to do, you don't do anymore. So, I mean, it's a board, and any other board members have any other questions for Ms. Folks?
I'm sorry, maybe I missed this or maybe I wasn't paying close enough attention. Do you feel comfortable sharing what the charge was exactly?
It was a Class D felony.
But for what was it, like battery or assault with a weapon or that kind of charge?
It was, I believe, battery with the weapon.
Okay,
thank you. There's a letter, Board Member Baltazar, inside there that's attached that talks about the court documents and the explanation and the time frame in which it happened.
Okay, I see it now. Thank you, Madam
President. Okay. So I would like to actually for a board member to make a motion.
This is Board Member McCormick. I'd like to make a motion to approve the licensing for Zesta Fowls.
Can I get a second, please? Can I get a second, please?
I think it's Board Member Douglas. I'd like to second that motion.
All in favor?
Aye.
Aye.
Any opposed? Motion carries. Good luck, Ms. Fox.
Thank you so much.
Petitioner number 10, It's Monica Mitchell, license number, student 101008. Petitioners requesting for approval of her application for testing of a felony. Do I have Monica Mitchell here today?
Yes.
Hi, Monica. Can we have you sworn in, please?
Yes.
Are you verifying that today's testimony will be the truth and nothing but the truth?
Yes, I do.
Very good.
Thank you. So I just completed a 10-year sentence on a felony in Nevada State Prison. Bear with me. I positive for coronavirus, so I get short of breath. The school that I was in, the cosmetology program that I was taking inside, has done wonderful things for me, and I would like the opportunity to continue to be able to continue to take my testing so that I can get my license and continue to be an outstanding citizen. I am out on parole. It's been 3 months now, and I actually do think that part of the reason that I was granted the parole was because of the program that I took inside with the cosmetology. And also I want to mention too that the whole 10 years that I did in there, it was disciplinary free. I never had any write-ups or anything like that. So I made poor choices, and I would just like the opportunity to be able to continue my career.
I don't have any questions. Any other board members have a question before I call for a motion?
Not a question, but just sharing a position. I know that a lot of these that are going to come before us are for violent offenses, but I don't recall any of the previous ones being for murder, and that this particular charge does unsettle me, especially how soon you've been released from incarceration. It just makes me honestly quite uncomfortable.
My crime was during the felony commission, during a felony murder law. It was not by my hands, and like I said, I have served my time for that. I was noted as just the driver, but during the commission of a felony, all parties involved will be charged with the murder. But if you look into my case, a little more scrutinized, you will see that I was just the driver. Like nobody died by my hands.
Monica, can I ask you a question? How long are you gonna, are you still on parole?
Yes, I'll be on until August of 23.
Okay. I would like to call for a motion, please.
It's Board Member Douglas. I would like to approve Monica to test to get her cosmetologist license.
Can I get a second? Can I second that, Director Landry?
Yes, you can.
I want to second that Monica Mitchell is approved to get her license, and I wanted to be able to make a second to that. That if Monica, can I make another motion to that? Can I approve it? Can I approve the second and then I make another motion?
Hi, Gwen, because we're just having a discussion here with our DAG, because you have some autonomy over the school located on Smiley Road, it might be best to have someone else make the second in this case, and then you could just call for the vote. So right now, we just have a motion by Board Member Douglas to approve, and we're kind of up in the air. Is there a second to also approve for Monica?
Okay. Can I get a second on the motion, please?
When we don't have a second, what do we do?
Then the motion dies and someone has to make a new motion.
Okay.
Brian, your face is on our screen. Did you want to make a new?
I would have to make I can't second that motion, unfortunately. I would have to motion to deny the petition.
So now we have a motion to deny on the table. Is there a second to deny her petition?
I second that motion.
Okay, and then Gwen, you're up to call for a vote.
But I want to ask a question before I call for a vote. Is that possible?
Yes, that's possible.
Okay, how long do the petitioner have to be released after serving the 10 years? How long does a petitioner have to be released in order to apply for licensing again?
They can apply at any time. Depends on how long the denial is. If the denial is a straight denial, they can apply after, I believe, 5 years. But if the denial has some time frame, so it says denied for a year, then a year later she could come and apply again. So it depends on what kind of parameters are set with the motion.
Okay, so is there such thing as making a motion to give the petitioner an opportunity to prove herself now that she's being paroled for the next 2 years, to be able to prove herself and come back to the board to show that she has shown good faith?
Yes, she can do that with any of the motions that you put on the table. Just depend on how the motion's made as to what time frame she has to apply again.
Okay, so is there a way I can get a motion with a time frame?
But President Bramo, I just want to confirm with you, does that mean if there's a time frame that you automatically want to give her a license, or do you want her to just come back after that time?
I think that should be up to Executive Director Landry if the petitioner has shown good faith in the community, and because if the parole board has allowed parole, Executive Director Landry, and there is a probational period, if that individual could come back and at that time the board can set some restriction now, and they come back to you at that time and you are allowed to make that decision.
Okay, if the board deems that for this particular one, giving me the decision rights on that can happen. But if you don't give me those decision rights, then she has to apply back to the board, because I can't grant anyone that has a with violence on it. That's the only ones I can't grant.
Okay, because I'm a little bit confused, board, because that we granted licenses with violence before. So if we can, if you're not comfortable, if we're not comfortable voting, then we need to give the petitioner an opportunity to be able to know when the right time frame to come back. I'm just confused right now. Do I not speak on this, or do I speak on this? Because this petitioner was enrolled in the program, and she was enrolled in the program per the Nevada Department of Corrections as well.
Yeah, and one thing I would say, if you're gonna deny her the ability to get a license, you need to also consider whether she can be approved to take a test now and withhold the license, or she won't be allowed to test at all, and she has to test 2 years later, because that could be some, you don't remember everything you were taught. So
right.
are you voting on giving a license or not? And if you're not giving it the license, are you approving the testing? And she'd wait to get her, see if she passed the test, and in 1 year, 2 year, whatever the board wants, she could then reapply to the board and say, I've done all this, I passed the test, I'm ready to, to be licensed.
Okay, so.
So is that something that needs to be discovered, because there is an active motion on the floor? And so if that needs to be amended or revised, then I would gladly withdraw my motion and allow for other board members to voice their opinion on this matter. I absolutely understand, Madam President, your position, and I also understand what Gary's saying. So like I said, I'm more than happy to hear from others, and I'm more than happy to withdraw the motion to allow for further discussion.
Okay, can we do that, Board Member Baltazar, please? So
Absolutely.
that we can come to some type of agreement with the petitioner to see if she's going to be able to take a test and then receive a license later on, or never going to be able to test. I'm just not quite sure. I don't think the petitioner's cleared, nor I'm definitely not clear on where we're going with this. I'm just not clear.
Brian Baltazar, I withdraw my motion and defer to whoever second my motion.
This is Board Member Kai Stanton. I will withdraw my my second to open for discussion, and I will explain what my concerns are. She's still on probation. Okay, it is rather violent regarding what happened. Other cases that we have reviewed, from my understanding, weren't as aggressive as this one, and I could be wrong. So because we're still on probation, that's what that is we're giving the time to ensure that there is enough balance there is enough time to show a reflection of that good modeling citizenship, et cetera, that we need to have into place, because things are so fresh in that aspect of still having to meet certain guidelines regarding the state and other things of that nature. We do want everyone to be successful, but giving them the platform to be. And so that's where that time frame is coming in, where I am saying we need to give her that time to be able to have that on time with the probation officer in states and whatever the requirements are. That way there is a nice understanding and a balance, and creating a certain level of habit of not just accountability for the new requirements of the law and this, for cosmetology or whatever else is required from the industry, but also it gives us a little bit more security to say that the Nevada is safe, the public is safe, and that's what we're doing, is also giving them that second chance and opportunity with that background. We have some track record at that point.
Can I ask a question as well? I respect that, Board Member Stanton. Can I ask a question, Executive Director Landry? Because Monica just needs to take a written exam, would there be any way, if in fact the board voted that way, that she takes the exam so that she won't forget the information and the license is held till she proves herself?
Yes, that could be done. The board can do anything with dealing with licensing, whether to issue or to withhold or to do anything with the license, whatever the board wants to do with it.
This is Board Member McCormick. I would like to see if my, other board members would come in alignment with allowing her to test, since this is fresh. However, withholding the license until she completes probation. Is it possible at that time that she could come before the board again, or that wouldn't be necessary? So we would have to withhold licensing for her to come before us again. So maybe just, is that possible, Executive Director? Something like that?
Yes, any of that's possible. Whatever the board wants to do, you can rule on the licensing and testing of this individual. You can tell me when she can be allowed to test, when she can be allowed to license, or if she has to come back to the board to receive her license. Whatever y'all want to do, it's your decision to do it.
This board member Douglas, I have a question.
Go right ahead, board member.
Okay, I understand everybody on the board concerned, and I made that motion because I feel that it gets out of jail or is in jail, if they're a murderer, whatever they are, you know, that's not their livelihood. And everybody that gets out, they got to go to work somewhere. So opportunity to have or get her license. You know, she's going to work somewhere. There's murderers and killers among us as these types of jobs. So I don't think we should hold her accountable as far as well, she can't, you know, get a license. I'm pretty sure there's some murderers that's doing people's hair. That's just how I feel.
I respect that, board member Douglas. I just had a question, and I wanted to make sure that all board members read the information in the packet. That what I read, that Monica was the driver, she wasn't the actual hands-on person. So, you know, serving 10 years in prison and another 3 years on parole. I mean, we have to at one point say, you know, who are we, the judge? But I know we have to hold up the standards of our industry, and I totally agree. But I'm a firm believer in second chances. But if the board says so, I'm with the board. I would just like someone to, even if I could make the motion, Justin, that that she takes her test. Her practical has been passed already. She takes her written test and the license is held, and Executive Director Landry makes the final decision after parole and probation board information is given to him.
Just to,
I'm
I'm
sorry.
sorry.
Go ahead.
Go ahead, Balthazar.
Just to piggyback off of, I think board member Tia Luttrell was saying, running it congruent or aligning it with the parole would seem most comfortable for me. I'm not saying that she should be, you know, barred from making a livelihood. And, you know, to touch on what board member Douglas said, absolutely, you're right. Someone is going to, you know, offer her employment elsewhere. It's not a matter of that. It's just the time frame for me is a little uncomfortable. And although I understand what you're saying, that you were just a driver, I don't want to get into the nuances of, you know, what that says to me.
Right.
We have different perspectives on this issue, and it's not my position to, you know, superimpose my viewpoint onto you. But yes, running something that aligns with the parole timeframe would be, I think, a happy concession.
This is board member Kai Stanton, and to just be very clear, I think the full board wants to support the Working Nevada successfully, but we need to make sure, what does successful look like? And we also need to make sure that when you're dealing with customers that are irate or emotional, you're dealing with formulas and other things that are chemical levels, that we are taking an active view of what we're really looking at. And because it's so fresh, we're not saying we're taking anything away. I just want to be clear on my point of view. We're just saying that working with a probation officer or something of that nature, just to give us that extra support and to give that growth and other support as you're transferring into a new environment, is just better support for success. And I think that's where we're coming from.
Thank you, board member Stanton. I would like to if I can make the motion, Justin, I don't know if I can, but if I could make the motion, I would like to make the motion.
President Bremo, I would recommend that you don't make it, just because
Okay.
what Leah said earlier.
Okay.
If another board member agrees with that, I guess they could state that they would like to have the motion as stated by you.
We just need a motion. We need a motion so that we can move forward.
Yeah, thank you.
I think that this is Board Member Kaiseta. I think the motion is how do we put that in the proper terminology so it doesn't read incorrectly on the goal and what we're trying to achieve. So I just want to make sure that the verbiage is correct when we're making a motion. And I think that's what the hesitant, you know, we don't want to put something in motion that was never our direction. So what does that motion look like verbally, just to make sure that I am stating that correctly?
Member Stanton, sorry, this is Justin, just for the clarification. So could you give me again what the outcome you guys would like to see with it? Just so that way I can maybe help you guys frame that motion for you.
This is Board Member McCormick, if I may, Ms. Stanton. Board Member Stanton.
Yes, please.
Justin, I would like to form a motion that allows for us to withhold her license until she has successfully completed parole. I do believe that my board members agreed that testing at this time would be okay, but delaying the latter.
Okay, so Member McCormick, just to clarify, so it sounds like the motion would be that the board would be okay with allowing the petitioner to test for her license. However, the board would put parameters to withhold issuing that license if she's successful with the testing until she successfully completes her parole. Is that correct?
That is correct. This is Board Member McCormick. I would like to make a motion to approve the license or to approve the testing for this applicant. However, to withhold the issuing of this license and that it be conditionally based on the successful completion of probation.
Does she have to go back before the board, or do we just issue it when she's completed her probation?
To be issued upon successful completion by the board, by you. She does not need to come back before the board.
Member McCormick, I think that motion is fine if that's the direction that the board wants to go with this petition, so.
Brian Baltazar, I feel comfortable seconding that motion.
All in favor?
Aye.
Aye.
Any opposed? Motion carries. So can I just be clear? I think so that we all could be clear. The motion on the table was that the petitioner is able to take her exam and the license will be held until completion of probation and probation.
That is my understanding of what the motion was stated as, Madam President.
Correct.
Okay, I just wanted to be clear. Okay, thank you.
Thank you, everybody, and be safe out there.
Okay, thanks.
Thank you.
Bye-bye. Petitioner number 11. Can we go to, because I think we're moving pretty good here. Can we get done with these next couple ones before we even take a 10-minute break? It's just 12:03.
Let's do it.
Okay, so the next petitioner is petitioner number 11, and it's license number U104561. Is it Brunruzga Pinwata?
Hi, good morning. My name is Bunraksa Pinwatana. I go by Annie.
Okay, hi Annie. Can I have you to raise your right hand, please, to be sworn in?
Yes.
You swear that everything you're going to tell today is the truth and nothing but the truth?
Yes.
Very good.
Okay, so you want to tell us a little bit about, we have your the information here. It's your turn. Go ahead and speak.
It's a 19-year-old DUI felony. Since the felony, I have turned my life around. I am a part of several rehabilitation groups, and I'm in the process of moving to Southern Nevada. I am part of more social groups that help other people. I'm a great member of community. I pay my taxes. I have good credit. I have turned my life around. I am remorseful of what I did. But since then, 19 years, I think I proved enough to demonstrate that I turned my life around. So I'm just looking for new opportunities in Nevada right now. And that's all I have to say. Yeah. I mean, I would be happy to answer any questions.
And I'd be interested to hear what my other board members have to ask. Any board members have any questions?
Brian Baltazar, and of course, I want to ask if you feel comfortable sharing the details of the charge.
I was over drinking that evening and hit another car. I was 19 years old, and they did charge me with a DUI felony. There was bodily injury to it. They gave me some jail time and 5 years formal probation, which I've completed. I did go for an expungement. I do have lots and lots of letters from different organizations speaking on my behalf, but I couldn't upload that because that wasn't part of the application process. But I have turned my life around, definitely, and I'm just ready to contribute to society in Nevada.
Thank you. I appreciate your willingness to share that with me. And just for confirmation, it wasn't DUI manslaughter. It was a bodily harm, correct?
Yes, it was a DUI bodily injury.
Thank you.
Okay, so if there's no other questions by any of the board members, can we get a motion? Okay.
This is Board Member McCormick. I just want to make sure I heard correct. You did 5 years probation and that's complete.
Yes, it was, I wanted to upload those documents, but because it was so old, it wasn't readily available through the internet. And then
Oh no, it's okay. We just wanted to make sure that you had completed your probation. Thank you so much.
Okay, so any other questions before I call for a motion? Okay, I would like to call for a motion, please.
This is Board Member Harris. I would like to make a motion to grant Mrs. Numbers U104561 to get her license to pay a tax.
This is Tia Latron McCormick. I second that.
All in favor?
Aye.
Any opposed? Motion carries. Congratulations. So the board staff will be sending you, Annie, an email or some information, okay?
Thank you.
All right. Petitioner number 12 is it Francisco Castillo? License number A47662. Petitioner is requesting to enroll at a school as a student in both hair design and esthetician instructor at the same time.
Yes.
Can I have you raise your right hand, please?
You swear that the testimony you're going to give today is the truth and nothing but the truth?
Yes.
Very good.
Thank you. So we would like to hear from you.
Yeah, so actually I'm a I am a licensed esthetician. I am actually enrolled in cosmetology, not a hair course, not hair design, a full Cosmo, just because I wanted to be able to travel to other states, you know. But yeah, I've almost been a esthetician for 2 years, and I just enrolled at the International Academy of Style in September, and that was the school I went to become an esthetician. And so I'm familiar with some of the instructors, and they told me that their aesthetics has been, for lack of better words, I'm trying to say it, not catered to enough. They've had an overturn of instructors, and I just wanted to know if I would even be able to be an instructor while being a student. I've been able to demo, and it showed no conflict of interlapping times or anything. I've demoed on my off time, on times that I'm not even there.
Okay, I have a couple questions.
Yes.
Because I'm a little confused with this one.
Mm-hmm.
You're a licensed esthetician.
Yes, ma'am.
But are you a PIL esthetician as well?
No, that is what I wanted to, that is why I'm here before the board, to see if I would be able to become a PIL for aesthetics while being a cosmetology student.
So you want to be a student and an instructor at the same time?
Yes.
Okay, but let me ask you a question about the student instructors program. The student instructors program, even the PIL program, the PIL program states that you have to have at least a year's experience. The instructor students program is a 750-hour program. So are you?
What I'm trying to do is my PIL.
So you're trying to do your PIL to be a hair design instructor?
Aesthetics instructor.
Right, I see that here, and it says that you have been practicing services for over a year. How long exactly?
Almost 2 years. I have been with my current position 2 years in March, is like 2 weeks after I got my license, which I believe was March 5th, 2019.
You practice in a salon?
Ulta Beauty. I joined their brow bar in October 2019, but I've been using my license since March 2019 with them.
Okay. I think the only thing that I have a concern with, and that's me personally, is you being a student and a student instructor at the same time.
Mm-hmm.
Because when you're a student instructor, there's a certain level of respect that the students have to have for you, and you're no longer on the student level. You're on an instructor's level, because that's what the PIL program, you considered as staff.
Correct.
That's a little confusing. I'm confused.
The when I went for my appeal for the board, I stated that the only students I would be interacting with are aesthetic students, and I wouldn't interact with cosmetology students because I'm already a cosmetology student myself. So I don't need to learn the aesthetics while being in school. I would just be teaching them on different days where times wouldn't be overlapping.
So why would you need to be another student when you already have a cosmetology license?
No, I'm in school to be a cosmetologist, but I'm already a licensed esthetician.
So let me recap, because I'm also getting a little confused. So you're currently an esthetician wanting to get your education to be an instructor for esthetician services, and you're also wanting to at the same time go to school to have a full cosmetology license?
Correct. Yes, I'm already I am enrolled already in a cosmetology course.
Okay, because I think some of the verbiage on what we're seeing on your thing right here that's shared on the screen is saying that at the same period as being a hair design instructor. So I think that's what's throwing us off, because this is saying one thing and then your petition that's uploaded to our PACS is not saying that. So I think we have conflicting information on that's reflecting on two different areas. So I just wanted to gain that clarification. I think it's rather ambitious, and I mean, I would worry about you burning yourself out, but if that's the case, I mean, I don't really see grounds for not allowing it or anything that would impede our ability to grant it, other than, you know, obviously the sentiment of the board. But if that's the case, that I think that clarifies it much better.
Yeah, sorry. Yeah.
Yeah, Gwen Bramo, board member, I think I have an issue with it. I have a concern as well, because your cosmetology student, a cosmetology student becoming a PIL will work with the cosmetology students that do aesthetics. So it's almost like a double dip. It's almost like when you are a PIL and you're a PIL for aesthetics, you will definitely at one point rotate or somehow work with those cosmetology students that you're a student with. Just tell me, am I correct, Adam?
No. Oh, sorry.
I'm sorry. Madam President, for the record, Adam Higginbotham, Deputy Executive Director. The dialogue that you are having right now as the board is the same thing that the board staff had whenever the request came through. Whenever the request came through, I grabbed the Master Educator's Milady textbook and I started looking at it. And it was very clear on how important it is for the instructor and student relationship to be developed throughout the program. The textbook really covers that. And the staff, and it was ultimately the board staff, thought it is an unusual circumstance to be both an authority in a room and transition over to another hour, and now you're not the authority, you're the recipient from the authority. And I can see where that is very confusing, especially for some students that are going through financial aid and paying a substantial amount of money to attend school. I can definitely see where the confusion would lie with them attending a program with a school and then walking out of that hallway into another room, and now that person's an instructor over them or teaching a course. And staff thought it was the best determination to let the board have that dialogue and make that justification on how to proceed further, because we have a textbook that says about the importance of the layered relationship between instructor and student, and it didn't seem like this case fit that dialogue that was created in that book.
Thank you, Adam, for your sentiments. I just being an educator and a master educator for my lady, there has to be a separation. It has to be a separation from an educator and a separation from a student. And I'm not quite sure how that could even be possible, because as a cosmetology student and being a esthetician PIL, somehow though there's going to interact, because the cosmetology license is cosmetology. It's hair, it's nails, and it's skin. So how do you be a student and then you clock out and then you an instructor?
So if I may, it was I would only be instructing, or over with my PIL, I would only be doing that with students that are enrolled in the esthetician course. The cosmetologists have their own instructors for aesthetics. I would just be with students enrolled in the esthetician course, where there would be no overlapping with the cosmetology students.
So, hey, not too much kiddo. You doing okay?
Brian Baltazar.
I understand the direction, but
Okay, cool.
Madam President, this is Kai Stanton. I would like to just make a brief point of view. As a license holder myself in both, me taking the information for.
Kai, you're muted.
I think we muted you by accident. I'm sorry. We were
Oh,
trying to
that's okay.
figure that feedback for you and I ended up muting you. Sorry.
I think that's amazing. We can do that. I know we can do that. Overall, I'm concerned. I'm going to be honest with you. I don't think that's a good idea, none whatsoever. That compromises a certain level of leadership. It also compromises the delivery and the education that we give. It's actually contradicting. There's a lot of problems with that, especially as a PIL, you're still learning. So you're almost a student twice. So it's when you're learning and you need to focus and really take a look at all of the curriculum development, how to obtain certain solutions with different backgrounds and different emotional states that you're dealing with, especially right now. We have a lot that we have to focus on, especially as educators. There's a certain standard that is required, more so than anyone. And we don't want to blur those lines. But this is almost like a gift, if you will, to make sure that you're able to focus and become successful in one program and then taking on the other. That ensures that you are absorbing the information successfully and you can actually give quality education and quality delivery without feeling overwhelmed. And once you really dive into the education that you have, which, you know, I'm hopefully I'm, you know, that you are receiving excellent education regarding the focus of being an educator, you can really dive into that curriculum and what it's really focusing on. And because you're willing to do that, I think you'll understand our stance and my stance anyway, to having to say that, however, as board member Baltazar had highlighted, that is extremely ambitious, and sometimes it's nice for someone on the outside looking in to say, that is amazing, you can accomplish it, but this might be a better way to do so. Thank you.
Thank
This
you.
board member Douglas, I have a comment to make. I solely agree with board member Kai. I'm sorry, Kai.
Okay.
I think the only way this would work if you would enroll in another school, not the same school, trying to teach the same students. That's just my comment.
Brian Baltazar, and that's actually what I would completely agree with board member Douglas. I initially thought that you were attending two different institutions, but I would have to agree with her. I think that would uncomplicate a rather complicated relationship.
Any other board members have any other comment before I call for a motion? I would like to call for a motion, please.
This is board member Kai Stanton. I would like to deny the petition for license A-47662.
Can I get a second?
It's board member Douglas. I would second that motion.
All in favor?
Aye.
Aye.
Any opposed? Motion carries. Thank you, Mr. Castillo.
Thank you. Have a good one.
Okay, thank you. We have 4 more to go before we get down to the executive director stuff. You guys want to do a 10-minute break and come back, or keep moving? I'm ready.
I'm ready too.
10 more to go. Then we have,
We don't have 10 more to go.
yes, we do.
President Brimo, I think we're on number 13 and there's 22 listed on the agenda.
I would say you may want to take a short break for a lunch break. Come back, finish all the 30 minutes for lunch break if you want, and then we can finish all.
Okay, we can do a 30-minute lunch break. The time is 12:23. We'll be back at what? 12:53?
1 o'clock is good enough.
Okay, 1 o'clock.
All right, thank you.
See you guys at 1.
Hey Gwen, we're back. If you're back, you can start the meeting.
I'm back. I now would like to resume the Nevada State Board of Cosmetology's board meeting dated January 11th, 2021. The time is 1 p.m. Our next petitioner up will be petitioner number 13. Is it Paula Settler? Is there a Paula? Is it Settler or Steedler? Petitioner number license C1522. License C1522. Calling twice. Paula Steedler, license number C15221. Are you here today? Want to come back to this, Director Landry, or just go ahead and rule on it?
I'd go ahead and vote on it.
Okay, can I get a motion to withdraw petitioner number 13, please?
Board Member Harris, I make a motion to withdraw number 13.
Member Harris, do you mean by withdraw, deny?
Oh, deny it? Okay, I move to make a motion to deny petition Paula Stedler at C-15221.
Can I get a second?
It's Board Member Douglas. I second that motion.
All in favor?
Aye.
Any opposed? Motion carries. Thank you. Petition number 14 is Wendy Kolb. Petition license number C20412. Petitioner is asking for variance to separate restroom requirements for in-home salon. Is the petitioner, is it Colby available?
Yes, ma'am, I'm right here.
Okay, wonderful. Can you raise your right hand, please?
Yes, ma'am.
You swear to testify the truth and nothing but the truth in your testimony today?
Yes, sir.
Very good.
Okay, you have the floor to speak.
Hi, I live on a half an acre and it's horse property. So in Clark County, you can have an in-home studio in your home. It's home occupancy Title 30. So what I would like to ask, if I can go through the cosmetology board to move my studio here in my home. I started renovation, but I want to do everything legal. I've owned my own studio for 25 years. I practiced in Nevada for 25 years.
Hey,
and,
bro, on my damn trophy system. What the fuck am I doing?
Hello?
Excuse me, I'm gonna have just 1 second for me, please. I want to make sure that everyone's on the call or in the meeting with us today. You mute your microphones until your time is called, please. Thank you. Go right ahead.
Thank you, ma'am. And so I do work at SOLA in Green Valley at the district, and I still am employed there. I have my own studio. But right now you can see this is in my home. What I would like to do is I have a door going to the front of my home and turning that into a door where you walk into. You can see here how I have a wash bowl right here, and then I have my dispensary sink right here. What I would like to do is make it the safest as possible for my clients, because as I've been doing hair for 30 years, my clients are getting older. And with their whole COVID, I just don't feel as comfortable bringing them into the salon as with other people there and assistants, and I'm scared for them. So I think for me, this is a better plan for them and for myself. What I would like and what I am going to do is in my home right here, put a Remy Halo which is right here. It goes through my air ducts. And also this is a ventilation system that will take out all the air in my room in 1 minute and clean it through the UV light, and which that will kill all COVID, MRSA, any infectious disease, and filtration through my home and into my studio. So it'll always be clean, fresh air. So I really think by doing that, it would really help me and my clients to have a better experience. So I would hope that you would give me the variance of letting me have my studio in my home.
Can I have Adam to speak, please?
Hi, Gwen, this is Leah Easter. I think I can speak on this one. I believe Wendy and I have communicated via email. I think, Wendy, correct me if I'm wrong, your petition is just for the restroom requirement. You have the separate space, your ventilation is fine. I think when we walked through, it was just that your restroom is somewhere in your home and not in a like casita setting or somewhere in that salon itself. Is that right?
Right, definitely. As you can see,
if the board, you're asking them just for clarity that they can use your home restroom, the clients, versus a separate set of restrooms.
yes, you can see my room right here, as I'm going to turn that room into the doorway. But my restroom is, if you just walk out, these are going to be sliding glass doors to separate the beauty salon from my home. But right behind me, you can see where my bathroom is, 4 feet away. I'm not married, I have no children. I have no animals, so besides horses in the backyard. So it's very clean. And I would hope that you would give me the variance that I wouldn't have to put a bathroom inside this studio, which I could do, and whatever would make you guys happy and make it comfortable and safe.
Thank you. I appreciate that. I have a question for you, Wendy.
Yes, ma'am.
Because I know once you get, because it looks really, really nice from what I could see. I think you're doing a great job. And there's going to be your own private suite versus having to lease from Solis anymore if you didn't want to.
Yes, ma'am.
The bathroom inside your suite would probably be the best investment for you, just to keep it separated and because it seems like to me there's a lot of in-home salons and services being done, and it's coming about at a rapid pace. Yes. So as a board and as a board member, I can speak for myself that we have to be able to make sure that public safety and health comes first, which you totally agree, because you have this really nice system that's going to be like maybe got cleaned in the air, or some kind of air system you have installed.
Yes, my boyfriend works for heating and air conditioning, so I've spent over $3,000 on filtration system for this room and for this home. He has reworked this room for the plumbing to put in the sink here and for the dispensary sink here. But as you can see in the studio, there's really not any room to put a bathroom, as you can walk 4 feet into my bathroom, which is right here, as you can see.
No, but it looks like that's the bathroom that's in your home.
Yes. If you do feel like because I really have no space for here, I can go ahead and put up a wall here with a door, if that would make it logical, instead of having to run plumbing all the way through the bottom, through the concrete, and separate another door here, if you would like.
Do you have enough space for that?
I don't have enough space for my bathroom inside the studio right here, because this was a bedroom, but I took all the closets out to put in the dispensary. And this right here is going to be a glass shelving. So I mean, it would cost a lot of money for me to put another bathroom in, and I've already put in for this room close to $10,000. So to put a bathroom in here, I would hope I wouldn't have to.
I get what you're saying, but I'm just trying to think to maybe try to figure out a way to help you, because I know that we have a lot of petitioners coming before us for servicing clients at home. That's my only issue.
May I ask though, in Clark County where I live, because I live in a cul-de-sac and it's all horse property, I'm not zoned. I am zoned to have a studio in my home without putting a door in and without having a bathroom. So that's why I kind of started this project, because of zoning, and I got 100% okay with zoning with Clark County that I already went through.
So you don't have to be licensed by the Nevada Board of Cosmetology, do you? See,
yes.
that's why I'm confused. Do Wendy still have to be licensed by the state board if Clark County's superseding, saying that she can do this without a restroom, and then we're saying she needs a restroom? It seems like Clark County, does it supersede what the board has to?
No, we still have our requirements, and she has to have a restroom. She doesn't have to have it in her salon if the board will grant a variance. That's the only thing you have to do, is you have to grant a variance to let her use the restroom that's 4 feet away from her salon. She can use that if the board grants it. If the board doesn't grant it, then she's got to put a toilet somewhere in that salon.
Are you in Clark County Incorporated, or are you in Clark County?
I'm in Clark County. What does incorporated mean?
You know, like in the areas where they're still incorporating, where you can like vote in the mayor's election and all that stuff for the city?
Oh, I'm not for sure. Where I live, it's all zoned horse properties. So we all live on acres of property. So I'm not really for sure.
Because I know we're going to be able to see a lot of this in Clark County. Because they're moving away from like the high rent that they're charging. I was just notified just yesterday or day before that people are trying to now do businesses out of their home, and they might be in Clark County. So we have to be able to make sure that we have to be able to grant the same for all mini suite salons that want to open up in their home.
Yes, but I feel like because I am already with the Title 30 saying that I can do it out of my home and not have a bathroom in this studio area, that I would hope that you would grant me.
Well, there's other board members. Let's see what they have to say. Just one vote.
Board Member Kai, if I may, Madam President.
Hi.
Madam President, is this up for discussion, or can I just make a statement accordingly, because this isn't actually directed to the petitioner? This is just a conversation out loud, and hopefully I can have the other board members have that conversation with me, or what their point of view of is. So is that okay if are we opening it up for that conversation?
Oh, it's for discussion before action, yes.
Okay. My concern with this is looking at the bigger picture overall. If we allow for one suite, and that is an absolutely beautiful suite, there will be some more of these coming forward. I would like to make sure that we're doing that equally across the board. With the high of COVID, which was stated by the petitioner, which also sanitation purposes, there's a couple of scares that happens especially when you don't have certain isolations, things of that nature. And then we don't want to have a regular practice of having the public coming through someone's private home. I think that's very important, and that we take a sobering look on the security level of that, as well as the safety level regarding kind of containing COVID, et cetera. It's a lot easier to isolate one spot in an area, maybe even on the outside of that area, versus a larger entity having to maneuver to one section to the other. I think that having a bathroom that's either on the outside of that facility, inside, connected, but completely separated from the house would be a safety choice, just like we have to have dispensary sinks. We have to have an area for, you know, just all kinds of certain entities equally across the board. So if we do that for one, I just would like to say we need to do that for all. And I don't foresee everyone having the same layout. So we have to keep that in mind as well too. Thank you, board member.
Can we hear from you, Maggie? I see you on the screen now.
Yes, you felt me, I'm sure, President Primo. There's a couple of things that this brings about, as Board Member Stanton said. You now have individuals going through somebody's house. There are two things that this would cause us to do if we granted this petition, as she said, to put a wall with a door into her private residence. Those are actually two variances, because one is that they have to have a restroom within the salon. The other is that it has to be permanently sealed off from the rest of the house. So you would be granting a variance that not only says you don't need to have a bathroom within the salon, but you can have access to the rest of the house through that salon. It's clear that it says the only entrance and exit needs to be into the salon, not through the house. Then you have the added concern, and from my point of view, is when an inspector goes in to inspect, they have to go into the private area of that person's home to inspect the bathroom, because that's part of the inspection process. So you also have that kind of wrinkle or complication where our inspectors are now inside a private residence. I think it is a dangerous precedent to say both of those things are okay to do. And I would really caution the board, as you said, we're seeing a lot of inquiries about this, and that's usually where it stops. If they don't have a private restroom and inside the salon, if they're doing it in the middle of their house as opposed to separated, those are all viable concerns that the board should have moving forward. Thank you.
Thank you, Maggie.
This is Board Member Stanton, Madam President, if I may. I am so happy that Ms. Maggie highlighted that. That was, I apologize for not highlighting that to the utmost, what I mean by the safety overall. And inspectors are absolutely wonderful, and they want to make sure that things are done appropriately, but we need to also make sure that we're protecting them, and we need to make sure that they feel safe as well. And so thank you once again for bringing that to the forefront. That is a very huge high concern.
May I say something? Not to interrupt.
Yes.
I don't mean to sound rude, but I'm trying to do the best I can for my clients. So when I work at SOLA and there's 50 to 100 stylists working in a day, we have 2 bathrooms. So you're talking maybe like 200 people, 300 people using 2 bathrooms. I can't see why. I'm trying to put a filtration system in, a UV light. I'm asking of anything to do. I'm putting in a front door so they don't have to come through my house to go to the studio. The only thing is 4 feet away is my bathroom, where I can put sliders where they don't have to enter my living room and to my kitchen. I just want the safest most for my clients who are in their 70s and 80s. And I already have my clientele. I have maybe 50 people. So it's not like I'm open up to the public. I'm not. I just want a simple life and to do some money to pay my mortgage, and that's all, and keep everyone safe. So it's not like I'm going to be double booking. It's not like I will not have another person in here working. And I'm going with Title 30 with Clark County, saying that I am legal to do it here with the 1 studio, 1 person. I have parking. I'm going to have the access of the front door. Is there anything I can do that would make it better, where I wouldn't have to put a bathroom in here to get legal? Because I know of so many people doing it illegal, and I'm trying my hardest to do it as legal and to go through and keep my license.
And Wendy, we do respect that. I certainly do respect your honesty, but as a board member, we have had just numbers of people coming before us, and the compliance department is full. People are just moving away from their salons. can't afford to rent anymore and they're practicing at home. So if we grant, we have to be very, very careful as a board to grant for one, because then now we're up for the next practitioner to come and use your case. And what they'll do is they'll use your case. And we have no options but to grant, or we're going to create this havoc. So if there's a way that maybe you can look into the bathroom, stepping like right outside, if you can't do it right inside, because inside that 4 feet away is your private residence. That's your home, your bathroom, your guest, your family, and our state board inspectors have to go in there.
Okay, so if I put this bathroom by my front door, where the door is gonna be, where it's handicap accessible, if I put this bathroom right here before you walk in, would that be legal for me?
So what you can do is, it sounds like, and I'm not in compliance, but Maggie and Leah are both on the line here. They're both here today in the meeting. They could talk to the side of the board and help you get it figured out where it's not inside your private residence.
Okay.
Hello, excuse me.
Yes.
I would like to make a comment. This is Board Member Harris. So I do understand what you're saying about your door. You're gonna have a door. Now that part where the bathroom, is that your private, that's a half bathroom the guests use in your home, or do you use it every day?
I have a master bathroom in my bedroom.
Okay.
So
no, you don't have to use that bathroom. It's downstairs.
no, that bathroom is solely for the studio.
Now, would you be willing to put up a permanent wall to shut off your home, that kitchen that we just saw in your actual home, there in front of that other door, to block it off?
Absolutely.
I think that's what we need, is to put up a permanent wall where no one can come in or out. And then you too will have to go outside to enter your salon that you're sitting in. With that door, that window you're gonna turn into a door, right? Correct?
Well,
we're not going to go into details really, because it's not our position. If you could at this time, Wendy, you have the best compliance people right on the call with you that can help walk you through what will be acceptable and not. We don't know because we can see it looks beautiful from here, but I don't know which direction you're talking about coming and out. I don't think we can see that part. So you would have to, because they have to be the one that approves the license. Okay. So Leah has stated before that she had been working with you and this is what's needed. Maggie is super in her position, knowing what's needed and what's not needed, because we would have to grant not just one variance, Maggie said, we would have to grant 2. And we weren't prepared to grant 2. I wasn't prepared to grant 2 because I was under the impression that your suite had a bathroom that was separate from your home. I didn't know until I really went into detail with my notes that the restroom is a part of your living quarters.
Well, I do have 3 bathrooms here. So that is just my half hallway bathroom, which is just like, if I would take this wall out, it would all be connected. It would just be like right here.
But you're fortunate to be able to do that. A lot of people wouldn't be fortunate to be able to do that. And then we would be faced with, it's not our position. Our position is they also put in our package today that every board member has the law and what the law reads. So once the board members really read what that law reads, there's nothing really that we could do about it but work with compliance to get into compliance for the license that you need.
I understand. So how do I go about that? Do I make an appointment with?
Yeah, Wendy, this is Leah Easter. You have my email address and my phone number. Maybe sometime tomorrow, shoot me an email or I'll send you one if you don't hear from me. We can see if maybe one of the inspectors at some point can either kind of get a video call with you or come out or whatever everybody's comfortable with and see what options you have. Because it seems like you've got walls that might be able to be moved. You could add a bathroom. So there might be some options and you can go with whatever's most economical. And that way you don't need a variance at all. You would just meet the requirements. So we can get someone to actually come out and see it, hopefully.
Okay, that would be great. So in the meantime, just stay working at SOLA until I get my variance here, correct? Or not get a variance, or just.
Yeah, until you can meet the requirements, I guess, is probably what's gonna happen. You wouldn't need a variance at all if you can work out the wall.
Okay.
Okay.
I do appreciate you all. Thank
So
you so much.
do you understand, Wendy, what the board is saying to you? That we would have to grant 2 variances. We would have to grant 2.
I do understand that, but I just feel with my circumstances where I live within Clark County with the Title 30, I feel like being part of that, I think you can allow some variances, especially from the filtration system and the air duct system that I'm putting in, to give some more leeway for me, even with the bathroom being 4 feet away. That's all I was asking.
I think there's some modifications. It seems like after Maggie was speaking that you should be able to, Leah was speaking that you should be able to, and it's a blessing that you're able to even do that.
Yes, it's a blessing for sure.
Yeah, it is.
Mhm.
Okay.
Well, thank you so much.
Okay, so I need a motion from the board member, please.
This is board member Douglas. We're going to deny Wendy's petition at the moment until further notice.
Can I get a second? We can't hear you, board member Stanton.
Can you hear me now?
Yeah, a little bit.
Oh, that's weird.
Okay, we can hear you.
Okay. This is Kai Stanton. I would like to second that motion.
All in favor?
Aye.
Any opposed? Motion carries. Okay, thank you, Wendy, and the board office will be in touch.
Thank you so much.
Okay, bye-bye. The next petitioner is Kylie Miranda, license number ST 101413. Petitioner is disputing the inspection report findings.
Hi, I'm here.
Okay, can you raise your hand to be sworn in, please?
Yes.
Do you swear that the testimony you're going to give today is the truth and nothing but the truth?
Yes.
Very good.
I'm actually not 100% sure. I remember coming to our last Zoom meeting I had for the petition of my fines, but I'm not sure exactly what this petition today is for, and I wanted to be just clear on that.
Ms. Miranda, this is Leah Easter, Chief Compliance Officer. You submitted the petition to appear before the board. So it would be your role to tell us why you're here today.
Okay, I was denied last time when I did petition, and I received a new letter in the mail for today's date. So I just was appearing to just be safe.
President Bramo, there were two.
Okay, go right
petitions.
ahead. Go right ahead, Ms. Adams.
Sorry to interrupt, but there were 2 petitions. One was submitted April 15th and another one was submitted September 15th.
So I think it was just, I don't know. I think I submitted it because I wasn't getting reached out to, and I think I maybe did it to just be safe. But I did have a meeting a few months ago and my petition was denied. So I thought that this one was another hearing. I just wasn't sure.
Okay, so is this regarding the same petition, Maggie? Is this something new?
Well, interestingly you say that. If I can share screens, there is basically something new.
Okay.
Hold on one moment. Okay, thank you for your patience. So we did commit cease and desist. We sent a cease and desist on March 12th of 2020. On April 15th, there was a new Lash page presented, a new business page presented prior to the April 15th petition. So this website is actually currently still up. This Instagram page is currently still operating. It says clients, tips, mega in volume. So as of January 5th, not only is this website, her new website, still up and active, but it does say Lash training coming soon. So I think we have an issue here.
So that Lash page has been up. It was in the last, we talked about it in the last meeting. Haven't posted anything on it. I was told to not advertise until I was done with school. So I have taken that advice and I don't post on it. My post number hasn't even gone up. My Lash training is coming soon. I finished school in February and I feel like I'm not doing anything wrong in that sense as to advertising that I will be doing something when I have the license and I'm holding it. So nothing has been posted. I haven't taken clients since months ago, even before the meeting, because I'm not supposed to.
I thought, I didn't remember the last slide showing Lash training coming soon.
Yeah, no, because I didn't have it in there. I recently posted it in there because I'm graduating soon. I graduate in less than 6
So
weeks.
So effectively, you're still advertising without a license.
Right.
Am I not allowed to advertise for clientele or for future? I have so many people who I'm in classes with that have pages as well, and they advertise and they post things as well.
We're coming for them too.
Okay,
Yeah,
well,
they're not permitted to do that either.
okay, well, I didn't know that putting in that Lash training is coming soon is a problem because it's just, that's what I plan to do when I can, when I have my license. And those pictures are old.
And I understand that, but you're still saying classic mixed volume and mega. This is still an active page. It has not been taken down.
Where's my phone?
What was the fine last time for Kylie? Didn't we didn't we propose?
Yeah, it looks like there's $2,000 outstanding on this account that was upheld at the meeting on September 28th of 2020, or at least uploaded on that date.
March.
I'm sorry, March.
So on September, if that was March, on September, there's another petition.
So do I have, I got a paper, I believe, or after that meeting, that petition on September 15th, they told me that I was only being fined for $1,000. So I know that the fines are for practicing without a license and then one for running a business. So I continuously get emails from State Board and it only says 1,000. I have the 2,000 one. So I was under the impression that the business one had been dropped.
No.
Or that I didn't have to pay that one. I have only been getting emails for the 1,000 balance left.
Well, I'm even more confused, board staff. I think we have a bigger issue here besides the $2,000 fine. I think we have the issue, it appears to me, that we have the issue of a practitioner that's still in school, that's still performing services and advertising services online.
I do not perform services at all. Or advertise.
But you're still marketing for services online.
I made a post on Instagram since September 3rd, 2020.
After the board had already, after you had came before the board and the board upheld the decision of the fine, you advertised months later again. Am I correct or I'm wrong? I'm confused here now. Because you're saying you're not advertising for services when I remember the information from last time that you're not only are you advertising for services, you're promoting a Lash class that's coming soon.
I am sorry, I didn't understand or didn't realize that putting flash training coming soon was advertising that I'm taking clients right now. That is something that I want to do when I graduate and can actually do that and meet the requirements of doing that. I really didn't think that me putting that in my bio was
But in your bio, Kylie, it's fine, but
That's
you're
what-
advertising it to the public.
I'm really confused. That's
You know,
where
like
that,
if your personal bio, you know, like when you're creating a resume or a bio, that's your personal bio talking about the experience and the things that you hope to possibly gain in the future, which is fine. But what the compliance manager is, the compliance specialist is saying that you're advertising that you're still posting when the board asks you not to post for services or clients.
I have not posted a single photo on any of my social media platforms, anything at all, ever since they told me that advertising while I'm still in school needs to wait. I have
Maggie,
not.
can you show us the screen one more time so we can go ahead and move forward on this one?
My last post is from September 3rd, and that was before the last petition or the last meeting we had.
Oh, it was before the meeting.
Yes, I have not posted anything at all.
I thought it was after the meeting, Maggie.
No, last petition meeting. Those pictures were shown last time on September, the last time we had that one. Those are the same photos.
Okay.
I thought there were two Instagram pages that we're looking at. One that's private
That was my
now.
real one, and then my Lash page.
Madam President, this is Kai Stanton, if I may.
Yes.
Ms. Kylie, I'm hoping that maybe I can help with just slight clarification and the definition of clients. When we say clients or things are coming, especially when lash training is happening, that should be happening after you received your esthetician license and in a establishment, which you should be pretty familiar with the Nevada law book. Do you have a law book, Kylie?
I have a law book.
You do?
Mm-hmm.
Oh, awesome. Okay. So you should be pretty familiar with those laws, especially when you're attending education. And those laws are very, very clear regarding any services, especially utilizing certain words, which can be misleading to the public. And when that is brought to your attention, go ahead and shut everything down so things don't look or appear strongly misleading. Even though you're saying training, there's still some level of, how should I say, information there that would lead me to believe you have maybe other services that are being offered or, you know, things of that nature. So we don't want to have a business coming soon when things have not been certified or you are not currently a working part of the profession within an establishment that has been approved by the agency, the board. And these are all for your safety. Number one, having people in your home, especially with the height of COVID, does not protect you or the public. Number two, while you're still learning, we want to make sure that you're learning in a healthy environment as well as a safe one. So the bottom line is we cannot utilize the terminology at all with clients. That means you are doing a service for payment. We cannot at all, under any circumstances, have even just a photo of our, this is our cover sheet of a service at that time. This is a time where you should be absorbing all that information so you can apply it successfully. So that's where it all lies. Bottom line is, there's no license here and there's no authorization under any circumstances. And things can be very misleading, such as these sites. So my stance is on this. We have to just be clear across the board, and this isn't clear is the bottom line. It looks very misleading altogether. Thank you, Madam President.
And if I may, the specific law that Board Member Stanton was referring to is NRS 6404A 900. it is unlawful for any person to engage in or attempt to engage in the practice of cosmetology or any branch thereof, whether for compensation or otherwise, unless the person is licensed or registered in accordance to the provisions of this chapter. So advertising is clearly, I think, the attempt to engage in. Also, the cease and desist order that was sent to her was sent not only to her in her name, but also to her last page. And then this other page came up. So.
Ask a quick question.
Kylie, Gwen Gramo, Kylie, can I say something to you? I think at this point, I'm not quite sure where the board wants to go with this, but I'm just going to give you a word of advice. How much longer you say you had to complete school?
Like 6 weeks.
Okay, anything that looks misleading on your site, it needs to come down. And
Okay.
it needs to come down like right away, like today. Okay, because you don't want to keep coming before the board, and the fines are just astronomical. And I know that you're a student, and it looks like to me you do some excellent work. You don't want to start off on the wrong track, okay? So I think everything, because you came before the board and we requested you to remove those things, and then you still continue. So that makes it kind of difficult for me to even just explain it so that we can all understand it, because it's hard to understand when you're consistently doing what the board asks you not to. So do we have any other board members or any other recommendation before we move on to a motion?
I'll say one more thing.
Yes, this is Board Member McCormick. Kylie, I have a few questions for you. What brand are you using to perform these services?
I'm sorry, what brand?
What brand? Yes.
I used to work at a lash salon, so I had, as a receptionist, so I had discounts to buy their lashes.
So what brand?
Live Bay, Sassy Lashes.
Okay, and they're selling their products to unlicensed professionals?
We've never asked anybody to prove their license to buy products.
Okay, because it's not, you do know that they're professional products, right? They're
I
professional.
understand that, but they're for practice, and I was in school learning that specifically, so I was using those tools to help me. I didn't have, what else, I mean, in that, what else would I use to
So
help
you
me?
use them for practice, Kylie? Is that, I didn't hear that part. You use them for practice only?
Well, yeah, I was practicing.
Okay, Kylie, so how do we go from you're just practicing to becoming a trainer?
I'm in school, I'm training in school. So once I have my license, I am then able to train people. So that's why I put coming soon. I didn't put a date, I didn't put a time or anything like that. It's coming soon. It's not even, I haven't even, you know, it's in the works. It hasn't even happened yet.
Right, but you're saying basically as soon as you graduate from training, you're ready to become a trainer based on live-based products.
I've been doing lashes for a long time, so I feel as if once I do take a training course and then I can teach people, yes.
Okay, so you're not licensed. You know that you need to be licensed. You're using professional products that you acquired as a receptionist from Live Bay Lashes, but you're not purchasing professional products under your license, which would be required. So you're just basically conducting unlicensed activity all around the board. Thank you.
Okay.
This is Board Member Douglas. Kylie, I think you need to be more humbling when you're speaking to the board. I mean, because we can make or break your career. So it seems like you have a little attitude, and I think that should be more humbling.
I'm so sorry if that's how it's coming off. I want to also give my side or ask questions as well. And I do really apologize if that's how it's coming off. I am just like, I'm sorry. But in school as an esthetician, I've been told by instructors to post things so that when we're done with school, we can have that clientele. So I think my question is, if I were to be posting and having a page, if I were to be tagging Euphoria in my post, is that okay? Like, is that an acceptable advertisement?
Okay, you have board members and you also have compliance manager explaining to you what needs to be done. And it's like you're being combative with them.
No.
They're
I'm
trying to explain to you, hey, you should go this route because it's gonna further your career. If you do decide, or if we do decide to let you get your license.
Okay.
This is Board Member McCormick. I'd like to know what options are available to us as this is Kylie's second offense. And I do recall this specifically being brought before the board in which we asked her to cease promoting these services. The fact this page is still up with a call for training is a great concern to me. I would like to know what options exist at this point.
Board Member McCormick, this is Leah Easter. So I think there was some confusion with Ms. Miranda's petition. So none of these citations are new. You've seen these all before. So what Maggie's pointing out is just that the language on that page is still up. But the 2 citations she had for working prior to being licensed are older. And we were under the impression that this petition was just for you all to reevaluate whether you wanted that $2,000 fine to stand. It seems like you all want that $2,000 fine to stand. And it seems like Ms. Miranda may have conceded to understanding she was in the wrong. So if everybody's in agreement, I think you could vote on having that $2,000 stand. And I think Ms. Miranda understands that she should be maybe a little bit more conscious of what's on her social media page. And hopefully 6 weeks from now, she'll be licensed and this won't be an issue for her anymore. But it's not a new citation, I guess is my point. I just want to make clear, this has all been seen before.
And I think that that's my point, Leah, is that we did see this before and we asked it to be corrected. And so she's gone this entire time still collecting data and information from people interested in taking a training from someone who has not graduated from school. So action should have been taken at the first meeting to make sure that this couldn't even be a, oh my goodness, I don't think I understood fully that I couldn't still solicit business and not be a professional, a licensed professional. So the motion would be then to uphold the $2,000 fine that exists for Ms. Miranda. Is that what I understand?
That's correct. If you thought this warranted some other disciplinary action, it would have to go through the AG's office, kind of like we talked about with that case order earlier. But you're right, you have the option of just upholding the 2,000, keeping an eye on it, making sure everything gets better, or if you thought it was so egregious that it needs to be a complaint before Justin, then you could make that motion as well.
Can I say something, please? I'm sorry, Gwen. Bremo, I wanted to be able to make sure that once the motion, I would like to see here in the motion and to be said to Kylie, because she's going to remove the information, that Maggie, if you periodically check that page for us and the information is still there, I would like for Kylie to come back before the board.
I would add the caveat that that page or any other business page associated with her, if that's possible.
I'm sorry, Maggie, can you repeat that, please?
I would like to include any new page that she couldn't add another, close this page down, for example, and then start up a whole new Lash page.
Okay, no new pages. No new pages, Kylie. Okay. All right, let's.
President Bremo, this is Justin. Sorry, I just wanted to clarify something for the record. The only thing that I would recommend the board having to vote on today is whether or not to uphold the fine. Or as far as directions to Ms. Adams regarding the oversight or just the continued looking as whether or not Ms. Miranda's still doing that on the website, I think you could just use that as a direction to Ms. Adams without a board vote, but the board vote should solely just be whether or not to uphold the violations at this time.
Okay, so I just want to be able to, before I call for a motion, I would like for Ms. Adams to make sure that there's no new pages created and that page is and has been modified. And if not, I would like to have the petitioner to come back before the board. Can I get a motion, please?
President Bremo, do you want it modified or removed?
We want it, it's up to you.
I would say removed because it's a business page.
Okay, we want it removed.
Thank you.
This is Board Member McCormick. I'd like to make a motion to uphold the fines of $2,000 associated with this case.
This is Kai Stanton. I second that motion.
All in favor?
Aye.
Any opposed? Motion carries. Thank you, Kylie. So we are now to petitioner number 16, Jada Newman, license number C51692. Hi, Jada, you're
Yes,
present
I'm
with
here.
us? Can I have you
Yes.
raise your hand, please? Your right hand?
Are you willing to testify that everything you say today is the truth and nothing but the truth?
Yes.
Very good.
Okay. So you're here today before the board. You want to talk about what you're here for?
Yeah, so basically, I had received a letter and I had 2 fines, and both of them were for $1,000. One was practicing in a location not licensed by the board, and the other one was operating a salon without a license. And first and foremost, I don't know exactly why I got it, because I have worked in the salon ever since I did get my license, besides COVID or whatever. But my only thing is that I know that sometimes I do make YouTube videos from home, me doing people's hair and stuff like that. So I assumed it was something like that. So I did proceed to pay the one basically doing hair in a place unauthorized by the state board, but I didn't know that that fine was incorrect. So I ended up paying $1,000 when I guess it should have been $500, but I wasn't notified until I petitioned for the state board. So I kind of thought that was unfair, because I feel like I wouldn't have known that I was over fine unless I did petition, because I did pay way back in August and it went through with no problem. So nobody told me after that until I did decide to petition. So I do disagree with operating a salon without a license, because I don't know where that came from.
Okay, Maggie, is there any clarity? Can you clarify
Yes.
any of the information for us, please?
Absolutely. I'm sharing the screen again. So there was an error in the citation, which was on occasion. The practicing in a location not authorized by the board should have been a $500 fine. It was corrected in the system. So she had 2 citations, one for operating a salon without a license, and then the other for practicing in a location not authorized by the board. She submitted a petition on September 20th of 2020, stating there is no actual proof of a violation. This is her personal page, where she says her page is Styles by Me at Styled by Jada, where she also posted her license. So if you go to the Styled by Jada page, this is her Instagram. She does talk about her YouTube page, and that she's the CEO of Jada the Stylist. Here she's speaking about how to book an appointment and stop me when you've had enough. Again, talking about how to book same day, not booking same day appointments. You can book through her site. August is fully booked. This is the apartment complex where she lives. You please take note of some of these images, as you will see them again. This is her posting about her new apartment. Here's a picture of her showing a client with her new cape still on, with her new hair. Here's another picture of a client having her hair done. Again, this is the picture of the apartment complex where she lives. You can clearly see that this is not a salon. Posted August 14th of 2020. Again, August 15th of 2020. Again, August 19th. This is taking a picture within a residential bathroom. here we see her couch, her living room, two different images for braids, and here in her living room.
Okay, but can I ask a question?
Sure, go right ahead.
So like, can we not travel and do hair? Because all of those are not in my house. And I thought like, if I'm not doing chemical services or anything like that, I thought I was allowed to travel and do hair because I do that.
You do not have a limited license, to my knowledge. You would not.
So
be
I
able
have to have a
do-
license to travel and do hair?
Yes, but again, you said that some of these are not in your house, but this is your house, correct?
Yeah, that's correct. But I'm not denying that fine. That's what I'm saying. I did
Okay.
pay that fine practicing in a
And
location.
you- But there's another citation for operating a salon without a license.
But
And if
that
you
I
are
don't
performing
understand how that's
services and-
operating a salon.
Because a salon is any establishment where cosmetology is performed. So if you're performing cosmetology in a space that's not a licensed establishment by the State Board of Cosmetology, you are operating a salon that is unlicensed.
So do you understand, Jada, that the second fine came in because you were servicing clients not up under a cosmetological establishment? In order to travel to do hair, you can go from salon to salon with a license. But if you're performing services, and the services that you're performing the services up on, but not up under the cosmetological establishment, then that is a fine.
Okay.
So what is the fine, Maggie? Is it a $500 fine, or is it the additional $1,000? I'm looking at what exactly is the
So this operating a salon without an establishment is $1,000 fine for the first offense, for just one offense, which is all we've cited this for. The operating a salon or operating at a location not authorized by the board is a $500 fine. And what we did when we received that $1,000 fine is we applied $500 to the operating at a location not authorized by the board for a licensee, and then another $500 to the operating a salon without a license.
So the balance due is $500.
Correct.
So Jada, do you need a payment arrangement for the $500? Do you understand why there's an additional $500?
I understand.
Okay, do you need payment arrangement?
No, I don't.
Okay. Can I get a motion, please?
Board member, Doris, I have a question for her.
Okay.
Jada,
Yes.
are you working in a salon at the moment?
Yes, I am.
Okay, thank you.
Any other questions? Go ahead, Board Member Stanton.
I would like to make a motion to deny the petition of Ms. Jada, license C-51692.
This is Board Member McCormick. I second that.
All in favor?
Aye.
Any opposed? Motion carries. Thank you. Okay. We are now at the okay, I'm confused here. Okay, we're at petitioner number 17. Is it Hannah Shali? from D Circus Hair Salon. Do we have petitioner H999 for D Circus Hair Salon here today? Can I get a motion to deny?
This board member Douglas, I'm gonna be denying Hannah 899 for D Circus Salon for his petition, sorry.
Can I get a second?
This is Kai Stanton. I second that motion.
All in favor?
Aye.
Any opposed? Motion carries. Thank you. Petitioner number 18 is it Wing Ningo? License number N41605 for Nail Tips Salon?
Yes.
Hi, can I have you sworn in, please?
Give today is the truth and nothing but the truth?
Hello?
Yes.
Yes, I'm here.
Do you swear that the testimony you're going to be giving today is the truth and nothing but the truth?
Yes.
Very good.
Go right ahead. You're welcome to speak.
Okay, so the reason why I'm here today because one time the inspection came to my salon, and at that time my my reception just walked out when he come in. So and the inspection asked me, "Oh, who is he?" And I say, "Oh, he my reception. He usually answer the phone and book appointment from my shop." And then the inspection don't say anything, and he just go around and check everything. And before he left, he just told me like, "Oh, I don't want to see any unlicensed working here." And I say, "Oh, okay, but there were no unlicensed working here." And then that's it. And then when a couple of days later, they just give me a fine for $1,000.
Do we have the inspector on the call?
Yes, we do.
Can we hear from the inspector, please?
Yes, I'm right here.
Okay,
This is
thank
David.
you,
This is
David.
David. Yeah, David Scarpelli. Do I need to be sworn in?
Yes, you do.
Yes.
Okay.
David, do you swear that the testimony you're going to give today is the truth and nothing but the truth?
Yes.
Very good.
Okay. I went there based on a complaint of an unlicensed male. So I went in already expecting, or at least looking for an unlicensed male. This unlicensed, or this male that was in there, the gentleman was in the back in the hair area. And I wanted to ask him questions, and he just went out the front door and left. And at that point in time, because I wasn't able to ask those questions, I issued that citation because, like I said, I was there on a complaint. I automatically just zoned in on him, who ended up leaving, and I wasn't able to get the answers that I needed to verify that he wasn't actually there working on the clients.
David, I have a question for you. Did you have a description of the unlicensed worker working? Were
Oh,
you
my
given a
goodness.
description on the call?
On the, you're talking about the complaint?
Yes, I'm sorry.
I don't remember if there was an actual description or not.
Let me take a look. Just give me one moment.
Okay.
Maggie, it looks like there was a citation issued here at least once before for unlicensed workers, but it looks like the complaint says an out-of-state individual working there. I don't think.
That was the second complaint that we went on. It was me and Michelle, I believe. We caught another individual later after this one.
On
It was a
November
different, it was a different guy. It was a different guy. So that's a different complaint. There was a complaint before that.
I see.
It was right after we came back from the COVID lockdown. I'm wanting to say May.
Okay.
Let me see.
So this is the second complaint for unlicensed activity?
Well, no, not the one. The one we're discussing today is the first complaint that we got back in May. But since then, we've been back recently, probably within the past month, or maybe late November. But we've been back recent enough to catch someone else working there, unlicensed, a different male.
Okay.
Since then. So there's been two complaints, but the one that we're talking about today is the first complaint.
Okay. Okay, do I have any other board members have any other question before I call for a motion? I would like to call for a motion, please.
Oh, hi, can I say something?
You sure can.
I have a witness here and she can explain better than what I can do. So can she say something about that?
She needs to be sworn in, but Executive Director Landry, do a witness need to speak on anything?
Yes, if they want to speak, they need to be sworn in, whoever they are.
Okay.
Okay, we can have her sworn in.
Do you swear the testimony you're going to give today is the truth and nothing but the truth?
Yes, sir. Yes.
Very good.
And just for the record, what is your name?
My name is Karina Vega.
Thank you.
Yes. I'm an employee here at Nail Tips, and the person that the state board, what's his name? I'm so sorry. I'm bad with names. As soon as he walked in, the person, it's a female. It's not a male. It's a she, but it happens to have short hair. And since we were busy, we ordered food that day. And when he came in, it was a coincidence that she walked out at the same time he walked in. And I was here, and he said that that they got a complaint that a guy was working here, but the person that walked out, it was a girl, and she's not working here. I can tell you that she helped us answer the phone and bring us food.
But I thought David, our inspector, just said that he made conversation with that person. You tried to make conversation with that person. Am I correct, David?
No. What happened was I entered in expecting or looking for this unlicensed individual. This person was there. They were an employee. They got up and left. I wasn't able to ask any questions at that point to that person, because normally when we go in, we start asking questions, and depending on what the answers are, determining if they're there working or not working. But because that person got up and left and I wasn't able to ask those questions, I put the, what's the word? I guess the benefit of the doubt on them to tell us at the office of what happened and who that person was and what they were doing there. So that's the reason I didn't. when I went in, I did not get to actually communicate with that person. They left
Okay.
as soon as I walked in. And
Okay.
from what I witnessed or saw, I did not see any services being performed by that person, but they were in the back in the hair area, which made me believe that they were back there performing those services.
Right. I thought the witness just said they were walking out the door.
They may have been walking out the door as I was coming in, and they were in the back. I introduced myself and they walked past me and left. So I mean, they might have been walking out the door, but I didn't even get a chance to even communicate or stop them. I mean, they just walked right by me and left.
This is, I work in this station, the very first one right here. And the person was in that chair over here. And then when we heard the door that it was open, I turned around, but Wayne was telling him to go pick up the food as soon as the person walked to this door. So it was a coincidence that she got up and they crossed and he left. Like, I know since the guy told us that they got a complaint that we have a person without a license working. I understand that it could have, it looked like that I mean that.
So you don't have unlicensed, you don't have unlicensed workers working in your establishment?
Not at that time. The time that after he came, it was a person, working here in the first station, and but since they were having problems with the I think the transfer or the
But they didn't
person
have a
told him-
license though, right? They didn't have a license?
No, he thought that he could work because he already applied with you guys.
Oh, okay.
So he misunderstood. And as soon as the guy came here, he told him to stop, and he stopped and left.
Okay.
The
other-
guy, the guy that she's talking about, the second guy is the second complaint that we got.
Yes,
right.
Yeah, it's
Exactly.
totally-
I'm following you, David.
Okay, all right, cool. All right.
Okay.
And if I may, the gentleman who was unlicensed may not have understood that he didn't have a license just because he applied for reciprocity. But the owner of the salon knows what they need to have a licensed person working there. And this is a constant thing. An inspector will walk into a place, announce themselves, people leave out the front door. Or out the back door. So.
Right. And they were sitting over in the chair, right? I thought they were in the back and then they were in the door, but now they were sitting in the chair. I'm confused.
As a receptionist at a busy time of day, to have them sitting in a chair just doesn't add up.
The reason why I wrote this up as a citation, it was because that, like I said, that 51% of just questioning them, I needed to have more proof. And that I could not get any answers from obviously the person that left.
Yeah.
But the only response I got was that was a receptionist. And I just wanted to have them give their side of things to our office staff.
I think they need to be a little bit more clear. I think also, Nell Tips, that you need to be a little bit more clear when speaking with the inspector, because as a board, and I'm a board member listening, I've heard multiple scenarios. I've heard a scenario that the person was walking out the door to go get the food. I heard another scenario that the person was sitting over in the chair. And then I heard that the person wasn't working there, but then the person was a receptionist.
He was a receptionist. I mean, she was a receptionist, but since we were busy and she was sitting next to me in the chair. So as the wind here told her to pick up the food, that it was time to pick it up. So she got up, and as soon as the cosmetology person came in, that's when they crossed. And he thought that maybe he was since she looks like a guy, maybe he thought that it was the person that they had a complaint.
Okay, I just have one,
Because
actually, I have two questions and then I'm just gonna let this go.
Okay.
So she or he is the receptionist, correct? Is that correct?
Neil
Yes.
Titz, can you answer that?
So she-
Yeah,
okay.
yes.
It was a busy day, is that correct? Actually, 4 questions.
Yes.
Okay, where is the phone located? Is it at that station or is it at the front desk?
The what?
The phone, the telephone.
Oh, the front desk.
And where is the booking? Where's your
yeah,
booking
I'm going to-
information? Is your booking information at the front desk?
Okay. It's usually the front desk, but we do something so it can connect to my phone and her phone. So
Okay.
whenever someone call, I don't have to go here. It connects to my phone and her phone. So he or me, whenever she not here, I can pick it up or she can pick it up by cell phone. We don't
Okay.
have to go over here to pick up the phone. Yes.
So my point is, the phone is there, the booking is there, and the credit card machine is at the front desk. And it's a busy day and she or he is sitting at the station. Board members, it's up to you what you wish to decide.
Madam President, this is Kai Stanton. I've listened and reviewed the case. I'm going to be very honest with you. Due to COVID, number one, we should be practicing the 6 feet distance rule, number one. Number two, when we are performing services, no one should be behind or around the technician just for safety purposes. Things can spill, accidents happen, etc. The reception area and restroom areas are separate for those safety factors and to make sure that all floor plans and everyone that is licensed is in the areas that they're supposed to be in. When an inspector is asking questions and you are a part of that company or you are a part of that studio or establishment, it is your requirement, it is your duty as well to have that communication with an inspector, stop, acknowledge as he or she is acknowledging you and answer the questions appropriately and then move forward with the day. When you go past someone that is trying to receive information about the establishment so that they can do their job properly, that is saying that you are not being complicit with the laws and regulations, just the fact that an inspector is being ignored and you are not communicating, that alone is a problem. When also you're telling me that you can answer the phone and other people can answer the phone accordingly, et cetera, and the receptionist is actually on the premises, that's another concern as well. They should not be, no one should be, and this is also law, hanging out in a salon that is not licensed. You should not be sitting in a licensed establishment with license posted behind you, because then that's also further misleading and saying that I am working here, this is my license, etc. So it's really up to the board accordingly, but my stance is I think that facts have been highlighted enough, and I leave it back to you, Madam President, for other board members if they have any concerns accordingly, but I think the facts highlight.
Is there any other board members have a question before I call for a motion? I would like to call for a motion, please.
This is Kai Stanton. I'd like to make a motion to deny the petition for nail tips. The number is S-187484.
This is Board Member Douglas. I will second that motion.
All in favor?
Aye.
Any opposed? Motion carries. Vice Chair Baltazar?
Yes.
Okay, I need you to take this next one for me. I just got to step away from the screen. Petition number 19. Can you do that one for me?
Absolutely.
Thank you.
Alrighty, so moving on to agenda item 19, Petitioner Saba, oh my goodness, I'm sorry, I can't pronounce. The petitioner is disputing the inspection report findings. Is Saba present?
It does not look like Saba is on the call.
Alrighty, so we can therefore move forward and decide on this petition, correct?
That's correct.
Member Balthazar, sorry, just for the record, because it's a unique name, just wanted to say TH-183 is the license number. So if anybody out there is for TH-183, this is your mailer.
Okay, so calling again, just before we move on, for TH-183 license holder. Alrighty, can we get a motion to, in this case, deny the petition since they're not here?
Yes, this.
Go ahead.
This is Kai Stanton, a board member. I would like to make a motion to deny the petition for TH-183 Saba.
Do we have a second?
This is Board Member Douglas. I second that.
All those in favor say aye.
Aye.
Any opposed? Motion passes. Moving on to agenda item G, a petitioner Maya Crawford.
Brian, it's number 20 on C, no, on F, number 20.
I don't have anything beyond 19 on board pack.
I don't see a 20 either in our pack.
Andrew said the numbering on board pack might be viewing differently. You're correct. It's Maya Crawford.
Oh, okay.
Yeah, so for members on the agenda that's posted, it's Mike Crawford's number 20, but board pack shows G as it, so it's the same person.
Okay. So
I'm
moving
here.
on to 20 or G, the petitioner is disputing the inspection report findings on violation 3135330 and 3135331. Is the petitioner here?
I'm here.
Do we have to have her sworn in before having a discussion?
Yes, we do.
All right.
Are you going to testify that all the things that you're going to say today are the truth and nothing but the truth?
Yes.
Very good.
Okay, so in regards to my first violation as advertising as a license esthetician, during this time I was in school, and one of our assignments was, it was actually when we had went on quarantine and we were doing online learning, and one of our assignments was that we had to act as if we were graduated. We had to have like a biography, like false, like a fake resume that we made. And so during that time, we were doing online schooling, and the software that a lot of us were using actually wasn't working. So our teacher actually gave us the permission to use Instagram, which was where I posted a lot of my work that I do in school, or that I was doing in school. And so I had put licensed esthetician in my biography, literally to submit it as my assignment. I think I had it in for like maybe a day or two. I think I had taken it out before I had even gotten like the notice in the mail and everything. As far as like the practicing without a license, I called and they explained it to me, and so I understand that fine and everything, which I'm okay with. I guess my question to the board is if I'm able to do some type of like a payment arrangement, as I'm not working right now, and I did recently just finish school, but I am still paying off my balance of school as I didn't qualify for aid. I've been paying out of pocket for my schooling.
Thank you. And so just to clarify, so your instructor, I find that problematic that your instructor would have you do something that, I mean, shouldn't they have better understanding of, that they're not permitted to do this?
Right. And as far as I know when I had called about asking as far as like the practicing without a license, and they had also mentioned lashes on my page, which I wasn't, fully aware of, like, I guess that we weren't allowed to practice, but that was another thing that was kind of confusing to me too, because one of my instructors in school actually lets us sit there and lash one another, and she would bring in supplies. And the picture of the lashes that I have on my page is actually of one of the students that I was in school with. So I feel like there's just like kind of like, like I'm getting fined for something, but then at the same time, my instructor is like kind of contradicting, I guess, the law of what we're supposed to be doing.
Let's go ahead and hear from Maggie Adams.
Okay, thank you. Thank you, Vice President Baltazar. I am going to share the screen. Give me one moment.
And before I do, I believe President Bremo is back, so I yield back.
No, I just got back. You can complete this one.
Okay.
Okay, so the petition was filed October 19th. She was cited for using advertisements which contain knowingly false or deceptive statements, as well as practicing without a license or certificate. She did state on her petition that it was a school project and that the lash extensions on her page were done on my classmate and sister, and neither were charged for it. One of the instructors taught us lashes in class and let us practice on one another. This is her personal page that says licensed esthetician. Again, this is her personal page, not her business page that was supposedly part of the project. On her business page, we see her say again, licensed esthetician, performing all of these services with clients, retail, and pricing. These are some of her clients listed on her page. Again, more clients. Here she's saying she's a Las Vegas lash artist. Again, more lashes being performed. This is her how to book the appointment. Her address, her individual information. Let me just finish. We'll go through it all, and then you can speak if that's okay. I reached out to G-Skin Beauty, which is where, in defense of the school, I'd like to say, I reached out to G-Skin Beauty and said, this is what was said on the petition. Is this the case? This from Audrey Jones, who's the campus director, said, we never encourage our students to advertise any services on social media without being licensed. Students are taught never to advertise such services until they are licensed. We do not offer eyelash extension services on our clinic floor. I also spoke and got the social media curriculum, basically, part of it as a request. They're taught individual lash tabs along with makeup, and they perform that on a mannequin. They have demonstration and workshop individual lash extension on mannequins. However, they do not have any lash extension requirements, and we do not allow any staff to demonstrate techniques on the live model. This is not a service we offer in our student services area. So this is what the school has, two people in the school, the campus director, but being one of them, stating this is what we teach. This is how we teach it. They would never be told to go live. And you can see on the part of the social media class that the teachers get, their student to create social media posts for digital portfolio. Reminder, nothing posted on social media live page. So yes, we can absolutely do a payment plan, but to say that the instructor, that the school is telling you to do this, I take issue.
Which that's another comment I wanted to make, actually, because when I was trying to file like my petition, I was trying to actually upload documents because I have actually photos of the teacher, yes, performing lashes inside the school on classmates and mannequins as well. So I mean, if I'm able to send that to you guys, but I do have proof, so that is actually not correct. And my teacher, which I can give him, her email, whatever, she actually, once I notified her that I was, I had the complaint filed against me and that I was getting fined, she actually told me she would be willing to reach out to you guys because Instagram, yes, that was how we were told to complete our project. because the software that they wanted us to use was not working for a lot of the girls as we were doing online learning. So she gave us, maybe the director of the school in particular didn't, but via my instructor who was teaching me, yes, that was what we were told to do.
Thank
So
you.
it's kinda like,
And
This
be
is
that
board
as it, I'm sorry, one more thing, be that as it may, even if you were taught classes in school, even if they did say to post, you are practicing. These are not students. These
I
are
know
not
that the one on the right, I can tell you that's a classmate. The other two are all family. These are all people that are close to me. It's not like I'm offering services to the public and via the booking link. That would, like, I have a paper of the specific project which we were supposed to use actually a booking link. So as far as services that were on that booking link, I'll admit, like, yes, that is stuff that I do plan on offering once I graduate, but during that time, no. And even if somebody was to book an appointment, I would have had to approve it, which I was taking clients through my school, and I tried to even upload the proof of the clients that I was taking through my school. But it was only giving me the option to upload literally one photo when I was trying to petition to appear in front of you guys.
Board
So
Member Bramo, I'm
Like
kind of,
that's my blood sister right there in that video.
right, Maya, I think that some of the issue here, this is Board Member Bramo, is that it looks like the service is being, when you created this, I can see creating a social media platform. That's what we want to teach our students. But I thought in the director's letter, it said that those created marketing tools were not to go live. So for this to, because you have a lot of followers. You have a lot of followers, and when you have a lot of followers and you're offering, the services, I'm sure that they probably reach out to you. I'm not quite sure how it's happening, but did we ever give the schools the guidelines for social media? Leah, has that ever been presented to all schools yet?
It is not, Gwen. I think there were some changes you wanted to make, which Maggie's been working on, and they're slated to go up in April. We didn't put them on this agenda just because it was already really big.
Okay. Okay, good, wonderful.
Am I able to submit that documentation because it's, you know what I mean? Like, as far as she, because I know the director is saying that that's not what it's taught, but again, I went to school at night, so the director wasn't there a lot during the night. So I feel like the instructors definitely did bend rules a lot because she wasn't there. So maybe it wasn't something that wasn't supposed to be taught, but we were definitely being taught, and it was definitely being taught live. And I'm pretty sure I have documentation of the instructor working on a student there with the massage table laid out and everything in her supplies. So
But instructors can do demos, and they can do demos if they want to go live with it because they're not advertising or marketing services. So I guess you could probably submit some additional documentation at another time, and they could always be reviewed by staff. But I think that's a director's, instructors kind of issue there. Maybe you can write a letter to the director and tell the director that the instructor gave you permission and give them that proper documentation. But I don't think, as far as staff and board, we can get into what the directors told the instructors and the instructors told the students, and that could just go a long ways. I think just advertising those services to the general public is against the regulation.
And these posts go back to March 10th of 2020. And the citation was issued August 25th, I believe.
Okay.
Do we have any other board members that have any comments or questions? If not, then can we get a motion?
It's feast or famine with motions today, guys. You guys are all at once or nobody at all.
I know it. We need a motion. I'll make the motion.
Okay.
I would like to make a motion to uphold Myers Crawford, license number ST 102125 petition. I would like to uphold the findings.
Do we have a second?
This is Kai Stanton. I second that motion.
All those in favor?
Aye.
Any opposed? Motion carries. Thank you, Ms. Crawford.
Thank you.
Alrighty, now I yield back to Madam President.
Okay, thank you. I appreciate you, Baltazar. We're gonna go now to petition number 1. Petitioner disputed inspection report findings. That's Alyssa Lepacolo, license number U102360. We have the petitioner here.
Yes, I'm here.
Okay, can you swear? Can you raise your right hand, please?
Yes.
Do you swear that the testimony you are going to give today is the truth and nothing but the truth?
I do.
Very good.
Okay.
So I'm just petitioning the fines because a while back did my own nails and decided that down the line that when I had the money, I wanted to go to school. And so over a period of time, I had just done my own nails and practiced on my mom. And I had worked up some photos, and I'm a part of lots of nail groups, and I saw lots of girls have photos. So I decided to make a Facebook page to post my photos. I never intended on it being like a services page. Upon making the page, it asked to put in what the page was and services. So I just put it in. The page was only up for 1 week. I think exactly, maybe a couple days over a week before I had gotten the fines. Nothing came from the page or anything like that. I didn't make any money. I was just practicing on friends and family, and the whole reason for the page was just to post to my friends on Facebook to just show them the nails that I've done, but I never made money from doing nails. I was just practicing from stuff bought at like Sally's and Walmart on my mom and my friends, my 2 friends only, over about a year. So I'm petitioning the citations because I'm unemployed. I don't have a way to pay that right now. And I took the Facebook page down immediately upon finding out because I didn't know that that wasn't allowed. So I took it down immediately. I haven't even practiced on my own nails anymore. I was just unaware, and I haven't done anything since.
Shall I?
Yes, please, Maggie.
Okay.
Help us out.
All right. Okay. Hold on a moment. It seems to be taking a little bit. Okay. Thank you. Thank you for your patience. Yes, the citation was issued October 7th, 2020. She was issued a citation for practicing without a license or certificate and operating a salon without a license. She was, as part of the citation, we send a cease and desist demanding that she and her web pages stop conducting unlicensed activity. Her petition stated that she is, again, practicing on her own for fun, did create a Facebook page. It was only up for a week and a half. And all my practice has been done for free. I do not have a salon. I'm not acting as a salon owner. The people I've practiced on has been in my home. Her Instagram page is Alyssa Nailed It, where she says home-based, self-taught and learning, accepting clients. Feel free to ask about pricing.
Yeah, and that was created.
Petition was filed.
Sorry.
The cease and desist was issued October 7th. The petition was filed on October 8th. This was printed this January 7th. It's still up.
Yeah, but I haven't been on the page. I haven't done anything. I don't even go on the Instagram page anymore. It's changed. That doesn't say that anymore.
You're right. When I looked on Friday, this picture was here. It was dated, I believe, November 30th.
Yeah, and it was a photo I had previously already had. It's my mom's nails. I had already had it on the phone, and so I just finished posting the photos that I had. That's my mom.
May I continue?
Yeah.
When I checked this morning, as I do prior to the board meetings, it was still up. It came down during this meeting. The citation and cease and desist was issued October 7th, as I said. Again, she filed October 8th. Her Venmo has payments made to her on October 9th and October 20 of 2020 for nails.
I didn't
So,
charge
I mean,
those.
you've had enough for it. This is her, where she says she's a nail tech in training, and this is her Instagram or her Facebook and Instagram information, advertising as a nail tech. She's saying here where her nail account is. This is where she provides her text and her email and her phone number for clients. It's all publicly available. These are the photos that she posts. Each one of these is a separate day or a separate post on her Instagram. This is where she has her scheduling page where she says she's home based. All appointment types are scheduled at a starting price and include solid colors. Clients more than 10 minutes late may have to be rescheduled.
And that was a part of the Facebook page, this.
This is, again, her business page is posted. We have posted October 6th. Instagram business page, first extra large set. These are individual posts where she posts September 18th, September 2nd, purple nails from the other day, March 19th of 2020, December 28th. How you can book. I'm a self-taught nail tech. Would love to do a set on you to increase my skills. You can book me through this link. Clearly, this is not for friends and family because they would already have her information, her contact information.
Yes, and that was created from the Facebook page after I created that. And
Again, she's providing her phone number and her booking page on a public site advertising for nails.
Yes.
This is her schedule of services where you can request, where you can schedule online what you want. More postings of the nails that she's doing. This is our law. Again, it is unlawful for any person to engage in or attempt to engage in the practice of cosmetology or any branch thereof, whether for compensation or otherwise, unless the person is licensed.
I know, and I understand that. And all the photos that were posted were free and weren't charged for it. And I wasn't aware that, I understand now that I shouldn't have been posting, even all those sets were free. Half of those are my mom's, half of them are my own nails. And I understand now that, yeah, I shouldn't have been posted it. I shouldn't have created that after I created the Facebook page that asked for the services for what the page was. I understand now that, yeah, I shouldn't have done that. And that's my mom, like, that's me. And so a lot of them, that's my mom, were created over, or were done over like 2 years. Every few months, I just did my mom's nails for fun, and I did mine every
Issa, are you attending school right now?
No, I wanted to attend school and I had money to. I tried to, but I couldn't afford it. So I had to wait until I was going to try this year when I'm not a dependent anymore.
Well, that's good. Okay. I just think the biggest problem I have with it is it was multiple postings, and I think that the issue is that you had a price page and you were booking. Clients could book through you, so we don't know if they were booking through you or not.
I understand that, and I realize I should have used that Facebook page, which was
when you start asking clients for money and said I'm self-taught, you do. I want to say you do good work. You really should think about seriously attending school, getting a license so that you can make a decent living at this, but you can't do it without one. Yeah. And that's a big problem in our industry right now is this booking without a license and posting without a license. The board has to take some type of a control of this. Yeah. So I do understand. I think we all do. We're licensees, except one's a public member and he looks out for the public as well. Yeah. Thank you, Maggie. If I don't have any other comments from any other board members, can I get a motion, please?
This is Board Member Kai Stanton. I'd like to make a motion to deny the petition and uphold the citation as well as all the fines to case U-102360.
Can I get a second?
Board Member Douglas, I second that motion.
All in favor?
Aye.
Any opposed? Motion carries. Thank you.
I have a question.
Yes.
How do I go from here? Since I'm unemployed, and how do I go about the payments, and what do I do from here?
We have our compliance manager there. She can tell you. Can you speak to her, Miss Leah?
Or hi, Alyssa, someone will reach out to you and they'll give you some payment arrangement options and you can go with what works best for you then. And you'll get a letter in the mail and you'll probably get an email as well.
Oh, okay.
Okay.
Okay, thank you. Make sure you take those posts down.
I did. The Facebook page is deleted the day after I got the fine,
Okay.
and I'll take
Thank
the-
you. Okay. Petitioner number 2 is disputing the inspection report finding. Is it Hugh Nugent from Aqua Nails Salon 10944, license number N11714.
Hello? Yes.
Hi, can I have you sworn in, please?
Yes.
You swear that everything you testified today is the truth and nothing but the truth?
Yes, sir.
Very good.
Okay, go right ahead.
Okay, go right ahead.
Oh, yes. Hi, I'm Huynh, fiance. My name is Chucky.
Oh, excuse me, sir. Excuse me. We need to have you sworn in as well.
Okay.
Yes.
No
Okay, and
problem.
then
yes.
Can you say your name and then we're gonna have you sworn in.
My name
Yes, my name is
Chucky Hong, and I operate the salon with Huynh. She's my fiance. She's the owner. At the moment, she's with the client right now. Is there any I can take
Oh
over?
no, she needs if she's taking care of a client, the person
Yes.
that's petitioning the board.
Mhm.
She needs, if she's there, she can speak with us. We don't need you to speak for her while she's taking care of a client.
Oh, no. We can, she's here. We're speaking with me.
No, I'm here with him, so I can
Let's go in the back.
go in the back. Okay. Hold on. Holly, give me 10 minutes, okay? Thank you. Thanh lên lấy tiền giùm Thanh. Yes, I'm ready.
Okay, so you've been sworn in. If your fiance wants to speak, we're gonna need to swear him in as well, okay?
Yes.
Okay. So can you fiance, can you speak your name and be sworn in, please?
Chucky Hong.
You swear that the testimony you're going to give today is the truth and nothing but the truth?
I do.
Okay, now you can go ahead.
Okay, sorry. Yeah. Okay, so I'm the one that mainly run this salon, from greeting the clients, open, close, and all that. Huynh is the owner. We're usually we book all day. That week I got sick. I got cold, and Huynh here, we just hired that girl Linda in, and because when they call, they walk in to ask for a job, and I was sick, and she here was very busy with her clients. She wouldn't have times to answer phones and all that. So at the time, we needed somebody to answer phones and clean up, because we have a person, usually I'm the one that does all that, but I was off that week. So unfortunately that she's have to hire somebody, and I don't know, because she was interviewing that girl and saying that she can come in here to do phone and stuff like that. But that's the first time they were talking, and she said that, oh, I can also do nails too, but I'm not good. This is what my fiance told me. And then afterwards, my fiance called me and said, hey, she can do nails too. I said, no, we don't know that yet. If she says she's licensed, then have to put it up there. we're comfortable, but let her do her job right now and stuff like that. So basically, she never hand on or touch any of our clients because our clients is difficult clients here. That's why we maintain our salon very clean and very modern, very update. We even all through the services too. So anyhow, it's only here just for like 3 days and like couple hours. But as far as what that day, I think the inspector came in. I was at home sick, and I looked through my camera and I saw the inspector come in. Okay. And stuff like that. And I, you know, and when my fiance called me and said, hey, the inspector came in and stuff, she was working. My fiance was working with a client. And for whatever it is, the inspector talked to that girl in the back. She was doing cleaning. She was cleaning at the sink in the back, which is right
she
here
does
or
something
something.
in the back.
Because
I
what
know.
we hire for is she's very friendly, talking, like, you know, with greeting customer like that. That's what we need. And cleaning. So the point is the inspector came in and talked to her before even talking to my fiance or anything like that. And then when they done talking, what Nguyen told me is inspector came into the wax room and saying that, do you know that girl, she cannot touch the clientele. It's gonna be working here. She cannot touch the clientele. It's a phone.
On the phone, what do you mean the phone? We talk directly face to face.
Yeah.
And he says she cannot touch the clients. He said no, she didn't.
Yeah. So basically that our point is we did not know that girl. She was just working for a couple of days. And whatever the fine we got fined is like, I think it's $2,500. I don't have the paper handy here. So anyhow,
right here, the paper right
yes.
here.
Yes.
25.
What happened to the screen?
Did you hear me?
Hello?
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 Yes, we can hear you.
Oh, okay.
Yeah, we can hear you.
Okay.
But
So
I
anyway,
think we.
okay.
Look how she looked.
Yes.
We have a copy of that information.
Okay. So here's the point. Well, I'm going back to that day. I'm going back to October. We hired her just for that week to fill me in. But then after that day, left without reason. She said not work. And then she said she asked us to pay her. We wrote her a check for $117 and it was never cashed in. That check. On October. See? We wrote her a check and she was never cashed it. So ever since on, we can't, you know, and stuff like that. And so that's why we don't know where and what this girl is. This happened right after that day. So then again, Inspector David did came by again.
Just a couple of days ago.
2-3 days ago. And I believe to check to see if that girl is still or whatever. But it's not here. And I don't think it's fair because before COVID, we have 10 technicians that work for us. But after COVID, 6 of them left. We only have 4. Her and I here, we're very busy. We have our own clientele. So we couldn't take in more calls or appointments. of that. That's why we need a person to answer the phones and clean instruments and all that. So we were due and behind with rents after the COVID. So we're struggling with that. And more so if we lost a lot of business.
I understand. I totally
I don't know
do.
what to tell you. It's I don't know what to tell you. It's we're struggling and we don't know who's is legit to be hired or we're not. And it's like we're a target here. Like I don't even know who's legit or whatever to these kind of things happens. And the point is when David came in and called my fiance in the wax room and told her that, that, can you tell her her name?
Yeah, that she cannot touch the clients. And the license wasn't her. So.
Mm-hmm. Oh. Hello? Oh, okay.
Yeah, so I say I don't even know because I just hiring her like few days ago. So she says she come in and help. For the answer the phone, a receptionist clean up or something. And she says she can do nail too. I say, okay, I have to talk to my fiance first. And then but few days, ahead, she didn't do anything, touch any client. She just do cleaning.
She never did.
She had me answer the phone and do something like that in the shop.
Okay, I think what we should do right now, thank you for your input, but I think we need to hear from our compliance specialist. She has the information for the board members.
Okay.
Thank you. President Bremo, hold on one moment. So citation was issued on October 18th for the salon allowing an unlicensed individual to perform services and also for fraudulently using a copied or altered license or certificate. This was issued for the following reason. When the inspector went in to do the inspection, they found the person, the unlicensed person working, and asked her. She stated that she was licensee and she gave the licensee's name. The individual was then asked to see her ID. She could not produce or present an ID. She pointed out the license that she was. She's saying, I am this person. The inspector asked to see her ID. She could not provide an ID with that name on it. She then was asked what her birthday was, again, referencing the license number. She couldn't verify her birthday. She was then asked for her address. Her answer of the address did not match the records we had on file. She was then asked for the last 4 digits of her social, which she also could not answer. The unlicensed individual could not prove that she was actually the licensee that she said she was. She pointed to this license. This is the license that was posted at the station where this individual on the left was working. Forgive me, I don't think this looks like a cleaning uniform. This person was working at a station under this light. She referenced the station where this license was posted. She's saying, this is my station. We then asked her questions related to this license number. She couldn't answer any of them. That's why the citation was issued. So that's why the citation was issued. The board can decide what they wish based on their information, but the inspectors went in, they asked the questions, they got the wrong answers. This person indicated that this was the station she was working at, and to say one more time, and that this was her license, which clearly it was not.
Right. We understand that, but the thing is, the inspector talked to her.
We don't even know
what they're
talking about in the back.
And then when they finish, he then called us in and tell she's not supposed to touch clientele, and which is my, what did he exactly that David say to you, honey?
It says she cannot touch the clientele. That's
right, because she's unlicensed.
Right.
Yes.
Right.
Yeah.
So from there on, that's what we know. But when she was here, she never did touch a clientele.
I just have one question for you. When you hired her to be your receptionist because you needed a greeter, did you ever get a copy of her driver's license or any kind of state ID?
She said that Yeah, she said that we asked for it. Wendy asked for it. Then she said that, oh, I left it in my boyfriend car. So when he picks me up, I'll give it to you. That's what she says.
So
And
what
then
name did you write her check in?
Linda Nguyen, the one that the license.
The license.
So you never, when you hired her, you never had her to do an application and get
That
her.
was the second day. And the second day that's when she came in and she just said that, oh, here's the license I can do now. I show you. This is what the Wendy told me. Here's the nails license that you can, like this. So that's why we here write the check for her. And that.
Right, I can understand that, but I just didn't know if you could hire somebody and they working for you and you don't have them to do an application and get a copy of their ID.
That was the second or third day.
But she had already
because
started working though, right? She had already started working? Or no, she hadn't started working yet.
No, she hasn't
She
started
just was
working
there.
yet. Yes.
Okay, so let me just be clear. So when you first hired her, she never came to work. You just said she came in for an interview. You said, I like you, you start tomorrow. And then she showed up. She didn't have ID or application or nothing.
She worked, I believe that was a Sunday. When a Sunday she
The
came
Sunday,
in.
before
she
David came.
She came
David
in
came
at
in.
the Sunday that girl.
Mhm.
She came in around like 1 o'clock. And then we were really slammed. We were really busy. So then she picked up the phone and, she's helping us and all that and said, okay, so Wendy here, is she in need? So here that Wendy said, okay, you can start the job. So she came in like 1 something, we're closed at 5. She was here just for like 2-3 days. 2-3 hours that day. And then the next day, when Wendy asked, okay, I'm gonna need your ID and stuff like that to stuff. So she came in again.
And gave you the license.
Monday.
That's when she gave you the license the next day, right?
Yeah, yes.
The next 2 days or something, because
Next
I
week.
believe that she said Monday, tomorrow I cannot work for you. And then, or whatever. Was it a Monday or something?
No, it was the Wednesday that David came on Wednesday.
Yeah.
Yeah,
So
she-
the Monday she didn't
She
come
didn't
in.
she didn't work on Monday,
Then
but the Tuesday.
she came in.
Yeah.
She came in, she said, I
Just
come in late, and then she
and-
come in around the same time, noon, like 1 o'clock or something. And then she go, I'm gonna be off on Monday and Tuesday, just so you know. So the next time, I can only help you in the morning from maybe open 9:30
That's
to
mean,
like 3
she
o'clock.
said she just helped me like few hours. It's
Yeah.
not
Okay,
like
I
all
think
day.
everybody gets the gist of what happened. I just can't. I mean, we're not here to tell you how you hire your employees or what
Right.
documentation that you need from them. All we're here to do is just try to uphold the law as it is written. So at this particular time, I need a board member to, if you don't have any, if any board member has a comment, they're welcome to comment. If not, can we get a motion, please?
This is board members. The petition of license number N-1171 and uphold the fines that are before us.
It's Board Member Douglas. I second that motion.
All in favor?
Aye.
Any opposed? Motion carries. You can reach back out to the state board and they will give you the information that's needed to proceed forward. The board has made his recommendation and
I just
decision.
lost them. So what is the recommendation decision?
The
I
board
just
has,
lost. I
the
couldn't
board
hear
has,
you.
the board has denied your petition. So we're gonna uphold the board
Okay.
staff recommendation.
Okay. So when will
And
be
that's
we
that's
reaching
having
out again?
unlicensed activity in your establishment.
Okay. So am I waiting for whatever the paper that would be mailed to?
Miss
or-
Leah, can you explain what's gonna happen next?
That's right. In the next a few weeks, you'll get a letter in the mail that'll tell you of your next steps.
Okay, all right.
Okay, thank you.
All right, thank you.
Okay, bye-bye.
Bye-bye.
Okay, we're here at the agenda item number 8, items for subcommittee meetings. Number 1, the board to vote on allowing the Law Review Committee to move forward with the development of a tiered aesthetic license system in Nevada to be presented to the full board. Any other questions or comments from any of the board members? So the board will be moving forward, if approved today, with the development of a tiered aesthetic license. Do I have a motion?
This is Kai Stanton. I'd like to make a motion to approve.
Board Member Douglas. Oh, I'm sorry.
It's okay. To be approved. Thank you.
This is Board Member McCormick. I second that.
All in favor?
Aye.
Aye.
Any opposed? Motion carries. Number 2, the board is to vote on allowing the Hybrid Education Committee to move forward with the development of a permanent regulation change that would allow the board to vote on remote practical learning during a governor-declared state of emergency. Can I get a motion?
This is Board Member Kai Stanton. I would like to have an allowing for remote practical learning during the governor and post emergencies.
Can I get a second?
This is Board Member McCormick. I second that.
All in favor?
Aye.
Any opposed? Motion carries. Any opposed? Motion carries. Number 3, the board to discuss placing a limit on the number of theory hours that may be completed by students who are utilizing remote theory learning during COVID-19 pandemic for discussion and possible action. Any board members have any comments? I do have a comment. Board Member
I do.
Bramo. Okay, go right ahead, Stanton.
I'm
I
sorry.
apologize. No, go right ahead.
Just looking over some numbers, and I would like maybe someone can help me regarding the practical hours. I would like some clarity regarding the 50% because I am looking to maybe we need to have some adjustments to 25% versus 50, and then the 5 hours versus 10, just so that there's some balance. I'm not sure if anyone else took a look at that and how it affects the schools and the practicals accordingly.
So what my hold on, excuse me. I'm sorry, it's that time of day. My comment, this is a comment, because I think this is as we have it stated. I think Director Landry, when we initially during COVID knew that we needed to act and we needed to act accordingly. My personal opinion is that we did what we had to do, and I think we did a great job making sure that we accommodated the schools and as well as most of all the students. But now I think that it has come a time to where remote theory hours across the other states they're kind of winding down. And I know that once the governor lifts his directive and we're going into our permanent, in case there is, we need to have an amount of hours that's required for theory. Have the staff did the numbers on what that looked like?
The staff didn't do the numbers on what it would look like because how much you can do remote versus in class is really a function of the schools. And we don't know what needs to be taught in class versus out. We don't know what can be taught, as a remote student, and how much you can retain and bring that back to class. It really is going to depend on the schools and what you think as a school owner, what the other schools think, whether it's going to be 25, 30, 40, 50, whatever percent of their theory learning can be done. You've been pretty clear about no practical training right now.
Right.
So that's clear. This is just for theory and only theory. So whatever you come up with is what we'll implement. And if you want to change it later, we can change it later. It'll all be up to the discretion of the board. It's not right now in the laws or the regulations what the percentage is. So you can set it as a guideline for today and then come back and review it later at a later date to change it if you wanted to. But this is just to come up with whatever the board thinks the theory learning should be, and whatever percentage that can be taught remote, that's what you need to come up with. And that's if you want to come up with a decision today. If you don't want to decide today, it'll be pushed back to the April meeting.
I think that I would like to see, I would like for the staff to help assist us with that. Because 50% of theory hours, the students are going to max theory. I mean, without a question, they already have. And I think that this is just something that we need to put in place, and we need to put it in place, and it needs to be possibly voted on our April meeting. So if the board could get some information, because I know all states are not doing 50%, because this 50% is not just going to be during the pandemic. We're talking about theory hours as well, because some theory hours be done online, some theory hours be done in the school. Are all theory hours are going to be done online, to what percentage? And I think we need to narrow down, because we need to start looking at, while we're in law review committee, we need to start looking at the curriculum, because the curriculum is saying one thing and we've over exceeded it. So we're going to run into a wall. We're going to be trying to figure out where we go now, because every single curriculum is already stated in the law. And we're going to have to change it during law review committee, because the theory hours are not going to match.
Right.
They're going to be.
We can come up with what each state is doing, what percentage they're allowed to be remote versus in class. We can give you all those percentages. I don't think we can give a recommendation per se. We can give you what all the states are doing, and that way you can base it on that and say.
Well, I think that's given us enough.
Yeah.
I think that's given us some information, because not only while we're in law review, we possibly need to do some rearranging of those theory hours on what you have in law, because you have 250 hours or whatever we have there, and it's from all courses, but all that's going to change. Because if we're going to allow a student to do 500 hours, it's no longer going to be 250 hours of theory.
We'll come up with what all the states are allowing in class versus what they're allowing remote, and with that percent.
Okay, perfect.
We'll have that for the April meeting.
Yeah, can we defer this to the April?
Yep, we sure can.
Yeah. Can I get a motion to defer, please?
Brian Baltazar, motion to defer the item to. Is there a specific date that we have in mind, or can I just say defer to a future meeting?
April.
You could say to the next full board meeting, Member Baltazar. I think that would suffice.
Okay, defer until the next full board meeting.
Wonderful.
This is board member. I second that motion.
All in favor?
Aye.
Aye.
Any opposed? Motion carries. Item number 4, CCSD sector practical hours for seniors, discussing and possible action. Can we hear from you, Director Landry?
Yes, we've had a discussion with Senator Atkinson. He has presented that information to the governor's office. Governor's office got back and said it looks reasonable. It looks like it could be doable, but we've not received any updated information since then. Senator Atkinson has tried a couple of times contacting, but as you know, the COVID vaccination has come out. That I think has taken a lot of the governor's time, and he has not responded yet as to whether he's going to approve or not the CCSD practical hours. All we're asking for is during this time of the governor's emergency orders, that the CCSD students have a special exemption to do more of their practical hours through distance learning. That's all we're asking for, just those senior students doing practical hours. We've not heard yet with anything from the governor officially.
If possible, maybe this week we need to probably make some other phone calls.
Yep.
We'll get together.
We can put this off to the April meeting also, or to the next full board meeting if we have.
But if you hear something before Executive Director Landry, can we call emergency meeting?
Yes, we can call emergency meeting. That's what I said for the next full board meeting. That'll be any board meeting from now, between now and April 12th. So whatever comes up as an emergency, we can call an emergency board meeting, act on that one, the one item, and then go on from there.
Okay. Wonderful. Can I get a motion to, what's my motion, Justin?
To defer this matter to the next full board meeting, President Bramo.
Okay. Can I get a motion to defer this action to the next full board meeting?
This is Board Member McCormick. I'd like to make a motion to defer this to the next board meeting.
Can I get a second?
Board Member Harris, I second that motion.
All in favor?
Aye.
Any opposed? Motion carries. Agenda item number I. Board to provide clarity on whether hair braiding scope of practice, including shampooing, for discussion and possible action. So pursuant to NRS 644A.085, the definition of hair braiding includes cleansing the scalp. But for hair design and cosmetology, it further goes into what type of cleansing of the scalp. This is for a discussion with board members. Any board member want to start the discussion?
And Gwen, this is Leah Easter. Just as a quick note, I think this has been pulled for something for Kai as chair and law review to review. But in the meantime, the specialist team wanted some clarity because it's so vague what to do until law review can kind of parse out the language better. Because we'll have people come through as hair braiders asking if they can also shampoo, or do they need to take the shampoo tech course in addition to their hair braiding license? And so that's why this is on this agenda now, is we're trying to figure out what to do with the people between now and law review changes.
Okay, so you want me to comment?
Sure, everybody, yeah.
Okay.
Please.
I don't have a problem. My comment to this is that I'm having an issue with the hair braider shampooing. And because it appears to me where this is almost considered as a natural hair care license, which I've been an advocate for a long time. If you're gonna do natural hair care, you need to shampoo. But we have to remember how the braid license came about. So we have a braid license that came down through ancestors, or if you learn to braid and you can pass the exam, there's no school required. And now we want to be able to give the hair braiders an opportunity because it says cleansing the scalp. But how did cleansing the scalp on artificial hair get to be cleansing the scalp of shampooing artificial hair. I'm a little, I'm confused, and I've been braiding since I was 13, 14 years old. I'm just kind of trying to figure out where this came about.
I don't know. I'm looking to you for that. This has been here since.
It doesn't, I'm confused. I was lost when I was reading it, and I was looking at the difference between hair braiding, hair design, and cosmetology. I'm like, okay, these two licenses here required many of hours of schooling. This license here required none. But then this license that require none are going to be able to do the same type of shampooing and conditioning as those that required extensive training.
Mm-hmm.
And I thought, go right ahead, Leah.
I don't know if Adam's still on the call because I'm not as familiar with the testing section because it's the specialist team here. But I don't know if the hair braider written exam even asks shampoo related questions. I thought I heard from someone that it did, which would seem weird then that they'd ask you about it, but you couldn't do it with your license, even though I could understand. I guess I'm at your point too. It's like a little bit of a hodgepodge. Like what would cleansing the scalp mean then for a hair braider, or do we just remove that from the hair braider definition at some point in the future? I don't know.
Because a hair braider is getting the same kind of advantage of the ones that had to attend school to learn how to analyze the scalp before you shampoo it, the different type of shampoos and when you use them to rinse out chemicals. But if they're not doing chemicals, they're not doing relaxers, they're not doing any of those services, why would they need to shampoo?
Right. I don't know. That's a good
okay.
question. I don't know.
Okay.
Board member, this is board member Stanton, Madam President, if I may. I'm looking at some of this here, and I do believe that does need to be removed when you're saying cleansing the scalp, because that can be highly misleading. My concern is that there is no schooling regarding this, so there's no proper draping. There are some other things that are a high concern that comes with that as well, whereas others can utilize that for a different service, and that is not our goal here. There is a license that can be obtained. That is a shampoo license separate from the braiding license, which should be utilized for two licenses, especially when you're not going to school. The board has, board staff has made sure that there's enough information on the website through testing as well as sanitation breakdowns to make sure that they are aware of not just the laws, but proper procedures, having those two licenses, because hours of education is not required. I do think that it is beneficial for a braider to have both licenses, but it is solely up to them to utilize one or the other. I totally understand that. But that is, to me, highly concerning, because I do not want to a la carte cosmetology or hair design, especially after so many, that is a rigorous level of training that is to be had there. So we just really want to be very careful about also the wording. I think Leah is very on point when she says it's confusing. I mean, as I'm reading this, if I was standing in the court of law and it clearly says cleansing, and there's a definition of cleansing there in the scalp, but yet we don't allow that in the hair braiding licenses, we do need to take a look at that. So honestly, it's a little conflict. It's a conflict of interest, the bottom line. When I'm reading one thing and then I'm fined for it, we need to take a look at that. So I really would like for that to be addressed accordingly. Hair braiders should not be doing draping and doing other things with shampoos, things of that nature. There is a full breakdown even when you're utilizing shampoos, acid lines, things of that nature that are required in certain shampoos, conditioners, people that have alopecia, open sores, ringworms, things of that nature. You need to be able to identify a lot of those conditions as well. And that's not highlighted in any of the curriculum given, only through cosmetology or hair design. So that's just my point of view on it all. I really think that we need to horn in and clarify 110% the definition of hair braiding because it is misleading. I do think that I'm not sure how we can relate that, that you are not to shampoo, because that is in there on section 2, line A. And so with Leah asking for an interpretation when it's clearly in black and white can be highly confusing for the reader that does not communicate with the board, but yet has a law book. So.
Thank you, Board Member Stanton. Adam, I have a question. I thought we were gonna look at the shampoo technology license because I remember, I'm not sure if it was on the Assembly side or the Senate side, where they asked for this license for a particular reason. And I think the reason that they asked for it, and I kind of vaguely remember during that time when they asked us to create a license to see if a student wanted to be able to pay, I believe, full price, or if it's introducing them into the industry. So are we introducing them into the industry with this license, or are they just getting a license and they're just assisting in the salons? Because I'm not quite sure what's happening with the license.
Madam President, for the record, Adam Higginbotham, Deputy Executive Director. Madam President, are you referring to the hair braiding license or shampoo license?
The shampoo license, see, because if the hair braiders would have to get a license, they would have to get a shampoo license, but then there was a reason for the shampoo license. And it's just all kind of confusing, you know, how they, just the wording of it, how it's worded.
Okay. So the shampoo license, it originated out of the, I guess, the growing trend of occupational licensing reform and looking for ways of reducing certain barriers. There was a movement during the early stages that looked at creating specialty or niche licenses, such as what you're referring to, the shampoo license. Those licenses typically are not career-driven scopes of practice. You know, making a living just performing shampoo services would be quite difficult. It was intended that the shampoo service, from my recollection, that it was intended as an introductory part to the industry. So someone could look and experience the salon setting, perform a limited number of shampoo related skill sets or services. There's a health and safety focus that they would have through the course. And then they would get their license to go and work after after passing a state law test. For the terminology that's used for the hair braiding, you know, cleansing with the S, it's typically referred to an application that's going to be applied to the skin. In our particular law, it says cleansing of the scalp. However, when cleansing is usually referred to, it is for the skin, where cleaning would be more used for infection control matters or removing debris. We still don't know whether or not the application of using the shampoo at the cleansing section, which is why we're here, it could go either way, and it could be read in either way, because cleansing is removing debris. In some applications, cleaning requires the use of soap and water, which would be shampoo and water in this sense. But with cleansing, in the beauty service industry, from my understanding, it's typically referred to for the skin.
Can I share something with you, Adam? Can I share something with you? When African Americans,
I'm sorry, one moment.
When a person is getting their hair braided and their braids has been up for 6 weeks, they need their hair shampooed. Because that's how long those braids, some braids take 10, 12 hours. And when they take those braids down, some people keep those braids up 3, 4 months. So when they take them down, they need to be educated on, if we're going to allow them to shampoo, they need to be educated on hair analysis, scalp, all that stuff, so that they can fully cleanse their client's scalp. So just taking some dry shampoo, going down the parts is not gonna be enough.
So are you looking to expand upon the cleansing of the scalp to be clarified for it is shampooing?
It needs to be clarified so
Or
that
it
when
is
the law
an
review
act?
committee gets it, right. Don't you think it needs to be clarified?
After conducting the risk document, it seems like it is very appropriate to make sure that the scalp is cleansed before you set a new product on top of someone's scalp. So if someone is entering with a scalp that is not properly cleansed and they're setting a product that's going to be on top of that scalp for an extended period of time, it does seem that it would be a better way of mitigating the risk of any infection risk if the scalp would be cleansed. with
Because it
soap and
sounds like
water,
they're
which would
already
be the act of
shampooing. It sounds like a braider is already shampooing. We just need to get some clarity.
Madam President, this is Board Member Kai Standen, if I may. So I guess my concern is, number one, I would like the clarity of my whole focus altogether, because there is no education as far as in an educational institute required. I would really like to see a braider with a shampoo license as well. I would not like to see a shampoo license with the braiding license. That's just to help support even further education on how highlighting the questions that they have or the sanitations that are highlighted that are already there when you test for that particular licenses. That is different with the braiding license. So because that's already out there and that's our goal altogether, how do we will in that narrative? I think that's what Leah is saying. How do we will in the conversation and highlight the description of what's already been printed? Because it does say cleansing, and that is a very good grounds to argue that it's okay to shampoo. So how do you will that in? What does the conversation look like? Because it's a law and it's already published.
Okay, so but what I'm saying is that I understand what you're saying. I'm just trying to figure, I know how do we will it in, because I'm sure it's already out there. I think it should just be a conversation. Either we taking out cleansing of the scalp, or we're gonna combine two licenses. You can't get a braid license without a shampoo license, and they got to understand that that means not shampoo in color, not shampoo in chemicals. See, to me, we opening up a big can of worms, because we're giving them all the tools necessary to be able to shampoo color, know what type of shampoo. But I guess if they're gonna do it, then what can we do? It is what it is, right? Maybe we just have laws where you can't lock your door unless it's certain times, and when the inspector comes and shows his badge, you need to open up your door. We got to put something in place here, because the doors are being locked. They're coloring hair. They're doing all these things, so they have to shampoo. So maybe we should allow them to shampoo. I just think we should be able to see that either we're going to take it out in law review committee, or we're going to expand on it. So maybe we should just vote to move it to law review committee, and then you guys bring it back to the full board. And Adam, if you can help with some other information on what braiding license look like in other states, does it include shampooing?
Yeah, Gwen, so that is a good point. So for upcoming law review meeting, which I think is the 25th, we do have a 5-state breakdown of how the other states treat hair, whatever. So I don't know if you want to talk about it more there.
Okay, good. That's okay, good. You're on top of it.
I think for staff, though, it's like between then and now, how do you guys?
Okay, you on top of it. Because that's my thought. That's my thoughts.
Yeah.
But
okay.
You'll need to get a ruling on what are we going to interpret the law today. If it says cleansing the scalp, it doesn't have to be shampooing, because that's clean. Cleansing the scalp does not mean you're washing the hair. But we need to make sure, what does the board want to do? Do you want to allow shampooing now, or not allow shampooing, and you'll handle it later? But we need to know something today.
Okay. I recommend not. Okay. Can I get a motion for a recommendation?
This is Board Member Kai Stanton. I'd like to make a recommendation for not allowing braiders to shampoo with the, I'm not sure how to word this. With the, I don't know if we want to adopt something to help with that narrative or the conversation as far as the braiders. I'm probably going to need help with this because I know this is probably going to be some backlash if that's been the interpretation already. So I'm not sure how that can be adopted, but I would just like to make a motion to not allow braiders to utilize the shampooing technique to cleanse the skin. Was that good?
That's good. That'll do, because all we need to know is what your intention is. If your intention is not to allow shampooing, we will not allow shampooing. Cleansing the scalp is not the same thing as cleansing the hair. Two different things, two different applications. So we'll tell them, if this is what the board wants, we'll tell them you cannot wash the hair. You can only clean the scalp. That means picking things out or doing whatever, using an oil or an ointment on the scalp, but you cannot wash the hair. And we'll put that as our new definitive guidelines. When the board comes up with another recommendation, after the law subcommittee comes back and says, we want to do this, this, and this, we're going to have a shampoo, a braiding and shampooing, a just shampooing, whatever that's going to look like, then you'll need to tell us and we'll have to run forward with that. But for today, we just needed to know, do you want to allow hair braiders to shampoo with the current laws the way they're written? And you're saying no.
Right.
Right, can I get a second?
Brian Baltazar, second that motion.
All in favor?
Aye.
Aye.
Any opposed?
Aye.
Just to confirm, because President Bramo called for negatives, are you aye or a nay? Just for the record, sorry.
All my eyes.
They're all ayes?
No, I want to hear my eyes.
Okay.
Brian Baltazar, aye.
Kai Stanton, aye.
And my nays.
Board Member Harris, nay.
Okay, Board Member Harris is a nay. Motion carries. Okay, so now we're going to the Executive Director's review and report. Director Landry will deliver an operations report to the board. The board will review the Executive Landry's performance over the last year and evaluate him for his possible increase today.
Right. Now I'll go over the Executive Director's report first, and then I'll go with the raised recommendation. On the Executive Director's report, we outlined testing services, licensing information, inspection, compliance, operations, all the things that we do every report, and talked about the capacity that we did and the amount of tests and all that we've done. The board staff did a great job in doing all the things they're supposed to do, and even more so because we're doing this during COVID. And during COVID, we thought we might be impacted pretty severely, and we weren't. We've been able to keep up with the testing, we've been able to keep up with all the things we're supposed to, and still get things done. So anyone who has any questions about the Executive Director's report, any of the content that's on it, willing to answer those questions now and can answer them, or if there's no questions, I'll go on to my review. Does anyone have any questions of my Executive Director's report?
No.
I do not believe so.
Okay. I'll then move on to my review. And just to let you know, this review is not for a pay increase because my pay is deemed subject to the governor's pay. But this is just to say whether you think I'm doing a good job or not. Doing a standard job is the way the interpretation is for getting a one-step pay raise. And I wrote to you today to establish what I find my team has accomplished during the fiscal year 2020 life cycle. As you know, in order to receive the type of pay increase, I have to perform at a standard level of accomplishment. I'm writing to you today in order to receive one-step increase from 55.7 to 55.8, with a pay increase from $167,603 to $175,746. You may not remember, but my salary cannot be more than 95% of the governor's salary. So any pay would have to wait until the governor's pay is increased. Your granting a pay increase to me would be justified by your belief in what I have done and what I will accomplish during my tenure as the executive director. I'll go on in here and talk about testing, licensing, inspections, and financials, all the things we've done there. And as you can see, the performance of the board staff and my executive staff was in keeping with the parameters which were set out to achieve during the FY 2020, despite the downward trend in the overall economy caused by the COVID-19 pandemic. With the executive staff and leadership which I established, none of the objectives would have been accomplished. So with that, I'll just say whether you want to give an increase or not, that's up to you. You just need to vote on it. But I'm up for an increase from 55.7 pay to 55.8 pay. It will make no difference at all to my pay, because my pay is regulated by the governor's salary, and it'll be regulated by that until they change the law. But I'm held to 95% of the governor's pay. That's it.
President Brandon, I think you're on mute. Oh, sorry, I think you
I did. I was just letting them speak. So so do you want to do the whole report and then we vote, or do you want to just go ahead? We can vote now.
I did my executive director's report, asked for any questions. There were no questions. And then I went on to my own review. That's what I was reading off my letter that I put in the board packet, and just said, whether you give me an increase or not, it doesn't affect my pay, because my pay is controlled by the governor's pay, and it can be no more than 95% of the governor's pay. So that's where we stand today.
Okay, and so everything that was in the executive director's executive summary report, and that was some of the concerns, that's in there too, right? Was that in there, Director Landry?
Yes, it is.
There was no concerns, no questions?
Nope.
No questions? Okay, because I was getting ready to say this. You gonna speak now?
Board member.
We all hold our peace.
So ultimately, 2021, I think that 2020 was a learning curve for everyone. I think things have been addressed accordingly, but when we utilize terms as trying and things of that nature, I would like to see these things already in motion, which I do see a lot of that today, and some wonderful, successful things as far as communication between staff and board, I think has been a lot more successful. I would strongly like to see a lot more things implemented accordingly. I know there are some solutions, but once those solutions are in action, I think that would feel as a board member, and I know I'm only one, to see a lot of these things take place, such as the training for the board. We need to make sure that's implemented as soon as possible, ASAP at 110%. Communication with, I saw that was in there, Attorney General. I've noticed the trying, but I know that those solutions are going to be handled accordingly, and the elevation of proper communication will be there as well. That was a great conversation. And just overall, I think the bottom line is making sure, and I think we can all attest to this across the board, there's some major value that happens with this board. And the whole reason why the agency exists is because we are coming together as the public and saying a voice by saying, hey, this is what we need in order for us to be successful as working professionals in the one of the top growing agencies within the working people of Nevada. And that should be taking 110% seriously, all board members, as well as their value. And I thank you, Executive Director, for taking the time to actually go through each one and highlighting the serious concerns that affected us all, not just through COVID, but prior to. If there is a misunderstanding in any way, or we're not sure, or we need clarity, I do think it's okay to have a conversation with a board member and say, hey, we sent an email, or I just want to reach out and just have clarity on X, Y, and Z. I would like to see a lot of that go into place before we go ahead and give a raise. I think that because we also are a growing agency, I know that things tend to kind of slip through the cracks, but that's just a testament because we're growing and we're getting bigger. I think I heard we have over 35,000 applicants. So each department probably does need to have that extra support there accordingly without any salaries adjusted. The praising of staff and those that work for the agency, I'm excited to hear that they are acknowledged. And that was another big thing, and that we do appreciate them on a regular basis and letting them know all their hard work is approved. So I'm happy to see that the communication will be there and that it has been applied moving forward, as well as the pays. Once again, I appreciate every single person and the board, but we want to make sure that the board is ready to deliberate and communicate efficiently and accordingly. And that does fall on the shoulders of the executive director. So, you know, he has absolutely large, broad shoulders. He has to, you know, he has to take on a lot. It's a lot. Absolutely. And that's not easy shoes to fill. So I do understand that. But when we have certain things that are concerning regarding board members and the continual statement of, I didn't know, or I need help with this continually, that was a high concern, which I see there's a solution in place. I further see there's training in place. And I further see that there was an understanding to make sure that we can all move forward as one body and a strong agency. So thank you, Madam President. I turn it back to you.
Thank you, Board Member Stanton, for your comment. But I wanted to, and Executive Director Landry, I really do appreciate your concerns and your willingness to listen to your board members and continually to work hard, you know, with the staff. And I know what it's like when you have staff. You know, it's a constant work in progress, and we have a great staff. I do think at this time, though, board members, that Director Landry, we had given pretty much not a directive, but we had a wish for him. And I think he's pretty much fulfilled that. I think he's answered a lot of our questions and concerns. Today, I mean, putting it off today or putting it off for today or next board meeting, I just don't really see the difference, because the raise is not going to happen actually until the governor's raise happen. If we have an issue at that time, then we can say, okay, well, you know what, there's a next time and we need to do things differently. But I think he has more than willingly and diligently was there to listen to the concerns and want to be able to help support the difference. So I want to be able to call a motion today for us to vote for Executive Director Landry to get his raise when the governor gets his raise. Maybe it won't be to the end of the year or next year, but at least it will be the same raise that he's asking for today. So if any board member have another comment or conversation that they wanted to maybe talk about right now, this is the time to talk about it. If not, I would like for us to move forward so that we can work together and continue to be a strong and a solid board that stands for the Nevada State licensees as well as the businesses. Do I have any other board member want to comment? Okay, thank you, Balthazar.
So just a quick question, and this is just a matter of gaining clarification on the process. So the governor's, the increase in his salary, that is something that's voted by the legislature during this upcoming session. Is that correct?
That's correct.
I believe so.
Okay, that's all I really all I had a question about. Do we have any other board members, or are we?
So we ready? You guys ready? Any other questions or any other comments? I mean, this is the time, you know, we have so that we can move forward. We have a lot of work to do. 2021 is going to be a great year. We're going to be real busy, and a lot of things are happening, and our state is growing, our licensing is growing, our programs are growing. So I would like to call for a vote. I mean, a motion.
I'd like to make a motion to accept the executive director's report.
Board Member McCormick, I second that.
And sorry, Member McCormick and Member Stanton, by accepting his report, do you also accept the recommendation of the raise or just the report itself?
Board Member Stanton? She might have stepped away.
There we go. There we go.
Okay.
I make a recommendation to accept the executive director's report. And the raise would go into effect when you set legislation, according to Baltazar. Am I correct? I just want to be clear.
You're
Raise
clear.
would not go into effect until, okay.
Until the governor receives his raise.
Right, so Member Stanton statute out there, I believe, Andrew has it out there, but it's a statute that says that no executive director or head of an agency is able to receive a compensation more than 95% of what the governor makes.
It's Andrew Helms, Chief Financial Officer. That NRS, just for your reference, is NRS 281.123.
Right. So until legislation is introduced in session, which starts in what, February, unless legislation is introduced to raise the governor's salary, and if that passes, then whatever we decide here would go into effect.
That's
correct. Am I correct, though, Executive DeLandry?
Yes, that's correct. Nothing changes until the governor's salaries change. If the governor's salary does not change, doesn't matter what you want to pay me, doesn't matter what you want, it's going to be controlled by that 281.123 will control my salary.
So are you saying you wouldn't need a raise either way it goes then, right?
No, it just, all this is what do you think my performance is going along well? That's what this is for. It's not for a raise. It's, do you think my performance is going well with what your expectations are?
I guess a better way of framing it is it raise worthy, even though there may not be actually a raise due to no increase in governor's salary. So is it raise worthy? Am I kind of describing it?
Yeah, Balthazar, I think that's more of a better description of it. So if it's raise worthy and there is a raise by the governor, then it would increase Director Landry's salary. If there is no raise, unfortunately, then he would be capped at the 95%, which I believe he's currently making at this point. It'd be more symbolic, I guess, at this point, if there is no governor's raise.
So let me just explain it to the board and under my interpretation, how I'm interpreting this. If the governor doesn't receive his raise, Executive Director Landry doesn't receive his raise. If the governor receives his raise, Executive Director Landry receives his raise. That's what we're voting on today.
And it will only go up to where I'm within 95% of the governor's salary. So if the governor gets a 3% raise and it doesn't get me to the full 175, I don't get the full 175. I get 95% of the governor's salary, whatever that is.
Right, exactly.
Member Stanton, sorry, just for the record, is that what your motion is entailing?
Yeah, so my motion is to entail the approval of the executive director's his report, to approve the executive director's report and to include, how do I? Okay, let me say this. Everything is already in motion, right? So we're good as far as the summary and things are in motion. So upon success, and then there are some space there for improvement as needed. So I would like to say, I'd like to make a motion to approve the executive director's report on the approval of the raise before us, with the understanding that everything will be accomplished that is given within the report.
Can I get a second, please?
This is Board Member McCormick. I second that motion.
All in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Thank you. Thank you, staff,
Justin, I have a
for all
question.
the good work that you guys are doing. I have to be able to say it publicly that you guys are doing a really, really good job. You know, it's not just Director Landry, without his amazing staff to keep him lifted, and he can, you know, get the results and get some of these goals that the board has to be accomplished. I think that we're moving in a good direction this year so far.
Member McCormick, I believe you asked if you had a question. I'm sorry.
Yeah, I just wanted to know for the record if I could have requested that he buy everyone a box of Krispy Kreme upon.
Oh yeah, we can restate the motion.
Because they feel at minimum.
Like to amend that, that's right.
Okay, wonderful. Okay, let's go down now so we can get the grooving on. The agenda item number K, the monthly financial report from our Chief Financial Officer.
So included with this board packet is the annual audit. And that annual audit was submitted as required to the Governor's Finance Office and LCD. And the summary is included in your board packets as well. I'll briefly go over it. I'm not going to read it verbatim, because I'm sure you already did. But there was no evidence of fraud, misrepresentation, or misuse of public funds during the 2019 and 2020 fiscal audit. The financial highlights: during the fiscal year, the board's net position decreased by approximately $8,000, which isn't bad considering the pandemic. Total expenses increased by $37,000, primarily due to legal fees incurred during COVID-19. Revenue increased by $278,000 over the previous fiscal year. The current financial condition and staff capabilities are sufficient to meet anticipated operating expenses. The audit evidence that the auditors obtained was sufficient and appropriate to provide an accurate opinion. The financial statements are neutral, consistent, and clear. And the final comment is from the auditors that the current revenues and expenditures depict a stable financial environment for the future. If anybody has any questions about the July to October 2020 financial statements or the audit, please let me know at this time.
I just had one question, Andrew. How are we doing with during the last year of COVID? Still the year of COVID, but from the time that we opened back up at the board office there, as far as those outstanding fines, because I know we had a lot of outstanding fines. Have any of those practitioners started making or any type of payment arrangements or payments?
We're still experiencing a lull, because so what happened with the citations is that we gave a pretty decent not grace period, but we weren't sending the invoices out as often as we were pre-COVID, you know, because we don't hassle people for payment when times are tough. So we just picked that back up, but there really is a lull. There's a lull. People aren't making payments just because I think their finances are preoccupied right now.
Right.
So I can see that continue for, I don't even know, maybe the next 6 months, maybe the next calendar year. next 12 months, I expect that lull to continue. So the more citations we write, our accounts receivable, our AR report will probably continue to go up a little bit, and that's just something that we're gonna have to deal with. But you know, we can only send in invoices so many times, and it's up to the citation holders to actually pay the citations. That's all we can do.
Well, at least they're still working, most of them, you know, so
I hope so.
we have some hope, because they still get to work, right?
Oh yeah, I mean, unless they're unlicensed, in which case they shouldn't have been working to begin with.
But they have to, well, I'm saying, but they have to pay. Remember, we gave them a certain amount of time to pay. So like what's happening with those that if they didn't pay their fines, they could not renew their license at that time, remember?
Yeah, that's still true. That still should put a hold onto their license in our licensing database. That should create a flag of some sort so that they can't get their license.
And remember one thing, Gwen, all the citations that we issue, none of that funds our budget. That's going to the state. What funds our budget is the license fees, the testing fees, and all of that. That's what we collect from our clientele. The other fees, the citations and all
Oh,
that.
we don't get any of that money?
No, do not.
Oh, okay, well, I
I'm
shouldn't
sorry,
really
what?
worry about it. I was just looking at it and I shouldn't worry about that then. Well, maybe we should give them the license so they can go to work.
They should worry about it because we're going to continue working those numbers down, but it's not a number one priority because we don't get the revenue from that. That all goes to the state.
Okay. Okay.
The one thing though, President Bremo, just to piggyback off of that, one fee that is recoverable if the board does is attorney's fees for any disciplinary complaints.
Okay, right. We have to keep you guys paid, right?
But we can always try to collect it from the licensee based off of whatever disciplinary action.
No, we don't want to add it to their license. Then if they don't pay and it's time for renewal, they don't get their license.
Yeah, so.
Okay, I think that's all good. Any other questions for Andrew before we go to general public comment? Can I get a motion to accept the monthly financial reports from Andrew, please?
This is Board Member Kai Stanton. I would
Before we
like
do-
to make a motion. Oh,
If I may. Sorry to interrupt.
That's
Thank you,
okay.
Andrew, for that report. I just was curious, do you think we'll see a trend for more of our fees or more of whatever revenue that the board brings in to be acquired by the general fund? Since there is, obviously budgetary issues for the state, do we foresee that being a possibility?